No, I can't wait till that because,
The committee rules for Peggy.
oh, thank you very much. It takes too long. They come on at the last minute. I
Oh.
have to check my work. It's 2 minutes before we start. Yep, and, Amy today. Thank you. We have some question from Christian Senate Chair. She wants to run things her way over there. And I wanted to tell Tom, I said, obviously it's your committee. Hold on one second, let me get out of here. Good. But they want to hold all the nominees and stuff.
Hey, Richard, can you fix your name? It says you're Richard Jordan. Can you do that? We can do that for you, I think, if you can't.
I was just trying to find the buttons.
Right. And I don't know if you want to put where you're from in your name too, so people know exactly a judicial branch or I don't remember the name of the consulting firm, but
Okay.
that would be really helpful. And I will disappear so I don't take up screen space.
I wish I could. I think I must.
How do you change your name? Do you know, Richard?
So like what?
Mine was
If you put your hand over your picture, you'll get a thing that says mute or 3 dots.
Your cursor.
No,
Put
your cursor. Your
Oh.
cursor, Elaine.
okay.
Upper
Okay,
right
got it.
hand- Upper
Got
right
it.
corner, 3 dots. And
I got
that they rename.
Yep.
And then even went to the street of the homeless.
Thank you so much.
Sure, because you just said to me, Suzanne, that, she doesn't understand why some
Does one of you want to do the introductions? Elizabeth, do you want to do the initial introductions of everybody, or because you're the first one who contacted me, I'm picking on you.
That's fine. Happy to do that. Thank you, Peggy.
Is that okay, Senator Carney?
Yeah, that's great. I think, good morning, everyone. It's 10 o'clock and we have some committee members who are still logging on. So we'll get started in just a minute. But the normal process is for us to do a round of committee introductions initially, and then I can turn it over to you, Elizabeth, if that works. Thanks.
Thank you.
And Helene, I wanted to say hello.
Hi. You're my senator, right?
Yes, not exactly neighbor, but not too far away.
Nice to see you.
It's great to see you as well.
I'll be here, but I'm going to give up my valuable real estate.
Peggy, do you want to participate in the introductions, Peggy? Okay.
You can say hi.
Thank you. And I'll ask you and Soupy both to say.
Oh, no.
Thank you.
You had to go and say that, didn't you?
Lois, you are popping up as my name. Do you mind changing your name? And I also want to let you know that you're not on mute. And we're going to begin with committee introductions. I think now it looks like we have critical mass in attendance. All right, good morning, everyone. We are convening today as the Joint Standing Committee on the Judiciary. And our program today is that we're going to start with the presentation of the evaluation of the adult drug court. And then we'll move on to a bill hearing, and then we have judicial nominations starting at 12:30 this afternoon. We usually start our committee hearings with introductions. And today we'll start with our legislative analyst, Peggy, and our committee clerk, Susan Panett. Go ahead,
Thank
Peggy.
you. Thank you. I'm Peggy Reinsch. I'm the legislative analyst one of the legislative analysts for the committee, and I work in the Office of Policy and Legal Analysis.
Thanks, Soupy.
Hi, I'm Susan Panett, or Soupy, and I am the committee clerk for the Judiciary Committee.
Thank you. And then I'll go through committee members, starting with Representative Sheehan. Would you like to introduce yourself?
Thanks, Madam Chair, and good morning, everyone. My name is Erin Sheehan, and I represent House District 12. That's part of Biddeford.
Thank you. Representative Downs?
Good morning. Thank you, Chair. I'm Kathy Downs. I represent District 130, which is Bucksport and Arlington. Thank you.
Representative Libby?
Good morning. Thank you, Chair. I'm sorry, distracted for a moment. I'm Laurel Libby. I represent District 64, and I reside in Auburn and represent part of Auburn and all of Minot.
Thanks. Representative Poirier?
Thank you, Madam Chair. I'm Jennifer Poirier. I represent District 107, which is all of Skowhegan and a small part of Madison.
Thanks. Representative Evangelos?
Good morning, everyone. Jeffrey Evangelos, House District 91, and I represent the towns of Washington, Union, Friendship, and Walterboro. Thank you, Madam Chair.
Thanks. Representative Newell?
Yes, thank you, Madam Chair. I am Rena Newell, tribal representative for the Passamaquoddy tribe.
Thanks. And Representative Moriarty?
Thank you, Madam Chair. Good morning, all. I'm Steve Moriarty. I reside in Cumberland and represent Cumberland and part of Gray in the 45th District.
Thank you. Representative Reckitt?
Morning. I'm Lois Reckitt, and I am the representative for District 31, which is the ocean end of South Portland.
Thank you. Representative Babbage?
Yes, good morning. My name is Chris Babbage. I represent House District 8, which is most of the town of Kennebunk.
Thank you. Representative Harnett?
Thank you, Madam Chair. My name is Tom Harnett. I serve as the House Chair of Judiciary, and I represent House District 83, which is the town of Farmingdale and the city of Gardner. And thank you all for being here today.
And we have a couple of committee members who are not able to join us at the beginning of today because of conflicting schedules with other legislative work. And so you may see others pop in and out of the meeting and introduce themselves throughout the day. I'm Senator Ann Carney. I represent Senate District 29, which is all of South Portland, all of Cape Elizabeth, which is my hometown, and a part of Scarborough. And with that, I will turn the introductions over to Elizabeth Simoni. Go ahead, Elizabeth.
Good morning. Thank you, Madam Chair. Good morning, Chair Harnett and members of the Judiciary Committee. My name is Elizabeth Simoni. I am the Executive Director at Maine Pretrial Services. We are a nonprofit, and we are privileged to provide case management to all of the treatment courts in Maine. We also do pretrial services, as our name suggests. I am joined today for a presentation with you by Ann Jordan, who is the Criminal Process Manager of the Administrative Office of the Courts, by Richard Gordon, who is the Grants Manager and oversees all of the drug courts for the judicial branch at the Administrative Office of the Courts. And finally, and not at all least, by Helene Hornby, who is an independent consultant. She served as an evaluator and lead principal on a project looking at the drug courts. She is representing Public Consulting Group today. Thank you.
Thank you all for being here today. I want to extend you a warm welcome. And you may proceed with your presentation if you'd like.
Thank you. Thank you, Elizabeth. We're really delighted. Thank you, Senator Carney, for inviting us and the committee. We're delighted to be able to present our results today. This work is the result of 1 year of effort that involved all the treatment courts in Maine. And I'm going to share my screen because as a consultant, it's mandatory to have a PowerPoint. Just a second. Going into screen sharing mode. Hopefully. Let's see.
Let us know if you need some kind of special permission to do that. I'm not sure if that's the case or not.
Okay, let's see. Screen share. Almost there. Okay, can you see it now?
Yes,
Yeah.
thank you.
Okay, good.
And it's not in presentation mode.
Okay.
It's perfectly fine as it is. That's
You can
really
see
up to you.
the sidebar. Let's see. So you're seeing these things on the side?
Yes, but again, if that's fine with you, that's okay with us as well.
Okay. Well, I'll get started. Maybe I'll fool with it a little bit. So as I said, this is a year-long evaluation, and today we're going to talk about who the treatment courts in Maine are, just as a review in case you don't all know, what our conclusions and recommendations are, and hopefully we have time for discussion, or we will definitely make time for discussion. Ann Jordan is going to start and tell us a little about little background about the treatment courts.
Good morning, everyone.
Morning.
This report deals with our adult treatment courts. We did not do or did not include the family recovery courts for a wide variety of reasons. The purpose of our adult drug treatment courts is to stop criminal activity that was related to the abuse of alcohol or drugs, to hold adult defendants accountable, and to increase the likelihood of successful rehabilitation, including elimination of recidivism through intensive judicial supervision, intensive case management, and specialized treatment. All participants receive judicial oversight, treatment, testing, and close monitoring instead of incarceration. Our courts are located in Washington County, which alternates between Calais and Machias, in Penobscot County, in Bangor, in Auburn, in Alfred for York County, in Ellsworth for Hancock County, and in Cumberland County, where we have both an adult drug treatment court as well as a veterans treatment track. In Kennebec County, we have the single state co-occurring disorders court and veterans treatment court. We do in Kennebec County accept persons with serious co-occurring disorders and veterans background from across the state if they can meet certain eligibility and appearance requirements. Our features of our court is we do multiple assessments for substance use and mental health disorders. We have a 5-phase process that includes intensive treatment, counseling, and moral reclination therapy, as well as case management services for Maine pretrial, which addresses housing, healthcare, and employment. Court appearances every couple of weeks, in some courts once a week, where the judge addresses each individual separately. We do random alcohol and drug testing, and we have a system of graduated rewards and sanctions, the purpose being to change behaviors in criminal thinking.
Thank you. Thank you, Ann. One of the questions that we often get asked is, do the treatment courts really serve people who have high criminal risk and high need for treatment? And the answer is yes. We were able to verify that in the evaluation. The national research shows that these courts are more successful with the most serious cases of person with addictions and felony counts. What this slide shows, the little box that's in red, is that where it says treatment court participants charge class A, B, and C, 70% of the people who have been through the courts in the last several years were in right now for either an A, B, or C felony charge. And some of the others who might have been a lower charge might have had a criminal history that also made them a high risk from the criminal perspective. So they truly serve a high risk high-need population. We looked at the age and gender of the people in the courts. We found that on gender, males are equally represented, not that it's the same number of males, but they're equally represented to their proportion in the population that people come from for these courts, people with these offenses, qualifying offenses and qualifying needs. So females are represented equally. They equal about a third of the population, and or maybe a little less. And the age range is 30 to 39. Is most people are in the 30 to 39-year-old age range. You see the white bar, 50% of the males and slightly less of the females are in that age range. Most of them, by being not real young and not real old, but most of them have many years of addiction history. The people I met and people that my team met were generally very long-standing alcohol and drug addiction, leading them to want to do something different by this age group. Megan Maloney talked to you a few weeks ago, and she used some of my slides, and she did give us credit. I don't know how many of you remember this, so there might be a few things that she gave that I'm going to go over to refresh everyone, if that's okay, Senator Carney. But I'm going to go beyond.
Thank you.
The evaluation concluded, our overall major conclusion was that treatment courts enhance public safety and improve lives at no additional cost to taxpayers. We went in here not having any idea what the result would be, and we looked at 4 years of data from 2015 to 2019, and sometimes we were able to bring it up to 2020 on recidivism, and that was the clear conclusion. And the reason we make that positive conclusion is there was reduced recidivism. We used a comparison group to compare treatment court and others. There were fewer mortalities. We were actually able to get data from the chief medical examiner on everyone who had gone through the courts, as well as the comparison group. We talked to 45 people who were either in the courts now, actual participants in the courts, or past participants. And we also conducted a cost benefit analysis. Each one of those measures led us to the conclusion that the court is effective. One of the primary problems we have is that we may not be reaching enough people. And the pandemic has kind of exacerbated that, making some of our numbers go down this year. So on the reduced recidivism, first I want to talk about graduation rates because that relates to recidivism. Treatment courts have about a 50%, 52% graduation rate. So only slightly more than half the people who start actually finish. That's because, as I said before, we're dealing with a really intransigent group as far as addiction is concerned. This shows the graduation rate by the court. We're giving each court its own information many times throughout the study so they can be thinking about what they're doing and how they're doing it. You see on the right-hand side that the Kennebec, the Veterans Court, actually had the highest graduation rate in the state. The treatment courts are expanding services specifically to veterans and giving them some of their own specialized dockets. It takes 17.8 months on average to complete the program if they graduate. So it's about a year and a half to go through the program if they graduate. But for those that drop out, which is almost half, they're still in there on an average of 12 months. And you'll see in a few minutes that even those 12 months have a positive impact on those who do not graduate. So post-program arrest and conviction recidivism is far lower for all treatment court participants. And in our particular study, we looked at recidivism after they exited the program. both for the treatment court and for the comparison group. On the comparison group, the Maine Pretrial Services has a management information system that, as you may know, they serve case management for the drug courts, but they also do pretrial services statewide on the pretrial, not for treatment court, but pretrial in general. So they maintain a management information system of everyone in pretrial services. And as you know, not all counties have a drug court, but we were able to look at the offenses of people in the MIS system of Maine pretrial statewide to choose our comparison group. We looked for people who had common offenses. They all have serious drug court offenses, including the 70% of felonies that I just showed you, and drew our comparison group. So when we do these recidivism analyses, we compare those of the treatment court to those who had traditional adjudications statewide. So you can see in the two bars, let's say it's 6 months, this is arrest recidivism. We looked at both arrests and convictions, and it's all after 6 months, 12 months, 18 months after they left the program. And you can see that the arrest rates are far lower for the treatment group, and they are statistically significant at every juncture. We apply these tests to see whether this difference could be by chance alone. Small differences or small numbers can produce chance, but these were significant. And we also looked at other studies throughout the country, and Maine does as well, if not better than as shown in the other studies. This is a similar analysis, but it's convictions. And we use the Maine Justice Information System, MJIS, in the judicial branch to find our arrest and conviction numbers. So after we choose our groups to study, well, for the treatment court is everyone who entered between 2015 and 2019. We match their records to the MJIS, and then we find new arrests and new convictions. In this case, since it's recidivism, this is after their completion dates. And you can see at 18 months, we had a 15% recidivism, a new conviction of someone in the treatment courts after 18 months, compared to 40% of people who had served some kind of a sentence in their original conviction, not in the treatment court. So it's a huge difference. Again, it's statistically significant, and it's equal or better to others elsewhere. Sometimes people get discouraged because of that 50%, 52% graduation rate. These people, I don't know if any of you have ever witnessed any of the treatment courts, whether you've ever gone to any of the sessions, but these case managers and the judges work really hard to engage people and give them all the help that they possibly can. But as you can imagine, it's a difficult, very difficult population because of the longstanding addictions. So many of them, almost half, don't complete the program. But what this slide does, it looks at conviction recidivism of the treatment group, dividing those who graduated and those who didn't complete it, that other 48% that did not complete it. And what you see here is a very similar percent of recidivism relative to the whole population. In other words, even those who didn't graduate were in it for an average of over 12 months. They didn't complete it, but they still do a lot better in the real world after they get out than people who didn't do it at all. And that's what this slide shows. The black bars are the comparison group, those who didn't have treatment court. The green and the blue are those who had it, those including separating those who graduated and those who expelled or withdrew. So I hope that the judges and the treatment team are encouraged that their efforts are making a difference, even though people don't actually complete the program. This graph shows people who didn't go to treatment court at all and how much they recidivate, because you have to compare treatment court to what the normal kind of adjudications. And if you look at convictions by 24 months, the blue bar, 77%. What that says is anyone who had been in prison, blue is prison, anyone who had been in prison in their original adjudication by 24 months, 77% were back in prison. That's the worst. If you were in prison to start with, generally you have, you're more likely to recidivate again. If you were on jail or probation, you have a little less likelihood. But I think you're probably aware of this recidivism rate of people in jail or prison or even on probation. It's very high. So these kinds of programs are important interventions. The second way we know that it's effective is fewer mortalities. And we were able to get data on overdose deaths from both the treatment and the comparison groups. These are rates per 100 over 4 years. So the comparison group had 2.4% of people died over 4 years, whereas 1.9% died in the treatment group over 4 years from an overdose, certainly higher than the population at large. The treatment group is not statistically significant in this case, lower, but it is lower. The third way that we know it's effective is the participant testimony, all the people we talked to. And I just wanted to highlight 2 or 3 statements that were given to us that are very typical of the kinds of things we heard throughout the study. The first one particularly, I gave up on myself, but they, the treatment team, did not give up on me. The people in these programs do often have slip-ups as far as continuing to use. They have randomized tests, usually a couple a week, sometimes more, for drug and alcohol tests, and they do slip up. And sometimes they get down on themselves. But the treatment team, including the therapists and the case managers and the judge, really try to stick with them if they're honest. Sometimes when they slip up, they get additional treatment, but as long as they're working, they don't give up on the person, and people recognize that. The judge gets to know you. He or she is stern, but understanding, and reinforces how proud he is. He sees your progress and is respectful. The reason why I include this is because the role of the judge is critical to these programs. The people on the team meet with the judge every other week, generally, sometimes once a month. In counties like Washington, where the judge has to go back and forth, I believe that between Machias and Calais. But the judge meets with the person for 3-5 minutes, each person, and listens to how they progressed since last time. And as this person said, it's true. They're stern but understanding, and reinforce how proud they are, and they see your progress. And they do everything they can to help you. This is about the case managers, the whole treatment team, but the case managers particularly work with these people to find housing, employment, further education if needed, support in the community, recovery support. So it's really, as someone said to me, a wraparound program. So all that is really critical to the effectiveness. As legislators, I know you're concerned about cost effectiveness, and we were able to demonstrate that these programs are cost effective. And let me break this down for you a little bit. What we did is that we looked at it. Well, within the treatment court, you have case management costs, which are contracted, in this case, mainly to main pretrial services. You have treatment costs, which are contracted to treatment providers, like even Aristic Mental Health, even though it's called Aristic, it's one of the providers. And then there's judicial time, which is extra than normal judicial time because judges spend an average of about 1 day a week on treatment court when you add the time they meet with the people and the team meetings and so forth. So we obtained the contracts from all the case management, for the case management agency and all the treatment agencies. And we divided it by the number of people they serve. And we looked at the judicial time, took 20% of their salaries. And we came out with a treatment cost of $10,964. This is not an annual cost. This is a cost for the entire, one person's entire stay. So as I mentioned, people are usually in it for about 1.5 years. But they're also in it for, some are in it for a year. The average is actually 15.5 months. So this represents the total cost. Then because some people, 48% do drop out, some of them wind up in jail, prison, or probation. If they can't complete the program, they have to go back to the original sentence. Most of them come in on a guilty plea, not all of them. So we took into account what their costs are on average if they dropped out and had to do jail, prison, or probation. That was $27,000. So the total is $38,000. If we can get more people to graduate, then that will really reduce that component and get closer to the 10,000. Then we took the comparison group who don't have case management or treatment costs, and we looked at, for anyone who had any jail, prison, or probation time at all, we calculated how much that costs, and I'll just show you a little breakdown of that. We were able to get the daily rates. See, the prison costs an average of $123 a day. Probation costs $4.86 a day, and jails cost $141 a day. We got the prison and probation costs from the Department of Corrections, and we got the jail costs from the Sheriff's Association. In doing this research, I was surprised to see how much data the Sheriff's Association has, but they actually have costs of every jail and what their daily costs are. Then we were able to, on the group, look at treatment comparison. We were able to pull from the data the actual number of days on average that treatment people spend in prison, probation, and jail, multiply that by the daily rates, and that's how we came out with the cost. Some of it may be a little bit low because they were still in jail and we were still in prison. Some people are still in prison. We had to cut off on a certain date. So it still shows the relative though, the relative difference between the two. And one more about the cost benefit. Because the treatment court people recidivate at a far lower rate, we calculated the cost at the different junctures at exit, 6 months, 12 months, and 18 months. So at exit, the treatment costs are 12% lower. That was the difference between, between the numbers I showed you earlier, the 38 and the 43 or so. So that was a 12% difference, or here, 38 and 43, or $5,268. But as time goes on and there's less recidivism of that group, whereas the other group still incurs more prison and jail time, the actual savings goes up. So by 18 months, it's a 28% reduction. I'm going to go on to the recommendations in a few minutes, but I'll stop there for a moment to see whether people have any questions or comments about what I've said so far. Okay, well, you can pop in if you think. Oh, I'm sorry, Anne, you have your hand raised.
Yeah, I thank you. This information is really impressive, and I'm not that familiar with the adult drug courts. Could you please And I don't know whether you or one of the other presenters is better to answer the question, but can you give us just a little more information about the training that the judges undergo in order to be qualified to participate in this program?
That's a really good question. I'd say Richard is our expert on training, but it creates, I'll just say that they have to adopt a totally different mindset. Actually, so do the prosecutors, to be in this program. And plus they've got to go back and forth because they're only doing it one day a week and they have their old mindset the other time. But Richard, can you address the training?
Yes, thank you, Chairman Carney. Over the last several years, we've been able to have all of the treatment court judges attend the New England Association of Recovery Court Professionals Annual Training Conference, which is held each November. This past year, it was held virtually, and due to scheduling conflicts, we only had one judge attend that conference. But usually we have, over the last 3 years, we've had all of them go to that. We also have trainings scheduled later this year from Justice for Vets, which is the Veterans Treatment Court arm of the National Association of Drug Court Professionals, coming in to do trainings for York, Androscoggin, and Cumberland in April, and Penobscot, Hancock, and Washington in June. We have a grant that ends this year that will allow us to send all of the judges to the National Association of Drug Court Professionals Conference in August, should it take place, and should the judges be able to leave to go to the training if the courts reopen and we start addressing the backlog of cases. There's also some online training that can be done on the National Drug Court Institute website and the Justice for Vets website.
Thank you. I'm not sure whether I can see all the hands raised. Are there any other hands at this time?
I can keep track of the hands.
Okay, are there any others right now, or should I go on?
No, you've got one more question here. Representative Arnett, go ahead.
Thank you very much, Madam Chair, and thank you for this presentation. My question is, dealing with slides 23, 24, and 25, where you compare the costs.
Yep.
Do you take into account also the value to people's lives that are added by going through the treatment court? And what I mean by that is that people are not incarcerated. They are able to keep their job, perhaps. They are able to keep a family unit together. It's not just about dollars that go out to me.
Right. Yeah.
Is there a way to value?
Sorry, go on.
Is there a way to value that? I mean, is that something that you look at, the value that's added to society?
Right. I did not, I read the literature on, there's a lot of literature on how to do cost analyses, and some do try to do that. Some look at taxes that are paid through employment, and some look at if you have to pay enforcement, support enforcement. I forget the exact term right now. If you have a child, they have to pay for their care to your spouse and so forth. We didn't do that. It was really beyond what we could do in this particular program, but it is possible to go beyond. It gets a little bit subjective, and sometimes you have to go to the people themselves. There was a national study done, and they did a survey of all the treatment court graduates. They had to find them and survey them and ask about their current things like employment status and salary. So people do make attempts to do that, yes, but we didn't.
Thank you.
I want to recognize Ann Jordan, who has her hand raised, and also to say hello, Ann. It's nice to see you as well.
Nice to see you again, too. Representative Harnett, in response to that question, I can think of two instances. While we haven't qualified it monetarily, one of the sessions in Washington County, one of our clients had been in the court about 9 months, was doing well. The judge gave him a pass to go down to Bangor to go Christmas shopping. And when the judge was talking to him about it, he asked him how did you feel about being able to do that? And he said, well, you know what? For the first time in my young child's life, his son was 5 or 6, I was able to provide him a Christmas from something other than the dollar store. And he was very, very proud of the fact that he was able to work, support his young son, and provide his young son a positive Christmas time memory that so many of us just take for granted. And in another instance, I was talking to a former drug court judge, Jeff Moskowitz, who indicated he was stopped by an individual in the grocery store one day. And this individual had not completed the court, but it had been a couple of years. And he approached Judge Moskowitz and said, I just want to let you know, even though I didn't graduate, I thought about it while I was in prison. I took those thoughts and the trainings that you folks tried to give to me, and I have been clean and sober now for over 2 years, and I'm supporting my family. So while we can't measure that by a dollar amount, the differences clearly are there. And those are just 2 examples.
Thank you very much for that, Anne. And I realize it's hard to put a dollar value on. I just don't want to lose sight of those benefits as well.
Thank you. Okay, so while there are many excellent things about the courts, we did find things that we felt needed improvement and made recommendations. By the way, I didn't do all this myself. I had 4 or 5 people on the team that I worked with, including a PhD statistician. The recommendations fall into 3 broad categories, what we call structural and managerial, which are statewide changes, court processes, a treatment team, which are things that we're going to ask over the course of the next year, that I'm still able to work with the group this year, things that we're going to ask each court to look at themselves, and community relations, because we think that these courts need much more knowledge and support in the community. On the structural ones, one of the ones that I think will be of most interest to this committee is the first one. Add 2 courts to cover all 8 judicial regions. So there are 2 regions that currently are not served by treatment courts. Region 6, which includes Knox, Lincoln, Saginaw, and Waldo, and Region 8, which includes Aroostook County. We're hoping through some process that the treatment courts can be added to those 2 regions. This is supported by the opioid plan, the strategic plan that Gordon Smith may have already presented to you on. The courts badly need a new management information system. What they had been using, DTIX, was decommissioned 19 months ago. They moved to the Enterprise Information System, which is held by the Office of Behavioral Health. That has not been effective. Everyone recognizes the need for a new system. One's been identified, and we're just waiting now for approval. These systems are really important because they keep track of everything about the person in the court. The kind of evaluation we did, largely, or one element of it, came out of the DTIX, the information system, the rewards, the sanctions, the start dates, the end dates, the drug analyses, and all that data has to come out of a management information system. The third one is an interesting one, I think. Enhance AAG or ADA time on the treatment team. And what we really mean is the cost of that. The teams are multidisciplinary teams consisting of defense attorney, prosecutor, case manager, probation, law enforcement, the judge. But other than the case management and the treatment provider are actually being paid through these contracts with the Office of Behavioral Health to be on the team, but the ADA has to borrow time from his or her normal job. And if anyone complains about expanding these courts, expanding the number of people served even within existing courts, it's the district attorney or the AAG who is working for the district attorney in this case on the team. they're beg borrowing and stealing their time from their normal job. And as you know, they're pretty overloaded already. So somehow we need to find a way to compensate their time. One county, Penobscot, has the DA has set aside, she's rearranged the time of the people who work for her so that one person can be dedicated to doing this part-time. And that's worked really well. She's not diverted. She just served on the treatment court, but it's part-time, but that's fine. But others have to work harder to take up the slack. The last one, institute common online training for the whole team. Someone asked about training. Again, everyone on the team has to think in a common way, and there's no real requirement that they be trained. And as Richard, they do by and by get training, but Richard mentioned that there are national groups that put training on, basic training on treatment court online, and we want all treatment team members to participate in that online training within probably the first 90 days of appointment to the team. So those are sort of some structural statewide kind of recommendations.
Before you move on to the next slide, I just wanted to recognize Representative Babbage, who I believe has a question. And then also Senator Keim has joined us, and I would like to give her a chance to introduce herself. Go ahead, Representative Babbage.
Thank you very much, Madam Chair. And I want to thank Ms. Hornby for this data collection and analysis. That's great. Great information for us. And I want to also give a shout out to Ann Jordan. Good to see you again. My questions were regarding the relevance of a couple of things, or irrelevance, regarding success with the graduation rates. The first one was geography. I know that when we started out these programs, someone had to live, reasonably close in order to successfully complete the program. We don't have congregate housing. People are living at home, to my knowledge. So I wondered if we had reduced geography as a factor in this being successful. That's the first one.
Anyone else can, Elizabeth might want to talk about this. I say overall, not real well, because they really do have to get to the court sessions and to the treatment, and transportation and distance are often mentioned as factors and impediments in some cases.
Well, I can comment some on that, Representative Babbage. During one of the good things, if there can be anything good that comes out of a pandemic, is the use of the virtual appearances. And we have been able to, we have several courts who have people who are living outside of their county with family, but are still able to make all of their treatment sessions, all of the court sessions. And so right now, yes, we've been able to do that. That's one of the things that we hope to work with the courts to encourage them to keep doing, because the use of these virtual services has really reduced the burden of transportation, of childcare. If someone is slightly ill and we don't want them to come to a court appearance or to a treatment session, they can still participate at home and keep everyone safe. So there are two courts that are of statewide jurisdiction, the co-occurring court and the Veterans Treatment Court, both in Kennebec County. And it is a requirement that you either relocate to Kennebec County to participate in those, or to the court's satisfaction, prove that you have the ability to make all of the requirements. I know there have been successful people that have graduated from the Veterans Treatment Court out of York County who have been able to make all of their appointments in Kennebec. So it has happened. It has increased during the pandemic because of the virtual services. Hopefully it will stay that way.
So I knew it had been a challenge, particularly with the Veterans Court early on, but you think over time, we have 6 courts now. I actually wasn't aware of that. So that has at least been reduced as a factor of shortchanging people the opportunity to complete these programs. The second thing I wanted to know is more of a motivational thing. I wondered if there was a statistical difference in the people able to complete the program of people who had dependents or not, people who had children. Do you know about that?
We did not look at that factor. That's a good question. Actually, I'd have to ask Elizabeth whether that's in DTICS, whether they have children, that information.
We have all of that data. So
Okay.
that would be something that we could look into.
Okay.
May I speak briefly to your question about residents and geography, Representative?
Yes.
Yeah, go
Thank you.
ahead.
Just from my limited perspective, one of the difficulties when Ms. Hornby talks about assistant DA time or assistant AG time, the plea negotiations up front. If someone's living out of county, they're dealing then with two prosecutors, the prosecutor in the drug court county and the prosecutor where the case lies. And those things take up a lot of time. Those things can also create barriers almost as much as transportation, housing, moving, all of those things. So I think that we've done a really good job with this patchwork quilt of courts. They've been around for, I think, 21 years now. But there are a lot of people that take a pass, if you will, because it's either too hard to figure out what the right plea would look like, or if they're going to be able to move. So I hope, as Mr. Gordon said, that we take lessons learned from COVID and think about how we can use technology to benefit people, because we're holding steady, surprisingly. Thank you.
Thank you very much
And
for
I
all
see
of that. Appreciate it.
Ann Jordan has her hand raised. Go ahead, Ann.
In response to Representative Babbage's question, the other thing we would like to point out is that the Maine Judicial Branch has been participating in the New England Regional Judicial Opioid Initiative, which is a collaborative of all the New England states. And we have a couple subcommittees that we're working on issues. We're working on regional broadband issues, both for telehealth and court communications and court processes, as well as regional transportation matters. Prior to COVID, we had representatives from the U.S. Department of Agriculture that actually had transportation grants available to purchase vans pre-COVID, again, to be able to pick up and to pay for staffing and people to, drive around the county, so to speak, and pick up our clients to bring them to court and to bring them to treatment. Obviously, that came to a halt with COVID. But we are looking and talking to other New England regional states on how they are dealing with the issues of transportation, housing, and everything else. The other issue is, as far as regional issues and the struggles that people have, one of our drug court graduates, Doug Dunbar, now works for Eastern Maine Development Corporation, and he was able to secure a multi-million-dollar grant to assist in things like education, housing, transportation, treatment, well, not treatment, because that's a different funding source, but to provide services to them and to people who are suffering from a substance use disorder, so that we can do sort of the wraparound that's there. So that information we wanted to share with you folks as far as the geography is concerned. Our Washington County Court, they alternate between Machias and Calais, just because of the sheer distances involved in trying to get people help and get them into the courts.
Thank you for that additional information. I know we've only got about 10 minutes left. Unfortunately, I think we could spend a whole day on these issues because you're doing amazing work. Senator Keim, did you want to take a moment to introduce yourself, and then we'll turn the virtual floor back over to Ms. Hornby?
Sure, thank you, Madam Chair. Good morning, everyone. My name is Lisa Keim, and I proudly represent Senate District 18, which is northern Oxford County and 2 communities in Androscoggin.
Thanks. Ms. Hornby?
Sure. I just went ahead to this particular slide because Elizabeth said some people don't choose to participate because of possibly logistical issues, or they really don't want to give up their substances. We have this little graph, see this blue that says client refusal, 46%. We graphed the reasons why people who may have been approved don't actually participate. And client refusal is the largest. The person doesn't want to do, even though they could go in. they don't want to do it. So one of our improvements that we're going to ask the courts to work on is to try to increase the acceptance rate, see why people are not participating. Couple of things. I know I don't have much time. I want to talk about racial disparities and what we're doing to address that. And on this particular slide, I just want to talk about eliminating upfront time and suitability discussions. This is one of the things I said that some of our recommendations we're going to ask the individual courts to work on. And these are those, because the problem may exist in some courts and not in others. Upfront time means that the requirement that someone goes to jail before they start treatment court. And this is a prosecutorial thing. Most prosecutors don't do it, but some in the state still, as part of their negotiations, say, well, they can go to treatment court if they spend 90 days in jail or whatever it is. They give it a sentence that they have to serve beyond that particular day, because some of them are in jail before they even start. That is not an approved practice by the Bureau of Justice Assistance. It is not a good evidence-based practice. And we think that that whole concept should be eliminated, as well as suitability discussions, which is that once people are deemed qualified for treatment court, the team often discusses whether they think they're a good candidate, and that could be for reasons other than what actually qualifies them. And sometimes that gets into a subjective kind of view of, I know that family, or they've failed in the past, or that type of thing. That's kind of in the field that's called a suitability discussion. Are they suitable to participate? And we would like to see those really minimized. I'd like to talk a little bit about racial disparities, because I know that's of interest to everyone at this point. And we're undertaking a process to address that in the courts. And as I said, that's one of the ones that's different from court to court. I just want to give you a little context of what's being done. In Maine, as you know, we have a very small Black or African American population. We also have more information on Native Americans and other people of color. That's part of this process, but the population in Maine is only 1.4% Black or African American. Our comparison pool are people that I explained to you before in the management information system statewide, of people who have committed similar felony crimes that relate to drug abuse. 5% in that pool are Black or African American, but only 2% are admitted to treatment courts. And so what we want to do is to at least have their presence in the courts comparable to their presence in the comparison pool, even though this isn't a one-to-one. We're not saying 5% in every single court has it, but it's on a statewide basis. So what we're asking, we're giving each court their own information on race and ethnicity, and asking them to look at 3 junctures. We're giving them data on 3 junctures: referrals, who's referred to the treatment court; admissions, who actually gets in; and graduations, who completes it. And the reason why we're asking them to look at these 3 junctures is because if they have a problem, they have to see if they have a problem. The problem will affect what they do, because it involves different people and processes. If their referrals, if they're not getting referrals of people of color, then we have to think about people who make referrals. For example, defense attorneys, prosecutors, probation officers are 3 of the large groups that make referrals. Are they aware of this disparity, and what can they do about it? If they have problem admissions, they have to think about who makes the admissions decision. And that's actually the treatment court team, and especially the judge, who has usually the final say in the admission. So they have to look at themselves. And if they have a problem with graduations, what we found is that sometimes different racial and ethnic groups have different paths to success as far as the treatment and also the community support. There's a lot of effort going on now to increase recovery support and community support for people in these programs. Does that include people of color, for example? Are we getting the same kind of, are people of color who do enter getting the same kind of support to help them to graduate? So each of these issues, people have to look at different, different things that might be producing it. So we're giving each court their own data. This is just an example on admissions where statewide, we have 5% with drug use offenses statewide, 1.9% admissions. Other people of color, including Native American, other indigenous groups, we have 8% in the pool, but only 4.6% of admissions. So this is the kind of data that each court is going to get for itself so that they can ask, they can assess their own court circumstances. Do they have a problem in either of those referrals, admissions, or graduation? If it exists, what's the potential causes and what's some remedies? And then we're asking them to set a goal, a measurable objective and action step to achieve the goal, and then to report back to the steering committee. So we're trying to initiate a statewide process over the next year for each court to work on these questions based on their own data. And we're almost done. I don't know whether you're more interested in mental health or veterans, because I have something to say about each of those.
Go ahead.
Okay. On the mental health, as Ann said, we have a separate mental health court. It's called a co-occurring court, actually, in Kennebec, that's statewide. But in fact, 2/3 of people with a substance abuse disorder also have a mental illness. This is national data: major depression, post-traumatic stress, anxiety, bipolar. And treatment providers in Maine, through their contracts, are required to be co-occurring. They're required to have both substance abuse and mental health treatment available. So we're basically asking each court to get with their treatment providers and say that co-occurring should be an expectation. We should expect anyone who's in the treatment court at least to be assessed and perhaps to have 2/3 have a mental illness that also has to be treated within the court. And we think that can help raise the graduation rates. There's also medication-assisted treatment is also available, as you know, and that's been a great help with some of these issues. On the veterans, I want to go back to the veterans because I think there are people who might be interested in that. If I can find it. Okay, veterans. The other area, I mentioned earlier that veterans have the highest graduation rate, 60% in the specific veterans court. But the state is trying to increase veterans services with separate treatment tracks in Penobscot, York, and Cumberland already is active in having separate treatment track for veterans. The research has shown that veterans have a different kind of ethic mindset, and they do better if they're treated with other veterans, and that's why there's this segregation of veterans. So that is being worked on right now, and I think that needs to be supported. There's a system called Veterans Reentry Search Service, VRSS, which interfaces with the Veterans Identity Registry. Basically, jails have access to a search service through the Veterans Administration that allows them to identify people in jail who are veterans. Sometimes people conceal it that they're veterans. And this search service is being used in some places, but not in others. And we're calling out, Hancock and Kennebec make good use already of the search service. So when they identify veterans and they have a substance use disorder, they're going to be a good candidate for the jail. I mean, for the treatment court. We're asking Penobscot County to activate their license to this service. York County needs to establish one, and Cumberland County already is the most active user. So there are tools to help with that we're promoting. And I think I will stop there, especially because it's 11 o'clock. Let's see. Wait, is that our time? Yeah, right, 10 to 11. So I'll stop there and see if we want to continue.
Yeah, thank you. I think we would all love to continue. This has been really, really interesting, and it's actually great to see the measures of success of the program and also the rooms for improvement. Unfortunately, we have a very full day today. And so I think what we could do as a committee is consider either continuing the discussion at a later time, or perhaps if committee members have questions, they might be able to email you directly. And would you be the appropriate person for them to direct correspondence to, or would that be
well,
Ms. Gordon or Mr. Gordon?
I guess, I don't know, Mr. Gordon has a more broad-based representation because the question might not relate to the evaluation. So why don't we give it to Richard?
We can do that, and then he could maybe triage any questions.
Yes, we're in close contact.
Yes, Madam Chair, I was going to suggest if you want to send it to me, I will make sure it gets to the appropriate person for an answer.
Thank you. So committee members, if you have questions, perhaps you can funnel them to either Tom or I, and we'll compile a list of questions and then send it to Richard Gordon.
Thank you so much for your attention. We really appreciate spreading the good news.
Yeah, thanks for the really interesting assessment, and also for all the work that's being done in the adult drug courts.
Thank you very much.
So we will sign off. Thanks.
Thank you.
Thank you.
And I did want to let everybody know that the PowerPoint will be posted on the Judiciary Committee's website. And again, please email questions to Tom and I, and we can compile them and send them to Mr. Gordon. All right, committee members, we are scheduled for a public hearing. We've all been listening attentively for an hour. Would committee members like to take a 5-minute break now before we start our public hearing? If so, please raise your virtual hand. Otherwise, we can do the hearing and then take a break before our judicial nominations. Okay, looks like people are pretty much okay with moving forward. So at this point, we will move into public hearings. So I will call to order the public hearing on LD 355, which pertains to real estate pest disclosures. And I see that the bill sponsor, Representative Connor, is here. And welcome to our committee, Representative Connor. It's very nice to meet you. And the committee process is that bill sponsors have as much time as they need to present a bill, and then any of members of the public, and then any co-sponsors are allowed to present for 3 minutes, and then members of the public will be taken in the order of supporting, in opposition, neither for nor against, related to the bill. So we will begin with you, and you have the floor. Thank you.
Excellent. Thank you, Madam Chair. I appreciate that. Senator Carney, Representative Harnett, and distinguished colleagues of the Joint Standing Committee on Judiciary. My name is Representative John Connor of Lewiston, and it is an honor to appear before you today to present LD 355, an act to require pest disclosure in all real estate transactions. The idea for this bill originated from a constituent who, I am sad to say, recently moved out of my district in Lewiston to purchase their dream home in the nearby town of Sabattis. After negotiating a fair price for the home, conducting a building inspection with a professional, and securing financing, Ben, Megan, and their 3 young children, Genevieve, Corbin, and Colette, moved into their new home. Soon after, they had an unexpected guest living in the room, a bat. At first, the family dismissed the presence of their uninvited guest as a one-off event, assuming they left the door open during the move or that living in a wooded area, perhaps it had snuck in. But just a few days later, another bat appeared in the home, indicating that there may be something more serious going on, and they had to move out of the home to stay with family until they could resolve the issue, which took several weeks. Incidentally, the Maine Center for Disease Control recommends a full round of rabies vaccinations for anyone who has slept or been unconscious in a home where bats are present, since it is not possible to rule out that a bat may have scratched or bitten that unconscious person in their sleep. So, Megan, Ben, and each of their 3 children received a series of 4 rabies shots. That's 4 per person, which were only available to be administered at the emergency room over the course of 4 successive visits. They also got to work identifying where the bats may be coming from and discovered some previously undetected gaps in the metal roofing. The bat removal specialist also detected bat guano on the roof, which was not visible during prior inspections, likely due to the fact that bats hibernate in colder months and become more active during the summer. Upon contacting the prior owners via the listing agent for the property, Ben and Megan discovered that the prior owners had discovered bats in the attic about 2 years prior to the sale and had contracted with a pest management company for bat removal and to seal the attic space. Obviously, that did not fix the issue long term. So when Ben and Megan inquired whether the prior owner would be willing to chip in for the cost of resolving the bat issue and their medical expenses, the former owner retained a lawyer, and the listing realtor contacted the Maine Realtor Legal Hotline, both of whom presented the argument that it was debatable and a gray area as to whether this would have been an issue that needed to be disclosed. Ultimately, the family's health insurance covered the medical expenses, and the realtors in the transaction contributed toward the cost of repairs, allowing the family to move safely back into the home. For Ben and Megan, who I believe are going to testify in this bill, learning of the past bat issue would not have been a deal breaker for buying the home. What this specific information would have provided was the suggestion that a closer look at the attic might be necessary, as bats occupy very small spaces and sometimes nest under insulation. Hard to find unless you're looking for them. Had they found them, Ben and Megan say that they still would have purchased the home, but this knowledge would have allowed them to correct the problem prior to moving in and putting their health and that of their children at risk. The intent of this bill is not in any way to slow down the very hot real estate market that we are all seeing, but rather to ensure transparency that lets home buyers make more informed decisions and get the professional advice they need, and when necessary, take steps to protect the health and safety of their families. We live in Maine. There is wildlife all around us. Each one of us knows a house, if not our own, where in the colder months, squirrels or mice or other small critters manage to make it inside. You've probably hard pressed to find a home that doesn't have a mouse trap or have a heart trap either somewhere in the home or out in the shed. The point is, however, that when a homeowner knows something about their house, it is very helpful for them to communicate that information to the home buyer. Under current law, buyers must disclose any known defect that could impact the value of the home or the health and safety of the occupants. The standard property disclosure forms in Maine ask about hazards such as lead paint, asbestos, radon, and methamphetamines. It asks about penetration of water either from the roof or from the basement. The form facilitates the transmission of information from the seller to any prospective buyer. It is my belief that by mandating required disclosure of past pest or wildlife infiltration, we will ensure that home buyers are better prepared to understand the risks and maintenance required for the homes they are buying. In closing, I would like to thank you for your time and urge the committee's favorable consideration of LD 355 to eliminate any gray area and ensure that when sellers know of past pest or wildlife infiltration, that they disclose that information to potential buyers. I thank you, and I would be happy to answer any questions that you may have.
Thank you very much, Representative Connor. Committee members, do you have any questions for the bill sponsor? Representative Moriarty, you may go ahead.
Thank you, Madam Chair. Good morning, Representative Connor. Thanks for your testimony this morning. I just wanted to ask you quickly about the intended scope of your bill. And in particular, do you mean to limit it to the known presence of pests or infiltration, or you are attempting to impose what lawyers would call strict liability upon the prior owner, regardless of whether or not they knew of the presence of pests?
Thank you, Representative Moriarty. My intention is the known. So the disclosure form for the real estate transactions is of the known items. So that is what my bill intends to point to, is just the known items that happen.
Okay, thanks very much. I guess if I don't overstep my bounds here, as we think about work session, maybe if that word known could appear at the beginning of subparagraph F, that might clarify that. One other thought was, does your bill apply to the backyard or the outdoors, or is it the structure itself?
Thank you again, Representative. My bill aims for the residential structure of the property that's being sold, just like you would on any normal residential transaction, what you are going to disclose in the residential portion of the home. That's what this bill is intended and aimed at.
Okay, very good. That helps clarify. Thank you.
Thank you. Representative Reckett, did you have a question?
Yes, I did. Actually, now I have a couple, but one of them just generated by Representative Moriarty's question. So what we're saying is that if I know there are skunks living under my shed, that's not a something I would have to disclose, because it's not the residential structure, it's a outbuilding. Is that true?
Correct. That is not the intention of this bill.
Okay, and the other two things I'm thinking about is the number of times I've had bats in my life, including when I first moved in here at one point. And but mice are the other. Well, there's the whole issue of mice and how you prove that it was 5 years ago you caught one with a trap and not a week ago. The other is the whole issue of bees, which tend to live in foundations and stuff. Are we talking about flying insects as well as everything else?
Representative, the intent is not necessarily per species or per animal. There does have to be some sort of common sense and some logic involved with this. For instance, the disclosure document says if there's water in the basement, you have to disclose it. Well, what does that exactly mean? Is it a rushing of water coming through the foundation, or is it if my washer backed up a little bit and it has a little bit of water? There is some discretion that needs to take place between the home seller and the agent. But in the industry, we've heard it: when in doubt, disclose. So if it's something that you would want known, before you buy a home, then we recommend it be disclosed.
Thank you.
Thank you, Representative Reckett. Representative Babbage, did you have a question?
Yes, Madam Chair, thanks so much. Welcome to our committee, Representative Connor. Good to meet you, and thanks for bringing this forward. Obviously, in a real estate transaction, the general rule is buyer beware. With Representative Moriarty's questioning, the word known, again, I just want to distinguish, and I apologize, I don't have the bill right in front of me. My toner cartridge just ran out. But I want to ask, you're not just talking about current, you're talking about past incident as well.
Correct, Representative. We are asking it to go back 5 years, as in the case of the example that I gave. the known incident was 2 years prior to the sale of the home. So we think that 5 years is a fair amount of time to go back in time.
And so this would be disclosed on the form that you mentioned. This is not something that you're assigning to the responsibility of a home inspector and their charge with regard to looking at a home.
Correct. So on the disclosure form, the property disclosure form that is filled out by the seller, it's a 7-page document, and not one time does it mention pests. However, on the real estate contract for sale, it does mention that the buyers should and have the right to inspections, and one of those inspections is a pest inspection. So our logic is the disclosure agreement is the memory jogger for the seller to say, hey, I've had these issues in the past, they've been remedied, but it just gives the buyer an opportunity to say, I want to hone in on that particular inspection, just as if a seller would have said, yes, we had a hole in our roof, we fixed it. That's on the disclosure. Then when it comes to the actual contract, the buyer knows that they want to go ahead and pay for that additional inspection for a roofing contractor versus just a general inspector.
Thank you. And I mean,
Representative Babbage, I'm going to
Okay.
ask you to hold, because you've had 2 questions and we have
Absolutely.
others who are in line. Thank you very much. Representative Harnett, you may go ahead.
Thank you, Madam Chair. Thank you, Representative Connor. Nice to meet you, albeit virtually. Just a couple questions. Maybe it's just one big question about the bill. You talk about pests and wildlife. Neither of those are defined terms in Title 33. I mean, there are common sense definitions. But in our house, we get ladybugs every winter and spring. They don't bother me. They really bother my wife. If we do something about the ladybugs, is that something I'm going to have to put on my disclosure statement? If I see ants in the kitchen in the spring and we put an ant trap out, is that something that I'm going to need to remember for 5 years to disclose? Or are you looking at pests as a pretty broad term?
Thank you, Mr. Chair. And I agree. Pests can be a very, very vast and wide, broad terms. The intent for this, and I would pose the question back to you, sir, that if you were getting ready to buy a property and the past owner knew that there were ladybugs every single year that they just could not get rid of, would you want that information known to you prior to buying the home? So that is the intent of this bill, is to put the onus on the seller to just give that information to a prospective buyer and let the prospective buyer decide if that warrants additional inspections or additional remedies.
Okay. Thank you, sir.
Thank you, Representative Harnett. Representative Libby, do you have a question?
Thank you, Madam Chair, and thank you, Representative Connor, for being here today. I think I have a pretty straightforward question. I'm just wondering if there are other states that have similar laws. Is there precedent for this in other states, and how has that worked out for any states that have passed this legislation?
Yes, thank you, Representative Libby. So as we can all pretty much assume, just about every southern state has a termite pest disclosure in their disclosure laws. However, closer to home, Connecticut and New York both have termites, wood / pests, disclosure laws on their books. In the Midwest, Missouri and Iowa both have pest disclosure laws that are on their disclosure documents as well. So a lot of other states, I don't have every single state listed, but a lot of other states do have such measures on their books.
And can I ask a follow-up, Madam Chair, please?
Yes, thank you. You may.
Did you find anything in your research indicating if such a disclosure had ever been problematic one way or another for real estate sales in that area?
Thank you again. And I will be completely honest, I do not know the answer to that. That is something I can look into and get back to the committee, but I have not seen anything that's jumped out in the research that I've done, but I will dig deeper and try to look for that.
Thank you, Representative.
Yeah. Could you please bring that information to the work session, Representative Connor?
Absolutely, Madam Chair.
Thank you. That would be really helpful. I see a couple more hands up and both have asked questions. So first, any committee member who has not already asked a question, like to ask a question to the sponsor? Not seeing any. So Representative Babich, did you want to ask an additional question?
Thank you, Madam Chair. Yeah, the last one that I was going to answer in the string of three that I had earlier was merely, well, Representative Libby mentioned about other states having similar rules. I'm thinking that most states might have rules that would affect the structure of the home. I wonder if any other states would have had an ordinance or a statute that would have required the presence of a bat in the home in a previous, not as an ongoing problem, but as a previous event. Because I'm unusual. My point, I guess, is I'm asking. Usually, you want to bring legislation forward that would reduce the potential for litigation, not provide opportunities for it. If you understand what I'm saying, and I understand where you're coming from. I just wonder if the fact that people put out mouse traps here and there and their failure to mention that as a periodic occurrence would jeopardize their compliance with the form. Do you get where I'm coming from, Representative Connor? Yeah.
Yeah. Thank you.
I believe I do, Representative. I didn't exactly hear what the question was, but I do understand where you're getting at with the opening up for litigation. But again, my bill is mainly geared towards consumer protection. This is to protect the consumers on the buying side of the transaction.
My question was, you do want it to include non-structural pests such as mice or.
Yes, sir. That is the intent of the bill. Is it may not just be structural, but any type of infiltration or infestation may be a better term.
Thank you, Representative Connor. Representative Libby, did you have a question?
I do. Thank you, Madam Chair. So I just want to clarify, Representative Connor, my understanding of what this bill does. We recently moved as well, just like the folks that brought this issue to you. And when we moved into our very old farmhouse that had been empty for 4 months, we found that we had a whole bunch of little friends living with us. And so it sounds like this is this sort of bill that would address that. Now, we're fairly sure that, of course, the folks probably didn't know about it. The house had been empty for a while, but as we look at this bill, I recall a conversation with our electrician. We were discussing some wiring updates, and he mentioned that those particular critters that we had found tended to chew on wiring and could cause harm, pretty devastating harm to our house if that happened. And so would the intent of this bill be particularly for pests that have the potential for harm, such as the incident with the bats that you mentioned, and any risk for fire as we would face in our house if we continue to have those critters living with us?
Again, thank you, Representative Libby. So the disclosure document is very clear that anything that could affect the value of the property or the health and safety of the occupants is what needs to be disclosed. So if you have an infestation of critters that could affect either of those, then yes, the bill is aimed at disclosing that. When in doubt, disclose. Perfect.
Thank you for the clarification.
I have a question for you as well, Representative Connor. So what you're talking about is having something that could be harmful to the structure or to the occupants listed just on the disclosure form. And then it would be, excuse me, up to the prospective buyer to decide what kind of an investigation to do and whether it would have any impact or not on the sale. Is that correct?
Yes, Madam Chair, that is the intent of the bill, is to be a memory jogger, if you will, for the seller of the property. If it's on the disclosure sheet and it just says pest, well, it jogs the memory to think back. Have I had, pests that I've had to eradicate? And then put it on the disclosure form and allow the buyer to do the investigation and to hire the proper technicians or professionals to dig deeper into it, to find out if there is a health and safety issue. So yes, that is the intent, Madam Chair.
And a prospective buyer could also just decide not to take any action if they like ladybugs, for example.
That is absolutely true. Just as it is now, if a leak was found in the basement and it was disclosed on the form, the buyer is not obligated to have a foundation expert come out and test for a leak. That is their prerogative. So it doesn't necessarily kill any deals in this hot market. It's just, it gives the buyer more information. That's what this bill is aimed at, is giving the buyer the most amount of information possible for such a huge purchase.
Thank you very much. Committee members, does anyone have additional questions for the bill sponsor? Representative Babbage, your virtual hand is up. Are you all set?
I'm all set. Thank you very much, Madam
All
Chair.
right, thanks. And I'm not seeing any other hands up. So thank you very much, Representative Connor. We really appreciate you coming to speak today and introduce this measure.
Thank you, Madam Chair.
At this point, we will move on to those who are wishing to speak in favor of the bill, LD 355. And I see that Mr. Cashman has joined us. Mr. Cashman, are you here to speak in favor of the bill? You're muted.
My apologies. I'm actually here in opposition to the bill, so I'm happy to hold back. I think everybody's muted right now.
Yeah.
Yep, you're on mute, Ann. Senator Carney.
Oh, thank you. If you could please turn off your camera and mute yourself until we call on you, we'd appreciate it. Thank you.
Absolutely. Thank you.
Is there anyone else who is here to testify in support of LD 355? I'm just going to check the attendee room here. I'm not seeing anybody here to testify in support. So at this point, we will take you, Mr. Cashman, testifying in opposition to the bill.
All right. Well, thank you very much, Senator Carney, Representative Harnett, distinguished members of the Joint Standing Committee on the Judiciary. My name is Andy Cashman. I'm a partner at Pretty Flaherty, and I'm here today on behalf of my client, the Maine Association of Realtors, which has over 5,600 members statewide, representing buyers and sellers of residential and commercial real estate throughout the state, and also affiliated members in related industries. I just want to say at the outset that, the prime concern that our members have is to make sure that people are happy with the transaction that they have, and that they're healthy in the homes that they purchase through our members. We are opposed to this bill for three reasons. And, there was a really great discussion, I think, there with the sponsor on some of the issues that we'd like to highlight in our testimony. I have submitted written testimony. I'm going to deviate from that a little bit just in the interest of time. But the three issues that we have is that the language is vague as it is now. I think it goes beyond what the sponsor just said that it was his intent was. In addition to that, we have concerns with the fact that the language is unnecessarily duplicative with existing seller disclosure law. And then third, we think that it's important to go beyond this proposal and do what our members are already doing, which is making sure that consumers are well educated. And so the first thing, just in terms of the vagueness, I think it was discussed a little bit in the questions, but this is requiring a pest or wildlife infiltration disclosure on the real property. I recognize that may not be what the sponsor is intending, but as drafted, that's what this would require. So again, it's vague as to what is considered a pest, what is considered wildlife, and what is considered an infiltration. The scope is very broad because this does not apply to the dwelling. It applies to the entire property around the dwelling as well. So conceivably, again, as drafted, and I recognize this isn't the sponsor's intent from what I've heard, but any wildlife in the yard, ants, squirrels, deer in the yard would need to be disclosed under this proposed language. But more troubling, I think, is the fact that this really is not required because, as I think the sponsor said a little bit, there are existing disclosure requirements for sellers as it is. And I just want to be clear about, given the questions that were asked there earlier, I want to be clear about what the existing statute requires. There are two different sections of the existing seller disclosure statute that already cover exactly this issue of pests and wildlife. The known defect requirement of seller disclosure, as the sponsor said, impacts anything that has a significantly adverse impact on the value of the property, that impairs the health or safety of the occupants or future occupants, or that if it doesn't get removed would impact the longevity of the property or the premises. So that absolutely covers existing statute, so existing disclosure. The hazardous materials is also something that's required. Both of those things are fully articulated in our seller disclosure form. In addition to that, we think that educating buyers and making sure that they know what they should be asking is important. We have that in our purchase and sale agreement. We already say some of the due diligence that you may want to consider includes pests. So when somebody is looking to purchase a property, that is discussed by our members with the potential buyer. We would be willing to amend one of our
Mr. Cashman,
booklets. Yes.
the 3 minutes is up. If you could.
Okay, apologies. I'll wrap it up. I was just going to say, I'm happy to talk about this more should I get any question, but we'd be happy to amend one of our materials I think might be helpful in further educating buyers as well, which I think gets to the heart of what the sponsor was discussing. So with that, I'm happy to answer any questions that you may have about this and kind of walk through some of that statute if that's helpful. Thank you for your time and consideration.
Thank you, Mr. Cashman. Committee members, are there any questions for Mr. Cashman? I am not seeing any questions for you, Mr. Cashman. I actually do have one. If you could provide us for the work session with a blank copy of the typical real estate disclosure form, I think that would just be helpful for us to be able to see. And if you could provide it in electronic format to our committee clerk, we'd appreciate it.
Thank you, Senator. I'd be happy to do that. And I did include, I can include the relevant parts in there for the disclosure. And I did include in my testimony already the relevant part of the purchase and sale agreement, which mentions pests as something that they ought to consider for due diligence. So, but I would be happy to get the disclosure you requested.
Thank you. And I see that Representative Libby has a question. Go ahead.
Thank you, Madam Chair, and thank you for being here today, Mr. Cashman. I just wonder, Representative Connor's constituents are far from the first person I've heard having this issue when they purchase a home, and sometimes those signs at an inspection are simply not there. And so can you recommend a strategy that you think would work, or wording that you think would work to fill that gap? I realize that not every realtor is, they don't all exactly replicate each other's educational strategies precisely. So is there a strategy that you would recommend to rectify this issue when it does come up?
Yeah, thank you, Representative. I think that the issue is that buyer education is important, and so what I was going to say in terms of an additional change that we could make on materials that are provided to buyers would be that every new buyer that our members work with get a residential property transaction booklet, and that includes sort of the whole scope of everything that ought to be considered by a buyer when they're purchasing a property. And we could include, it already talks about conditions of structures and systems and environmental hazards are all things that they ought to be thinking about before they even look at a property. But we could amend that to also specifically call out, pests and wildlife as an issue to further, jog that memory. But I would also say that our forms, our members are of the total amount of licensed people that are licensed to transact real property transactions in Maine, we represent about 90% of those, and the other 10% we think are mostly inactive. So what our materials are being used by essentially every transaction in Maine. And as I said in that purchase and sale agreement, we go beyond what the statute says by articulating these are different things in the due diligence that you ought to think about. And my testimony includes that. And pests are among those things. Pests are hard because I think that, there's no doubt at all that they need to be disclosed under the existing statute. But as I'm sure we're all aware, they have a way of sometimes getting back into the property. And I think that probably was the issue as to why the sponsor said that they were told that it was a gray area. I think that the gray area was probably as to whether or not, sufficient mitigation had been done. There was no gray area whatsoever in terms of the need for disclosure. So in that transaction, those buyers, the seller should have absolutely disclosed the prior presence of bats. It's gray because bats in particular unfortunately, I know this from personal experience, have a way of being able to find their way back into a structure if certain changes are made to the structure, such as, changes to the roofing and things like that. So I think that would be the only gray area here I don't know the facts in this particular case, but I would not deviate at all from the fact that those sellers should have disclosed that presence of bats.
Thank you, Mr. Cashman. Representative Libby, did you have one follow-up?
Yes, I do have a follow-up. It's kind of two parts, but they're both very brief. So if by statute that's already required to be disclosed, but seems like that's perhaps not clear to some sellers on occasion, what is the harm in specifically asking, even if the wording in the proposed bill were changed to be more specific? And then my other question is, because I'm not familiar with this part of the process, if there was a prior issue, say with squirrels versus bats, would that be a different type of inspection that the inspector would then know to look for?
So I don't believe so in terms of the last question there, in terms of whether it would be a different inspector. I think that the inspector's job generally is to say, to look at things more generally and say, hey, it looks to me like you may have a pest issue there. You should hire, a pest management company to take a look at that and do a proper inspection. That would be sort of the big trigger. Or you could hire a pest management company yourself and have that inspection done as part of the due diligence. It's a really good question as to, why not articulate this in the statute itself. And the reason for that is because there are so many things that could be a problem for people when they're buying a house that there's no conceivable way to articulate every single one of those things in a list. And when you start adding things to the list, it gives a sort of it gives a weight to what's on the list versus stuff that isn't on the list. So that's why the statute is drafted the way that it is, in that it doesn't by any means cover everything that could be problematic for people. It has these catch-alls of saying, it sort of takes a step back and it says, what is the problem with all of the things that could go wrong with a property? The fundamental problem is that it could hurt the value of the property, it could hurt the people, the health of the people living in there, or it could hurt the longevity. That's why we have the any known defect standard. Over time, other things have been added to that, but it's not necessary in this case by any means because it's already captured under that existing catch-all. And so that's really why we prefer the catch-all approach as to articulating everything that could potentially go wrong. At the end of the day, more information is important for the buyer, and the seller needs to disclose as much as possible, as the sponsor said. And that's what the law requires now. And then it's up to the buyer to say, of those things that have been disclosed, I'm concerned about this, but not that. For one person, one thing may be a deal breaker, and for other people, it may not be. And that's why the seller disclosure law is so broad. And then on the due diligence side, on the buyer side, we say, these are things you, even despite the seller disclosure, these are things you ought to be thinking about and asking about and thinking about whether or not that is important to you or not, and asking those questions. So I hope that's helpful.
Yeah, thank you, Mr. Cashman. Representative Babbage, I'm not sure whether your hand is up from a previous or whether you have another question.
It is up, Madam Chair.
Okay, go ahead.
Thank you. Mr. Cashman, can you help me to understand whether this problem that we are looking to solve through this legislation would be something that I guess I'm trying to negotiate the seller disclosure form versus a home inspector's responsibilities. And perhaps you can tell me if I haven't visited this in a few years, but has anything been put into statute that specifies some consistency as to what home inspectors would check for, and is this problem one of them?
That is an excellent question, Representative. And the answer is that we were supportive of a bill last session that would have licensed home inspectors in terms of consistency. And that did not end up passing last session, but we are in support of that general principle. However, I think that the difference between, the seller disclosure is anything that you know about that has been an issue with the property. That's, it's on you to disclose that to the next buyer, because if you don't know, it's not fair to put that requirement on somebody. But if you know, and conceivably if you're living there, you should know, then that is what is required. But the inspector portion goes to the due diligence, and the level of due diligence and the level of, how you pick that inspector, what inspections you pick, are all really up to the buyer to make that decision, to say, I understand that, this wasn't disclosed as a concern, but I really, really, really don't like mice or, whatever the case, spiders, whatever the case may be. And I want to make 100% sure that that is not here in this house. So it's sort of a twofold thing. It's, what's required on the seller side, and then what the buyers are encouraged to do.
Thank you. Thank you, Mr. Cashman. Thank you, Madam Chair.
Thank you.
Committee members, are there any other questions? Go ahead, Representative Libby.
Just one quick one. Thank you, Mr. Cashman. Thank you, Madam Chair. My last question is simply, it sounds like Representative Connor, the folks he was hearing about this issue from, they were told that this was a gray area, but what it sounds like you're saying is that this is not a gray area, it is a black and white area, and that issue should have been disclosed. Is that accurate?
Yeah, thank you for that question. Yeah, that's absolutely accurate. The issue, I think, is there's two issues. One, what should have been disclosed? The law is 100% clear that should have been disclosed. What the reference to the gray area, I can only imagine, was to say, okay, you have lawyers involved now. What is the likelihood of somebody winning a case, right? And what I was talking about in terms of the gray area, I think would be, whether or not those bats were still there, how would you prove it, so on and so forth. But really importantly, the way those issues around disclosure are dealt with is through mediation. And that, I think, is part of the good story here in terms of what happened to the family, was that ultimately it sounds like from what the sponsor said, that things were worked out, the costs were shared by the realtors who were not obligated to do that, but wanted to do it, out of just making sure everybody was happy with the transaction. But there is mediation, is how those things are dealt with.
Mr. Cashman, I think you're taking us far beyond the scope of the bill. We appreciate your your thoughts about what happened in that process, but I think that the whole mediation concept takes us beyond what we're here for a hearing on today. Thank you very much.
Yeah, I appreciate that. Thank you, Senator.
Madam Chair, I do have one quick clarifying question that speaks to the same question that I had.
Okay, go ahead.
And that is, can you just clarify for me if the current statute is for disclosure of an existing problem or a historic problem?
It's disclosure of a known problem. So if you know so in this case, like with bats, the reason that was required was that the presence of bats, even if it was mitigated, still should have been disclosed because they can return regardless of mitigation. It's very easy for that to happen. As I said, unfortunately, I'm personally aware of how that works. And they can also leave hazardous materials in the home, like in the attic, for instance. And therefore, even the fact that it occurred in the past and was mitigated should still have been disclosed.
Thank you very much.
Thank you, Mr. Cashman. Committee members, are there any other questions? Okay, I'm not seeing any other questions. Thank you very much for presenting today, Mr. Cashman.
Thank you for your time.
You're welcome. At this point, we call for any additional witnesses in opposition to the bill. I'm not seeing any. Is there anyone here to speak neither for nor against LD 355? Also not seeing any additional. I'm going to just check the attendee room. Nope. All right. And I think that then concludes the public hearing on LD 355. Thank you very much. And we will take a short break until our nomination hearings begin at 12:30. And so I would just encourage committee members, if you're going to sign off, please sign back onto the same link. And if you're not going to sign off, please remember that the live streaming continues. So mute your mics and stop your videos. And we'll see you at 12:30. Thank you.
Hi, Judge.
Hi, John.
Good afternoon, Your Honor. How are you?
I'm well, thank you. How are you?
I am well. It's going to be hard for me not to call you Chuck.
Yeah, well, I won't mind.
We are big on decorum here.
I know, I've been watching.
Hi, Chuck.
How are you?
It's good to see you.
Great to see you too.
Hi, Judge Dow. It's nice to meet you.
Nice to meet you, Senator.
Good morning, Your Honor.
Good morning. How are you? A lot of friendly old friends on this.
Right.
Except this person. How are you, Peggy?
I'm doing great. It's nice to see you. And I was just thinking about how we used to plot to make your phone ring while you were sitting in the committee room.
No doubt.
Yeah, he caught on pretty quick, so didn't last long. Well, it's nice to see you.
Nice to see you too. In the chat, Danielle Carson is asking a question. Does she have a video option, Soupy, or is that only available to her when it's her turn?
Unfortunately, only available, she can watch on YouTube, but for these purposes, only when I bring her in as a panelist, when it's her time to speak.
Great.
We are going to give committee members a few more minutes to gather. Then we will start up as soon as we can.
Peggy, I thought you were going to remember about my little dog who would wander down to Judiciary. That was his favorite place to be. Remember Finnegan?
Finnegan, right. I'm sure Finnegan's no longer with us.
No, he sure isn't.
Yes, right. Adorable dog.
Yeah.
Yes.
I know Representative Evangelos had to travel over to the state office building, so he's going to be another minute.
I'm here.
He's here.
He's a marvel. Look at that.
Representative Evangelos, nice to meet you. I'm Charles Dow.
Thank you, sir. Nice to meet you too. Looking forward to hearing from you today.
Judge Dow, I'm Chris Babbage. Nice to meet you as well.
Well, we've met Representative Babbage back when you would bring honorary pages to
I had
the
forgotten.
State House when you were teaching at Kennybunk.
Wow.
Thank you for remembering. That's great.
Ooh, that's good. Judge Dow, I'm Steve Moriarty. I don't think we have met, actually.
I don't believe so, no. I've been
Good to have you here.
good to be here, but I've been watching hearings on YouTube, and so I feel like I've been spending time with you all.
Good afternoon, Judge Dow. I'm Laurel Libby.
Pleased to meet you.
Okay. It looks like we have most of the committee here. My name is Tom Harnett. I serve as the House co-chair of the Judiciary Committee, along with my Senate partner, Ann Carney. This afternoon, we're going to have 3 judicial confirmation hearings. But because this is a new audience and cast of characters, I am going to start by having the committee members introduce themselves as I call on them. And I'm just going to use the list that's showing up in my participants, so it's somewhat random, beginning with Representative Evangelos.
Good afternoon. Welcome, everybody. Jeffrey Evangelos, House District 91, and I reside in Friendship.
Thank you. Representative Downs?
Good afternoon, and thank you, sir. I'm Kathy Downs. I represent District 130, which is Bucksport and Orrington, and I live in Bucksport.
Thank you. Representative Poirier?
Thank you, Mr. Chair. Jennifer Poirier. I represent House District 107, which is all of Skowhegan and a part of Madison.
Thank you. Representative Libby?
Thank you, Mr. Chair. Good afternoon, everyone. I'm Laura Libby. I represent District 64, which is part of Auburn and all of mine, and I reside in Auburn.
Thank you. Representative Sheehan?
Good afternoon, everyone, and thank you, Mr. Chair. My name is Erin Sheehan, and I represent House District 12. That is part of Biddeford.
Thank you. Representative Babbage?
Good afternoon. My name is Christopher Babbage. I have the privilege of representing most of the people of the town of Kennebunk in House District 8.
Thank you, Representative. And Senator Keim?
She indicated to me that she might be a little late joining us this afternoon.
Thank you. Representative Moriarty?
Yes, invigorated by a great lunch. I am Steve Moriarty from Cumberland, representing House District 45, which is Cumberland and part of Gray.
And Senator Carney?
Good afternoon. I have to laugh at your invigoration with your lunch, Steve. I'm Senator Ann Carney. I represent Senate District 29, which is South Portland, Cape Elizabeth, and some of Scarborough, and I reside in Cape Elizabeth. Welcome.
Thank you. Are there other committee members that are on that I might have missed? Representative Reckett?
Hi, my name is Lois Reckett, and I represent District 31, which is the ocean end of South Portland.
Thank you very much, and I'm sorry to have overlooked you, Representative Reckett. Are there any other committee members that have not been heard from? Thank you. Well, the first hearing that we have this afternoon is a confirmation. And this is a public hearing of the Joint Standing Committee on Judiciary for the purpose of considering the nomination by the Governor of the Honorable Charles A. Dow of Winthrop for reappointment as a district court judge. The meeting today is being conducted electronically. Under the law and joint rules of the legislature, this committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by majority vote of the committee members present and voting. As chairs of the committee, we will then send written notice of the committee's recommendations to the President of the Senate. The committee will hear testimony from and have the opportunity to question the governor or her representative, Mr. Reed, the nominee, and any other persons present who wish to speak for or against the nomination. Before we get started, I want to share some information related to the fact that this meeting is being conducted electronically. The meeting is currently being live streamed on the committee's YouTube channel. This means that anyone who is a participant in the meeting via Zoom can be seen and also heard if their microphone is unmuted. People testifying cannot be seen or heard until they are called upon to speak. This meeting will be recorded and available to view on the committee's YouTube channel early this evening when the meeting has been concluded. Pursuant to Title III, Section 157 of the Maine statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes Representative Moriarty.
Thank you, Mr. Chairman. I move that the Joint Standing Committee on Judiciary recommend confirmation of the Honorable Charles A. Dow of Winthrop for reappointment as a district court judge.
Thank you, Representative Moriarty. Motion made by Representative Moriarty. I will now call on Representative Reckett for a second. Representative Reckett, you're on mute.
I think Chris was going to do this, but I'll do it anyway. Anyway, I think I second the nomination.
Thank you. Seconding the nomination of the Honorable Charles A. Dow of Winthrop for reappointment as a district court judge. The statutory requirements of this position and the legal requirements for the nominee are set forth on the committee's webpage. At this point, I now recognize Jerry Reed, the governor's counsel, for the purpose of making a statement concerning this nomination. Mr. Reed, welcome.
Thank you. Good afternoon, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on the Judiciary. I'm Jerry Reed, legal counsel to the governor, here today to present the Honorable Charles A. Dow as the governor's nominee for reappointment to the Maine District Court. Judge Dow was appointed to the District Court by Governor Baldacci in 2007, reappointed in 2014 by Governor LePage, and has served there with distinction. Before joining the bench, Judge Dow had a varied legal career, which began in private practice at a small Portland law firm. He then served for 3 years as legal counsel and policy director to the Speaker of the Maine House of Representatives, and spent 5 years as special assistant to Attorney General Steve Rowe. He and I were colleagues in the AG's office during that time, and I knew him to be smart, insightful, practical, calm, and an excellent communicator. Judge Dow is a magna cum laude graduate of the University of Maine at Fort Kent with a degree in English and social science, and earned his law degree at the University of Maine School of Law. In his most recent term, Judge Dow has presided primarily in Lewiston, Farmington, and Waterville, as well as Augusta, South Paris, Rumford, and Skowhegan. In his 2 terms, he has sat in 27 of Maine's 29 district courts at one point or another. During his tenure with the district court, Judge Dow has earned a reputation as a highly effective jurist. He's known to be a good listener with a patient manner that puts those appearing before him at ease while always maintaining control over the courtroom. He's a knowledgeable, efficient, and compassionate judge. His reappointment to the district court is well deserved, and the people of the state of Maine will be fortunate to have his continued service. On behalf of the governor, I respectfully request your support for the nomination of Judge Dow to the position of judge of the Maine District Court, and will be pleased to answer any questions that you may have of me. Thank you.
Tom, you're muted.
Thank you. Before turning it to questions from the committee, I would like to give the opportunity to Representative Newell to introduce herself. Representative Newell.
Thank you, Mr. Chair. Good afternoon, everyone. Please excuse me for joining late this afternoon. I am Representative Rena Newell, representing the Passamaquoddy tribe.
Thank you very much, Representative Newell.
Thank you.
Now I would ask if there are any members of the committee who have any questions for the governor's counsel. Mr. Reed, if you do, please use the electronic hand raise feature. And seeing no questions, I will move on to another representative of the governor's office, and that would be Mr. John Hobson, who chairs the governor's Judicial Selection Committee. Welcome, Mr. Hobson.
Thank you very much. Representative Harnett, Senator Carney, members of the Joint Standing Committee on the Judiciary. My name is John Hobson. I have the honor of being chair of Governor Mills's Judicial Selection Committee. On behalf of the Selection Committee, I request that this committee act favorably on the nomination for another term of Judge Dow. Judge Dow has gotten excellent grades and feedback. The committee got feedback in terms of Judge Dow's mastery of the district court docket, his ability to handle the courtroom, and his general overall willingness to serve where needed, as you heard from Mr. Reed. But there are really 2 qualities about Judge Dow that I think it's important that the committee know about. As the committee knows, the judiciary and the judges that make up the judiciary come from all backgrounds. And it's important that in terms of delivering justice for the people of the state of Maine, that there may be many different components to that. And what Judge Dow brings to this job is, perhaps by function of his just natural personality, is an ability to both be empathetic and still lay down the law. That is something any number of practitioners have brought to the attention of the committee, is that Judge Dow is somehow able to get those who are standing in front of them and hearing bad news to actually feel like they still like Judge Dow and respect Judge Dow. And that is not an easy trait to develop. And candidly, I think there's a fair amount of natural ability on Judge Dow that he's able to do that. And it's important from the standpoint of maintaining a respect for the state and for the rule of law for that. And there's another quality that Judge Dow brings to this job that is a little perhaps unknown and maybe underappreciated, was being a judge in the state of Maine can be a very lonely job. It's an isolated position. Judge once remarked to me is, my jokes were never as funny as when I became a judge. You kind of set yourself apart so you can judge others, and that can be lonely. Almost universally, the colleagues of Judge Dow really appreciate his enthusiasm, his collegiality, his willingness to share knowledge, and his kind of just general openness and approachability. And that is important from the standpoint of maintaining morale within the judicial ranks and candidly having judges do the best job they can, because a judiciary that gets along, judges that get along, that have a sense of collegiality, really are better for not only their own jobs, but they'll do their jobs better for the people of the state of Maine. And Judge Dow, I think, candidly brings some kind of just a natural personality to the job that allows that, an approachability and an openness, and his colleagues on the bench have appreciated that aspect of Judge Dow's performance. So he does an excellent job in dispensing justice. He does an excellent job in having the people of the state of Maine be able to understand the rule of law and respect it. And he brings another aspect, which is basically the collegiality. So on behalf of the committee, I request that this committee act favorably on the nomination of Judge Dow to another term. The people of the Maine will be well served if he serves another term. Thank you.
Thank you very much, Mr. Hobson, and we always appreciate you coming to testify on these nominations. And thank you for your service to the state by chairing the selection committee. Are there any members of the committee that would like to ask Mr. Hobson a question? Again, seeing none, I will move on. I now recognize the Honorable Charles A. Dow for the purpose of making a statement concerning his nomination. Judge Dow, welcome.
Thank you very much, Representative Harnett, Senator Carney, members of the Joint Standing Committee on Judiciary. I'm Charles Dow. I live in Winthrop. I've been a judge of the Maine District Court for the past 14 years, sitting most of that time in Waterville, but also 5 years in Androscoggin, Oxford, and Franklin counties, getting around to all 16 counties at one time or another. Joining you today from South Paris in Oxford County. We're joined virtually by my family. I'd love to introduce them to you in person. My partner, Megan Burbank, is a lawyer in Lincoln County. Her children live in Lincoln and Kennebec counties. My son Patrick lives in Fort Kent. My son Ian is in Orono. My daughter Phoebe in Winthrop. Also watching you online are watching us online, my parents, Alan and Patricia Dow from Fort Kent, my sisters Jocelyn Haley and Sylvia Dow Harvey. I'm sorry that we can't meet in your beautiful historic committee room before the meeting really was called to order. I was remembering with Peggy Reinch some of our memories from working around there, and I have just one to share with you that works into my remarks. And I was remembering that when I first worked in the State House as a House page in 1992, the Senate chair named on your door was N. Paul Govreau, senator from Androscoggin, and a former state representative from Auburn, the city now that is represented on your committee by Representative Libby. Paul would go on to leave the legislature and join the Maine Attorney General's office as chief of the criminal division and then to other positions in the office. But he was a kind and dedicated public servant and a friend of mine, and Chairman Harnet's and Jerry Reed's and many, many others. And he died of a heart attack at age 71 on April 7th, 2020, during the early weeks of the pandemic shutdown. And so with your leave, I've printed a copy of Paul's obituary to attach to my remarks. But I wanted to share the memory of sitting in your committee room with Paul when we were both at the AG's office. We were waiting for our turn to testify. Paul had the bag of candy that's the obligatory tribute from a former member to the committee. And I feel certain that if Paul were here with us, I've tried to think of something to share with you that Paul would certainly share with us. And of course, we were scheduled for a week ago, and he would have certainly told you that pitchers and catchers report for spring training beginning tomorrow. And now I think the rest of the team is reporting tomorrow instead. But Paul was a big baseball fan, as you can see in his obituary. I remember Paul Govro to you for the record, but also because his commitment to public service is also my commitment. I don't like to work the kind of hours that Paul worked, because nobody does, because he was absolutely tireless in his service to the people of this state. But 14 years ago, I told this committee that to the extent I had a family business, it was public service. My mother was a teacher in the St. John Valley for 39 years. My father was a Fort Kent firefighter and fire chief, in addition to his day job for the Postal Service. And so when I got into law school, I could tell my father didn't love the idea of me being a lawyer. He didn't come right out and say it, but I asked him. I could sense that he didn't love the idea. And so I asked him if he was okay with it. And he begrudgingly said he was, quote, "as long as you're not crooked," was his guidance to me. He worried that the law was not honest work. And needless to say, my parents were relieved when I found work with a very decent human being whom they loved and I loved, my mentor as a lawyer, former House Speaker and Attorney General Steve Rowe. And I've tried to follow his example of scrupulous honesty, hard work, and servant leadership throughout my career as an attorney and a judge. Incidentally, through him, I met Representative Reckett, and I fondly recall driving both of them on a whistle-stop tour of Maine TV stations to draw attention to teen dating violence on a hot summer day. My service on the district court has focused more on civil and family work than on criminal. I could not estimate to the nearest 100 the number of bench trials I've presided over in the areas of child protection, divorce, parental rights, protection from abuse or harassment. I was surprised. I thought I would try to give the committee some context. And so the folder on my computer in which I try to save the decisions in which I write out findings of fact contains 1,255 files. These would not include most decisions made on a form order or ones that I outline on the record for lawyers to finalize and submit, which I do as often as I can. And so as you may imagine, I've made many mistakes, only a few of which the law court has fixed on appeal because they were errors of law. More often, a trial judge's mistakes consist of believing someone who's lying, making a poor choice of a remedy for a wrong, or just saying the wrong thing in a situation. And I've done all of those things. If I'm fortunate enough to have a hearing without opponents today, it's not because there are none or I've made no mistakes. I acknowledge that. I do want you to know that I try to learn from my mistakes. I work constantly to improve in terms of quality and efficiency. I think of my friend, former Judge Michael Cantera, who used to say that every day he learned something new being a district court judge. And that was either about the law or about himself or about Maine people, but most days all three. And I would agree with him on that. And I take feedback, both formal, like the Maine State Bar Association evaluations, and informal, which can be everything from the expressions on people's faces to the motions that get filed after the fact in cases. I try to be a better judge every day. I think that being a better judge requires staying on top of emerging issues like digital evidence and emerging practices like Zoom bench trials. And you see in my resume that was provided to the committee the leadership and training roles I've taken in those areas. District court judging requires being available to the public needing to conduct emergency business, mostly preliminary protection orders for children and criminal search warrants, but a variety of other kinds of emergency business as well. In the past pandemic year, I've done these electronically, and that may be the way of the future, but I thought it might be interesting for you all to know that if you didn't know that, and to remember, at least for the record, that I've done those emergency functions of the court while ice fishing, while turkey hunting, while out on the lake in the boat, at baseball games, and at Christmas parties. After I sent you my remarks in writing, I thought I would just say, for the record, I don't drink. And so before you get the wrong idea about what it's like to do a search warrant at a Christmas party, it's not what might have come to your mind initially. But I have enjoyed that kind of interaction, and I'm grateful to have served in an era where the branches of government would sometimes meet face to face in plain clothes and performed essential functions of checks and balances. And I'm grateful, frankly, that my children had a chance to see it. And I'm glad to preserve it for your record. I believe that the court needs to be a part of the coordinated community response to domestic violence. For most of my time in Waterville, I presided over a domestic violence court, which is judicial monitoring for people who are enrolled in certified batterers intervention programs as a condition of probation or deferred disposition. And I believe it's effective at challenging the corrosive beliefs that support violence within families, and I'm proud to be part of it. Finally, I sincerely appreciate the confidence placed in me by Governor Baldacci in 2007, by Governor LePage in 2014, by Governor Mills, both as a Judiciary Committee member in 2007 and as our current governor. I appreciate the work of Mr. Hobson and Mr. Reed and their kind remarks. I ask the committee for favorable treatment of my nomination. Really respect the role that you all play in balancing judicial independence and accountability, and I'm happy to try to answer your questions.
Thank you very much, Judge Dow, and I wished we could have, thank you for introducing your family. I wish we could have seen them in person, and thank you for talking about Paul Govro. When my son was much younger, I would take him into Paul Govro's office on a weekend and tell him that was the Hall of Fame for baseball in Augusta. And oddly enough, we then ran into Paul at a game in Wrigley Field in Chicago just by happenstance once. So a lot of fond memories came back there. Thank you for that. I would now ask if there are any members of the committee who have questions for Judge Dow. And again, if you would use the electronic hand raise feature, I will do my best to call you in the order that I see them. And the first hand that I see is Representative Reckett.
I only played softball, but my hands moved quickly. Judge Dow, I wanted to ask you just a general question about what's your what's the most important piece of work you've done, either in the aggregate or in the specific, while you've been a district court judge? Just a tiny question.
Yeah. Representative Rickett, the domestic violence court is on my mind because you're asking the question, and I remember the work that we did together, and I just talked about it. I've always thought that was important because it tends to prompt discussions within the family. I mean, I don't think the most important part of it happens in the court, but the people who are involved in the process, I know, are talking to their sons and daughters. They're talking with their mothers and fathers, and that's the kind of going upstream that I think is it's important. But I've done an awful lot of child protection work, and I think that's fundamentally important work. So I'd say generally it's the work with Maine families who are in the most difficult times of their lives that I've been where I think some important work has been done. I'm happy to have played a small part of it, but it's a big question, Representative Reckett, and tough to answer. But I hope that gives you an idea of where I'm coming from. I really enjoy the role I get to play, and to witness. Maybe it's not even playing a role, but you get to observe and witness people at extraordinary times in their lives.
Thank you, Representative Reckett. Next, I see Representative Moriarty. Representative Moriarty.
Gotcha. Sorry.
Oh,
Judge
okay.
Dow. Thank you, Mr. Chair. Judge Dow, when you were last reappointed by Governor LePage 7 years ago, you completed a fairly extensive questionnaire. And I simply want to ask you whether there is any new information to report in the intervening 7 years with specific reference to your tenure on the bench and to the performance of your duties as a judge.
I apologize, Representative Moriarty, that I didn't go back and review that the questionnaire that I filled out 7 years ago. In the last 7 years, though, I did get assigned to the Western Maine region for 5 of those 7 years. Now I'm back in Waterville, but part of that was to manage that child protection docket, which is a heavy docket in Lewiston and had traditionally been managed by a single district court judge, and they wanted to see that practice continue. And so I got assigned there to be that child protection specialist. So I would say in my most recent term, I did become did do a lot more trial work than I had as just a general district court judge. As you know, those cases can be fairly complex because of the statutory scheme. There's a lot of litigation and therefore a lot of case law in the area. There's some federal rules involved as well. And so I think that in the last 7 years, I've become a little more sophisticated as a trial judge, especially on the civil side. And I think that the one thing that has really taken off in that time period too is the digital evidence. And at one time I had did a training, or kind of co-presided at at a training at the Bar Association summer meeting and another training, but I had a slide that covered the number of search warrants in Lewiston. That's where I was sitting. That looked for digital evidence. I mean, cell phones, computers, other devices, hard drives, and so on. So I don't remember how far back I went, but as you can imagine, there had just been an explosion of search warrants seeking that kind of information. And so I think that I and my colleagues really had to come up to speed on that and understand the emerging federal case law on that. And I've done that. I've been to the United States Secret Service and other entities put on a wonderful training. It's a week long in Hoover, Alabama, and I did attend that. And so those are a couple of notable updates, I would say, to my whatever my responses were in 2014. Those would be among the highlights for me. It's just becoming a more sophisticated civil trial judge in particular, and really understanding digital evidence and where the constitutional, the statutory, the criminal rules lines are in doing that kind of gathering that kind of evidence.
Good. Thank you.
Thank you, Representative Moriarty. Next, I have Senator Carney.
Thank you very much, Chair. This is not a question, but a request of the committee. We are in unusual times doing hearings like this electronically, and I'd like us at the end of Judge Dow's remarks.
You're muted.
Oh, sorry. I was saying that although we are meeting in an electronic format, it would be nice to observe some of the really wonderful aspects of nomination hearings, and I'm requesting that at the end of Judge Dow's remarks, we acknowledge the presence of his family, maybe by either waving or greeting them in some way.
Thank you, Senator Carney. You're a much better host than I am. We will do that. Next, I have Representative Libby.
Thank you very much, Mr. Chair, and good afternoon, Judge Dow.
Good afternoon.
Having worked in a field that requires continuing education in the past, I'm always interested to hear about folks' continuing education. So I'd love to hear what your areas of focus have been in the last 7 years of continuing education. Thank you.
Representative Libby, I think that's a good question. As I mentioned to you, my mother was a teacher, and both of my parents are real lifelong learners, I think. And so I'm curious about a lot of things. And without having the timeline in front of me, it's hard for me to tell what happened when. I did spend a couple of weeks at the National Judicial College in Reno, Nevada. I think that was 2010. And I have done several days at the advanced training on the national domestic violence. I'm pretty sure that's part of my resume, that there was an advanced skills training for judges in the field of domestic violence. As I said, the national training in Hoover, Alabama on digital evidence. And we regularly train as a main judiciary. During my tenure on the court, we have done that with on our own, just the main judicial college we do every other year for a couple of days. And there were stretches of time that we did it with New Hampshire and Vermont judges as well. If there are specific questions about training, I'll be happy to try to answer, but I think you've got a decent synopsis of my judicial education on my resume.
Thank you very much.
Thank you, Representative Libby. Next, I have Representative Babbage.
Thank you, Mr. Chairman. I have just two questions. The first might help us to understand your thinking a little bit, but it's actually an opportunity to give us a homework assignment. As a person administering justice, I wondered what you might say is an area that the legislature could be warned about or do some work on. I'm thinking about statutes that maybe cause the process to go in the wrong direction or an overreaction. I'm talking about budgetary issues or legislative clarity. Is there anything that you'd want to talk to us about that you've come across that might be something we should hear?
Well, Representative Babbage, one, I think that's a great question. Second, I think it would be unwise to answer it kind of off the cuff, if at all. I think we have a tradition in Maine of the judiciary tries to speak with one voice to you all, and I think that's the way it has to work. I was hanging around there in a policy role before. I know I don't do that anymore. But it's a good question. I think we do need to communicate from judiciary to judiciary committee and to the legislature as a whole. I think that observing the guardrails and observing the lanes is absolutely essential. But if I could give it some thought, and maybe we could follow up at a different time, but I'm reluctant to wade into something that is it's a big question.
The other thing, if I may, Mr. Chair, was just to ask Judge Dow, growing up in the St. John Valley, during that early adulthood as well, what about that part of your life helped mold your decision to be where you are now, and how did it affect you?
Well, certainly that's a place that I think is known statewide for its sense of community, for the volunteerism, that's a town that thinks of itself as the little town that could. And so just observing and being a part of the power of a town to, especially in the work that I do, Representative Babbage, in supporting children, and young adults, and encouraging them, even ones who are who could be a little off track, because I certainly could be pretty off track. You're talking about a time of my life when nobody would have picked me for a judge. When I was in high school, following rules were not my thing. And so I really relied on being in a community that helped me along and supported the good things that I did, and tolerated some of the bad. Not just, I had good parents, and thank God for that. But it really does help me to deal with and understand families who are in tough times, young people, and they're all young. They're all, most of the business I do is with young people. Sometimes they're young people who are in the state's custody in the protective capacity. Sometimes it's juvenile justice, and sometimes they're over 18, but they've got young children. They're trying to get by, or they're involved in protection from abuse, protection from harassment. So just so I would say that the community, and knowing the power of communities, the power of everyone in the community kind of supporting supporting someone and giving them what they need. That's what I learned in Fort Kent and in the St. John Valley, because I think that they're extraordinary at that.
Thank you for your service, Judge Dow. Thank you, Mr. Chairman.
Thank you, Representative Babich. Representative Evangelos.
Thank you, Mr. Chair. And hello again, Judge Dow. I was wondering, you probably are aware that our Judiciary Committee and the Commission on Indigent Legal Services is struggling around the issues of the Sixth Amendment Center report and the right to counsel. And when you say the judicial branch should speak with one voice, aren't there times when perhaps members of the judicial branch should dissent from the current status quo when we're not in abeyance with the United States Constitution?
That clearly the answer is yes, Representative Evangelos. I mean, I took an oath to uphold the Constitution, not to fall in line in the judicial in the judicial branch. So, you know, always, if you're saying, Judge Dow, you have to choose between, you know, speaking with one voice in the judicial branch or the constitutions of Maine and the United States, then I'll always choose the constitutions. That's my oath. And I'm aware of the difficult work that the committee is engaged in. I've been watching your hearings, trying to just understand and get ready for this hearing. But you know, you're talking about something that's near and dear to the heart and to the work that we do. It's a lot of the work that we do involves appointed counsel, and so I'm aware of the tough choices that you have, and of the report itself, and the way that's been set up. We'll say, if you don't mind, an observation maybe I could bring to it, and you know, I don't want to speak out of turn, but I think it's just important to remember that systems don't have lawyers. I mean, systems don't have clients, right? The commission doesn't have clients, and lawyers have clients. And in the field of child protection, where I'm most familiar, the law court has in the past several years developed a doctrine of effective assistance of counsel and a process for challenging ineffective assistance of counsel in the context of motions for relief from judgment. And so those have been litigated, and I've adopted the practice of trying to make a record at important stages of the proceedings. You know, what the parties' satisfaction has been with their lawyers, whether they've been able to reach their lawyers when they needed to, and whether they've been satisfied. And I think it's important for the committee to hear that there are a lot of people who have been very satisfied, a lot of indigent people who have been very satisfied with the services of their court-appointed lawyers. And so that's not to say that you shouldn't fix it, that all of the concerns about the system and the record keeping and all that aren't valid. I know what you've been hearing, and I'm not trying to disagree with, just saying case by case, people tell me that they've been able to reach their lawyer, they've been able to talk through the difficult issues, and they feel and they're very satisfied with the services of their lawyer. And no matter what you do with the system, it's still going to boil down to a lawyer with a client.
Thank you for that. Just one more quick question. This one's a softball. On your questionnaire, question 17B, your intention to withdraw from any participation in the management of enterprises at home. Did you win that argument with your wife?
You must have gone back. You must have gone back 14 years, Representative Evangelos. my ex-wife ran a small business that I had to do dishes in. I think that's probably what you mean, or feed chickens.
Correct.
And so, no, I did that as long as I had to, but
Thank you.
yeah, thanks.
Thank you, Representative Evangelos. Are there any other committee members who have a question or questions for Judge Dow? Seeing none, Judge Dow, I want to thank you very much for your service to the state of Maine, not just the last 14 years as a district court judge, but all of the work that I know you did in the public service before that time. And I want to thank you for your time today and the thoughtful answers that you provided to the committee members' questions. I do have one question. You mentioned your file with the number of opinions that you've written. How many miles have you racked up driving to all of those courthouses throughout the state of Maine?
That's a good question. I could figure that out. It's a lot of happy miles. And so one of my recurring themes is some people have to wait till they retire to drive around rural Maine and look around, and we get to do it every day, first thing in the morning. And I always have considered it a real pleasure.
Thank you for your dedication. And I would, as Senator Carney recommended, like to acknowledge the members of her extended family that are here today and thank them for attending. Obviously, they care a lot about you, and apparently your father is okay with you being a lawyer and now a judge. But we would like to formally recognize them and give them a virtual round of applause for being here and supporting one of their favorite family members.
Thank you.
And thank you. We will now move on to other folks wishing to testify, and I will now take comments from persons attending this hearing who wish to speak for or against this nomination. Anyone who has a written statement but who does not wish to speak should have submitted that statement with the committee clerk prior to today's hearing. All such statements shall contain the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee upon his request prior to the committee's vote, and the nominee will have an opportunity to respond to the written comment. Those who wish to speak in person registered with the committee clerk prior to the start of today's hearing and will be called upon by me, at which time they will be promoted to panelist status in our electronic format and can then be seen and heard. When it is your turn to speak, please observe the following. State your name and place of residence prior to presenting your testimony. Only comments concerning the suitability of this particular nominee for this particular position will be considered in order. All other comments will be considered out of order. After you are done speaking and there are no more questions from the members of the committee, you will be returned to attendee status and the next person will be called. I'm now going to begin to call on people based on a list that I was provided by our wonderful committee clerk, Supi Panett. And the first person I have on my list is Senator Scott Searway. Senator Searway.
Trying to get the view. I guess I don't have a picture of me in there.
Well, we see your name and we hear you loud and clearly. So
okay.
Welcome, Senator.
Well, thank you and good afternoon. Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. I am State Senator Scott Searway, and I represent Senate District 16, which includes Albion, Benton, Clinton, Fairfield, Unity Township, Waterville, and Winslow. I am pleased to provide testimony in the support of the governor's nomination of the Honorable Charles A. Dow of Winthrop for reappointment as District Court Judge. I am testifying in support of his reappointment not just as a state senator, but also as a private citizen who worked with him as a judicial marshal, expressing the respect that I developed for him over the years as I experienced his demeanor and methods in the courtroom. Just for the record, the judicial marshals noticed that Judge Dow has a weakness for Reese's Fast Break, something he looked forward to at the end of the long day's work in the courtroom. His first day in Kennebec County was the Waterville District Court, and it was Criminal Violations Day. The normal count of cases for that day was above 120. At the end of the day, Judge Dow knew he was in the place for him. Judge Dow always ensures his staff safe and secure. When it is time to work or take a break, it is a team function. The team's success for productivity and satisfaction has been his goal. He is down to earth. He has an open door policy with a great attitude. And Judge Dow was an English major, so he has always been particular about the way his hearings are presented and judgments are written. Being bilingual in English and French has been beneficial, particularly during his time serving the Waterville area. Stepping into the courtroom for the first time can be confusing, and people may be bewildered with the paperwork involved. Judge Dow has made it a priority to help people understand what is going on in the courtroom so that they are comfortable with the process and reason behind why things are done a certain way. For example, on PFA, Protection from Abuse Day, most people do not have a lawyer. And so Judge Dow takes the time to explain the hearing process and make very clear what no contact means. He will hold the defendant accountable and responsible for his or her actions. Judge Dow is also fair with a common sense method to come up with judgments. If he has concerns about what to do, he will step off the bench and check the law statutes, and if needed, check with other judges prior to making a ruling. Many times I saw Judge Dow ask to record with his ink pen with earbuds hooked to it on his desk, and he would ask if anyone would have any objections, if it could be recorded. He would do this so he would not miss anything if anyone said they did or did not say something. This method helped to clarify many issues that could have been contested. I've reached out to several judicial marshals, and they all had nothing but highest praise and respect for Judge Dow. He is honest, hardworking, respectful, time spent with interns, and is just a great representative for the laws and conduct of Maine's judicial branch. I am pleased to give my highest recommendation for the Honorable Judge Charles A. Dow to be reappointed for the district court judge position. If there's any questions, I'd be glad to answer.
Thank you very much, Senator Seaway, for taking the time to discuss Judge Dow's renomination with us today. Very much appreciated. Are there questions from any members of the committee for Senator Seaway? Looks like you're being let off easy, sir. I will now move on. Again, thank you very much for taking the time to come and speak to us today.
Thank you.
I will now turn to Jason Jabber. Is Mr. Jabbar with us?
Can you hear me now?
Yes, I can. We can.
Thank you.
Thank you.
Senator Carney, Representative Harnett, members of the Joint Standing Committee on Judiciary. My name is Jason Jabber. I live in Yarmouth, and I'm a practicing trial lawyer with offices in Waterville and Portland. I'm proud to speak in support of the reappointment of Judge Dow to the Maine District Court today. When Judge Dow was first nominated to the bench in 2007, I was a lawyer with 6 years of experience. Much of my practice had been in Waterville District Court, where I handled criminal, protection from abuse, and family matters. I had the privilege of trying many cases before now Federal Magistrate Nivison, who occupied the bench at Waterville District Court until 2007, when Judge Dow was nominated to fill that seat. In replacing Judge Nivison, Judge Dow had enormous shoes to fill. I was skeptical, considering that I saw Judge Nivison as a Jedi master of sorts, and we were going to a little-known Judge Dow who possessed, in comparison to Judge Nivison, little experience. Since that time, I've appeared before Judge Dow too many times to count, mostly during his first term, when most of my practice was in district court and he occupied the bench there at Waterville District Court. My experience before him included several contested hearings, some that were complex, emotional, and challenging to preside over. With his enthusiastic, fair-minded, and compassionate approach, I'm proud to say that Judge Dow continued the tradition of excellence that Judge Nivison had established before him. And he did it with many of the same qualities that made Judge Nivison exceptional. As I was preparing for my remarks today, I was thinking about what qualities Judge Dow had and what made him an exceptional judge. And I thought about my coaches growing up, because I played a lot of sports and my coaches had a profound impact on me. The best coaches that I had were both liked and respected, and it was always a delicate balance. And I think parallels can be drawn to judges, because the best judges are compassionate, understanding, and cordial enough to be liked, but also firm and decisive enough to be respected. And Judge Dow has fit into that category. I also found it interesting that the comments made by Mr. Reed and Mr. Hobson at the outset of this hearing echoed the comments that I was preparing. Mr. Reed said that he's been smart, insightful, calm, and an excellent communicator. And that is exactly in line with my experience with Judge Dow. Mr. Hobson said he's empathetic on the one hand, and yet he lays down the law on the other hand. And Judge Dow has really been able to reach that balance where he's liked and respected at the same time. And that's really what has made him an exceptional judge. A few other things in particular that have impressed me about Judge Dow. Number one, the way he handles the crowded courtroom. Many of the people who appear before him are anxious and going through some sort of a life crisis. People in protection from abuse matters, family matters, criminal matters. And Judge Dow spends time to explain things in a way that helps put people at ease. It's both the way he says it, the time he takes to explain things, and his tone. He really has a way about him where he's empathetic, where he's compassionate, and he puts people at ease who are before him. And at the same time, he commands respect from those who will disrupt his courtroom, and I've seen him do that. So, it goes to the balance that he's able to strike. Another thing that has impressed me about him is how conscientious he is about reaching a fair decision. As I said, I've appeared before him in many contested hearings. Moving forward, that's unlikely to happen because my practice is now in Superior Court. But these have been complex family matter hearings, protection from abuse hearings, and less so criminal matters. But I found that he takes copious notes, and his attention to detail is reflected in the decisions he issues. I also recall the magic pen that Senator Searway talked about, that also speaks to Judge Dow always being on the front end of technology and being willing to adapt to technological advances. And that was one that was early on. And we said, what's this pen? What is this magic pen? Well, he was able to, when he makes notes, he was able to notate a point where he wanted to go listen to the transcript, and he had like a button on his pen that would take him back to that spot. And I think it really helped him to find the points of the hearing that were important, the evidence that was important. And he was adept at analyzing the evidence and applying it to the applicable law and reaching a fair decision. He didn't always agree with my position, but I could always count on him rendering a fair decision, and knew that he was doing his best to get it right. And he did he's always done a very good job at that, and he's highly respected for it. The last thing that I'll talk about is how he genuinely cares about the people who appear before him. And that's clear in the way he presides over his courtroom. He's cordial to both individuals and lawyers. Justice Silver, who was on the law court recently, now retired, he was speaking to a group that I'm the Maine Trial Lawyers Association, about the need for trial lawyers to become judges. And one of the things he said is the importance of not being arrogant before you become a judge, because he said an ounce of arrogance will turn into a pound when the robes go on. And with Judge Dow, you have all the humility you could possibly want in a judge, and none of the arrogance that we don't want in a judge. And he proves, as Judge Nivison did, that it's not necessary to be arrogant to command respect from behind the bench. Lawyers and people that appear before him certainly appreciate that. And so, in closing, in my experience, Judge Dow has been an exceptional judge and an excellent ambassador for the courts. And I enthusiastically support his renomination to the Maine District Court.
Thank you very much, Mr. Jabber, and the committee certainly appreciates you taking the time to provide comments today in support of the nominee. Are there any members of the committee that have a question for Mr. Jabber? Seeing none, I will move on to Danielle Carson. And the little delay in between people testifying has to do with moving them around electronically.
Good afternoon.
Good afternoon, Ms. Carson. How are you?
Thank you. I'm well. Senator Carney, Representative Harnett, ladies and gentlemen of the Joint Standing Committee on Judiciary, my name is Danielle Carson, and I am an attorney operating out of Leeds, Maine. My practice has always had a primary focus on family law, child protective, juvenile, and guardian ad litem work. But presently I'm working solely as a guardian ad litem in Kennebec, Androscoggin, Oxford, and Franklin counties. I'm here today to discuss with you my support of the reconfirmation of Judge Charles Dow to the Maine District Court bench. I first practiced before Judge Dow in the Lewiston District Court in Courtroom 5, where protective custody cases are heard. Word around the courthouse hallways was that Judge Dow was a bit of a force to be reckoned with, a judge with a keen eye for detail, and as impatient with injustice as he is with professional incompetence. So his reputation made me a little nervous. But fresh in my career, I had been commissioned as a pro bono guardian ad litem in a case involving a pro se mom and a dad represented by a student attorney from the Cumberland Legal Aid Clinic. This was the first time that I testified before Judge Dow on the stand in my capacity as a guardian ad litem. It was also this case which first revealed to me a repeating theme in Judge Dow's conduction of his courtroom and his cases. This was a judge who showed an appropriate amount of grace to an unrepresented mother while still holding her accountable to the rules of civil procedure. This was a judge who saw a father with a past that the evidence demonstrated did not define his present or his future, and children who both wanted and needed to see their dad. This was a judge who, within the authority of Title 19A, elevated the children's best interest over all else and joined me in my recommendation of an out-of-the-box kind of solution that may not have worked in 100 other cases, but it worked in this one. Time and time again, Judge Dow has exhibited the same approach to the many child protective, juvenile, and family law cases that I've presented to him. He's demonstrated this through creative chamber conference brainstorming sessions, a patient and listening ear on the bench, firm expectations of both the parties and the professionals in his courtroom, and finding just that right balance between parents' constitutional rights and the children's best interest. Representative Evangelos, to speak to the question you asked Judge Dow, I've personally seen Judge Dow stick to his guns on issues which he strongly believes in, even when they are unpopular in his courtroom. The threat of appeal or being overturned on appeal does not discourage Judge Dow from doing what the Constitution requires of him. I will never forget the judicial review before Judge Dow for a case with a set of twins separated 4 years prior, still lingering post termination of their parents' rights in foster care. They were in non-long-term separated foster placements without any adoption prospects on the horizon. I informed Judge Dow that day that because of a creative disclosure order he had crafted and issued for me to separately from the department help find a family to adopt these kiddos, that a family had in fact been located and these children were finally going to be reunited. This was no ordinary status quo JR, quickly expedited by onto the next one. Judge Dow's compassion and relief for those children was palpable throughout the entire courtroom. In my short 5 years of practice with Judge Dow, he and I have already weathered the trenches of this and many other cases which have ended with positive long-term outcomes for the children that we serve. And I know this to be true because I remain connected with many of these children long after their cases come to their legal conclusion. Judge Dow obtains justice for the children and the families that present themselves to him. Not cookie cutter justice, but the kind that takes each and every child, family, and their individual circumstances into consideration when crafting real solutions for constructive results. Representative Reckitt, this, I would argue, is some of the most important work that Judge Dow does. My practice is and always has been child-centric. This is because I too was a child of the protective custody system. My mission is to provide a voice for the children who otherwise do not have one, much like my own guardian ad litem did for me. So I'm uniquely qualified to stand here today and tell you the difference that it makes for the children of these cases to have a judge on the bench who can properly balance compassion with rationality, firmness with grace, perspective with fact, and above all else can remain focused on sustainable solutions and the absolute justice that children deserve. Judge Dow is that kind of judge. As such, I individually and on behalf of some of Maine's most vulnerable children and families respectfully request that this committee vote for Judge Charles Dow to be reconfirmed to the Maine District Court bench for a third term. Thank you for your time.
Thank you very much, Ms. Carlson, and the committee thanks you for taking the time to testify today and to share some deeply personal testimony. That's very much appreciated. Are there any questions from members of the committee for Ms. Carson? Seeing none, I will move on to our next presenter, who is James Cohen from the Maine State Bar Association. Welcome, Mr. Cohen.
Thank you, Mr. Chair and members of the committee. My name is Jim Cohen. I reside in Portland, Maine, and I serve as the legislative counsel for the Maine State Bar Association. It is our pleasure and my personal pleasure to appear here today in support of the renomination of Judge Charles Dow to the district court. As this committee knows, and for the benefit of the general public, the Maine State Bar Association every year evaluates judges in the trial court who are in their 6th year of their 7-year term. We did the same thing with Judge Dow, and we're pleased to say that the feedback we received was very positive, not surprisingly. And I will share some of the feedback that we received, and that forms the basis of why the nomination of Judge Dow. Comments included that he is intelligent, thoughtful, and very fair. He is described as decisive yet courteous, excellent in explaining his decisions, especially to pro se litigants. He is also commended for his strong management of the courtroom and docket while still making all parties feel like they were heard and their questions answered. And it is for these reasons that the State Bar Association is pleased to support Judge Dow. I can also say on a personal level, I've known Judge Dow for many years, and although I have not seen him in person for recent years, I have had the pleasure of seeing Megan Burbank on a regular basis. But I know Judge Dow to personally be exactly what the commentary I described above says. Judge Dow and I also had the good sense to work with Steve Rowe over many years. After Steve was termed out from the Attorney General's office, I had the pleasure of working with Steve at Viral Dana. So it is my great pleasure to speak in favor of Judge Dow's nomination here today. Thank you, Mr. Chair.
Thank you, Mr. Cohen, and thank you for taking the time to address the committee today. Are there any members of the committee that would like to pose a question to Mr. Cohen? Seeing none, thank you again. And I will now move on to the last speaker on my list, although I will check if there are others who had not signed up early. And that is Chris Lewis on behalf of the Maine trial lawyers. Mr. Lewis.
Thank you very much. Senator Carney, Representative Harnett, and the Judiciary Committee. My name is Chris Lewis, and again, I'm the president of the Maine Trial Lawyers Association. On behalf of my association, I'm here to speak in support of Honorable Charles Dow's renomination to the Maine District Court. Before I begin, I'd like to outline the MTLA procedures in determining today's testimony. Before today's hearing, we surveyed our membership regarding the nominee's experience, temperament, skill, and ethics. Our executive committee reviews these results and adds their experiences to the process. The testimony today is meant to reflect a consensus of that entire process. Our members rated Judge Dow highly for his skill and judicial temperament. Participants in the survey called him an excellent judge who genuinely cares about the people who appear before him. He takes seriously the decisions he makes, and that shows when he is presiding. They also noted his, quote, great demeanor and called him an excellent judge once again. Our executive committee concurs in these assessments. I personally will say that I have appeared before Judge Dow while volunteering in protection from abuse cases in Lewiston District Court, which can be very difficult, very emotional. I have found Judge Dow to be fair but firm. He goes above and beyond explaining the process to unrepresented parties. He's patient, but he is absolutely does not suffer fools. That's my own term there. Judge Dow is highly rated in our survey, and it's in the last time he was up for hearing before this committee, and his current results are equally as high. The MTLA's executive committee noted his leadership in the judicial system, especially during COVID, as COVID tests our court's ability to function efficiently. Judge Dow chaired the remote video court proceedings group, co-chaired the Unified Criminal Docket implementation in Kennebec County, and served on the Maine Commission for Media and Courts. Our executive committee appreciates his efforts to move the judicial system forward during these difficult times. Based upon his excellent evaluations as a judge and his exemplary leadership in the court system, the Maine Trial Lawyers Association is proud to endorse his renomination to the Maine District Court. We believe his continued service will bring honor to the bench and the people of Maine. Thank you for this opportunity to testify, and I am happy to answer any questions you may have.
Thank you very much, Mr. Lewis. And the committee always appreciates hearing from you and the membership of the Maine Trial Lawyers Association as we consider these important nominations and renominations. Are there any members of the committee that have a question for Mr. Lewis? Seeing none, thank you again for taking the time out of your day, and I bet we might be seeing you later in the day. I'm not sure.
Thank you very much.
Are there any persons on this call in the electronic format who wish to be heard on the nomination of the Honorable Charles A. Dow of Winthrop for reappointment as a district court judge? I will ask the committee clerk. I am not seeing any hands raised. Is that correct, Supi?
That is correct.
Thank you. All public comments having been taken, the committee will now proceed as follows. We will review any additional written comments on the nomination that have been received by the committee. Are there any such documents?
No, there are not.
Thank you. We will then vote on the nomination and notify the President of the Senate pursuant to Title III MRSA Section 157 and the joint rules. The vote must be taken within 40 days from the date of the governor's written notice, and we are within that time frame. The hearing by the Joint Standing Committee on Judiciary for the Honorable Charles A. Dow of Winthrop for reappointment as a district court judge is now closed. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. At this time, I will ask whether any member present objects to proceeding to taking the vote immediately. Seeing none, we will move on to the voting process. The pending question before the committee is that the Joint Standing Committee on Judiciary recommend to the Senate of the 130th Maine Legislature that the nomination of the Honorable Charles A. Dow of Winthrop for reappointment as a district court judge be confirmed. In accordance with 3 MRSA Chapter 6, Section 157, and the joint rules of the 130th Maine Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending confirmation. A vote of no will be against the motion to recommend confirmation. Is the committee ready for the question? I will ask the committee clerk to call the roll.
Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Downs.
Yes.
Representative Downs votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Senator Sanborn. Senator Sanborn is absent. Senator Kime. Senator Kime is absent. Representative Hagan. Representative Hagan is absent. 11 members voting yes.
11 members of the committee having voted in the affirmative and no members voting in the negative, it is the vote of the Joint Standing Committee on Judiciary that the nomination of the Honorable Charles A. Dow of Winthrop for reappointment as a district court judge be confirmed. Congratulations, Judge Dow.
Thank you
This
so
is
much.
the, confirmation hearings are among my favorite things that this committee does, and in more normal times, we would be getting up from our seats and coming over to personally congratulate you and perhaps meet many of those family members that you introduced us to at the beginning of this hearing. But we can't do that today. What we can do is express our deep appreciation for your work and offer our thanks and some somewhat muted virtual applause. Congratulations, Judge.
Thank you very much, and I really appreciate the committee's work and listening to these remarks. It's a little bit like being eulogized every 7 years, but I do appreciate your attention and your positive votes today.
Well, you look very good for somebody being eulogized, so I will give you that. And with that, I will now turn the chair responsibilities over to my co-chair, Senator Carney. Oh, I think we have to take a break until 2 o'clock because we can't start until the appointed hour. So you all have 7 minutes. Go knock yourselves out and be back at 2 o'clock. If you do walk away from your computer, remember to mute your audio and to shut off your video, and see you in a little over 6 minutes.
Good afternoon, Mr. Langner. How are you today?
I'm well, thank you. Good to be here. I'm hopeful it goes as well as just saw the end of Judge Dow's.
Yeah, it's it was nice to hear all of the reflections on his judgeship and his service to the state.
Yeah, he's a good guy. I know Chuck, and he does a good job, and he's a good guy, which the combo is always nice to have together.
We'll get started in just a moment. We're waiting for a few more committee members to return. Committee members, if you are present, could you please turn on your video and then we can get started with our next hearing? Looks like there are a suitable number present, so we'll begin. Good afternoon, everyone. This is a public hearing of the Joint Standing Committee on the Judiciary for the purpose of considering the nomination by the Governor of the Honorable Rob A. Langner of Fort Fairfield for appointment as a district court judge. The meeting today is being conducted electronically. Under the laws and the joint rules of the legislature, this committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by a majority vote of the committee members present and voting. As chairs of the committee, we will then send written notice of the committee's recommendations to the President of the Senate. The committee will hear testimony from and have an opportunity to question the governor or her representatives, the nominee, and any other persons interested who wish to speak for or against the nomination. Before we get started, I want to share some information related to the fact that this meeting is being conducted using an electronic format. This meeting is currently being live streamed on the committee's YouTube channel. This means that anyone who is a participant in the meeting via Zoom can be seen and also heard if their microphone is unmuted. People testifying cannot be seen or heard until they are called upon to speak. This meeting will be recorded and is available to view on the committee's YouTube channel soon after the meeting has concluded. We'll begin with the motion to confirm. Pursuant to Title III, Section 157 of the Maine statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes Representative Lois Reckitt for the purpose of making such a motion.
Thank you, Madam Chair. I move that the Joint Standing Committee on Judiciary recommend confirmation of the Honorable Rob A. Langner of Fort Fairfield for appointment as a district court judge.
Thank you. And Representative Babbage, did you have a second?
Thank you, Madam Chair. I second the nomination of the Honorable Rob Langner to be a district court judge.
Thank you. The statutory requirements for this position are posted on the committee's webpage. The chair now recognizes Jerry Reed for the purpose of making a statement concerning this nomination.
Thank you. Good afternoon, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. I'm Jerry Reed, legal counsel to the governor, here today to present Rob A. Langner as governor's nominee for appointment to the Maine District Court. Rob Langner has been a family law magistrate in the family division of the Maine District Court for 19 years. making him the longest tenured magistrate in the system. He served as an assistant district attorney in Aroostook County for 5 years, from 1997 to 2002, and began his legal career working several years in private practice in Fort Fairfield. Magistrate Langner graduated from Fitchburg State University in Fitchburg, Massachusetts, with a degree in English, and earned his law degree from Suffolk University in Boston. He's been an active member of his community as a coach of numerous youth sports teams for more than 25 years, including at the high school level, has served as a commissioner of the Fort Fairfield Housing Authority and on the board of trustees of the Loring Development Authority in Limestone. Magistrate Langner's career represents ideal preparation for a position on the district court. He has had the experience of a private practitioner representing clients who need a lawyer's help navigating the legal system to resolve high stakes issues. He developed extensive trial experience and knowledge of the criminal law while serving as an assistant district attorney. And he is a bona fide expert in family law from his almost 2 decades of work as a family law magistrate. His legal career and his record of service as a volunteer have made him a pillar of his community. On behalf of the governor, I respectfully request your support for the appointment of Rob A. Langner to the Maine District Court, and will be pleased to answer any questions the committee may have of me. Thank you.
Thank you, Mr. Reed. Committee members, does anybody have a question they'd like to ask Mr. Reed? I'm not seeing any raised hands. Thank you very much, Mr. Reed. Next, we'll recognize John Hobson from the Governor's Nominating Committee. You may proceed, Mr. Hobson.
Thank you very much. Senator Carney, Representative Hartnett, members of the Joint Standing Committee on the Judiciary. My name is John Hobson. I am chair of Governor Mills's Judicial Selection Committee, and on behalf of the Selection Committee, requests that this committee act favorably on the nomination of Mr. Langner. Mr. Langner, as Mr. Reed just kind of detailed, has a long history in the area of law that the district court deals with extensively, which is family law. But not only has he had an extensive history, he has a very well thought of history. When, as part of the selection process, interviews were done and we solicited information and input from the bar that practices in the area that Mr. Langner is the family law magistrate. There were effusive in their praise of Mr. Langner, not only the carefulness with which he basically administered the issues that were in front of him, but also the efficiency with which he did so, and his willingness to basically, candidly, travel long ways to have a hearing, sometimes on short notice, to get something resolved. It is kind of the old adage, which justice delayed is justice denied. It really applies in district court. It has a vast amount of work, and not only does the work have to be carefully done, it has to be done efficiently. And Mr. Langner, in his tenure as the longest serving family law magistrate, has certainly proved that he can do it. As Mr. Reed also detailed, he also brings to this job some background in criminal laws, having been an assistant district attorney, again, in Maine's northernmost county, as well as a brief time as a private practitioner in that county. And again, this is important because if you're in a position of a district court judge, it's important to have a sense of the community. It's important to have a sense of the individuals in the community they come from who are going to appear in front of you. And Mr. Langner appears in that capacity as a family law magistrate. In his other capacities I've just mentioned, he clearly has the history and background to be able to hit the ground running on this job, and he's shown that he has a commitment to public service. So on behalf of the Judicial Selection Committee, I request that this committee act favorably on the nomination of Mr. Langner.
Thank you very much, Mr. Hobson. Do any members of the committee have questions for Mr. Hobson? Not seeing any hands raised. I actually have a question for you, Mr. Hobson, which is, you spoke of the praise for Magistrate Langner's work. Could you share with us one or two of the comments that you received?
Sure. One of the comments, and he may detail this when he's giving his comments. The comments were that he was always willing to put in the time necessary in hearings to be able to get the issue thoroughly aired and resolved, and that his decisions would come out timely. It's not a small point in district court, and this was basically universally among the practitioners, is that they could count on Mr. Langner delivering a decision in a timely manner, so that they didn't have clients who kept coming to them saying, when is the decision going to be issued? When are we going to get a decision? And so that he was able to get things done, but done well. And he brings 19 years experience to the job, and he's candidly also well liked among the bar. So that's kind of a synopsis of those, but those are the two traits that stood out from those comments.
Thank you. That was very helpful. Do other committee members have questions that they would like to ask Mr. Hobson? I'm not seeing any. Thank you very much, Mr. Hobson. The chair now recognizes the Honorable Rob A. Langner for the purpose of making a statement concerning this nomination.
Thank you, Senator Carney. Thank you, Representative Harnett, members of the Standing Committee on the Judiciary, and all others present. My name is Rob Langner. I know that's a tough last name at times. It took me a long time to get used to it myself. I live in Port Fairfield with my wife, Tricia, my daughter, Olivia, and depending on the time of year and their need for financial assistance, my two college-attending sons, Malcolm and Colby. I appear before you honestly honored and humbled to seek your confirmation of my nomination as a district court judge. I know you have before you my resume and my answers to the legislative questions concerning my possible appointment. I'll try not to rehash too much of what's contained in those documents. Instead, I'll attempt to supplement those materials by giving you a bit of a peek into some other aspects of my life. I must start off with an admission. I was not born in Maine. Now, that's not generally a bad thing, except to all those native Mainers in Fort Fairfield. To them, I will always be from away. Now, mind you, I married a Fort Fairfield girl in Fort Fairfield, and I've lived there for nearly 27 years. I've raised all three of my kids there. I've been on numerous committees, commissions, boards, and other events in town. Yet I will always be from away, and I accept that. I was born and grew up in Minnesota, which, when you think about it, it's kind of like Maine without the ocean. I was the fifth of 6 children. We didn't have much growing up, but my father did work, and he worked hard, and he instilled in us the belief that hard work pays off. I've lived with that belief my whole life. I began working on a farm when I was 12. I worked every summer and in the fall after school. I started out at $1.25 an hour. Since then, I've always had a job. I recently talked with my son about the various jobs I've had over the years. Frankly, he was astounded. I've done everything from construction to demolition. I've made Big Macs, BLTs, and Bloody Marys. I've sold suits, cleaned offices, landscaped lawns, loaded trucks, taught school, and inspected potatoes. I've managed a bar, I've managed a hotel, and I've managed people. I'll say straight out, the worst job I ever had was as a recruiter of software engineers. It was much worse than raking rocks and digging holes, and I did that too. Most of these jobs I did so I could earn money for college. I was committed to get a degree, but we had little money to make that happen, so I worked. I was in fact the first in my family to attend college. Neither of my parents finished high school, but I knew that higher education and continuance of hard work would take me farther, and I believe it has. I worked all through college and law school, and I paid for it as I attended. Now, my kids know they have it easier, and I know they appreciate that. My wife and I got married in 1994. At that time, I was a recent law school graduate, and we were living in New Hampshire, but not quite sure where we wanted to end up. I knew New Hampshire wasn't where I wanted to be, so we considered our options. My wife was from Fort Fairfield. We had the pull of that small town Maine, and that was enough to draw us to Fort. We've been there ever since. I was lucky enough to become associated with a seasoned, established, and well-respected attorney, Larry Ayob. One of the many things I learned from Larry was to treat everyone with respect. Whether a potato farmer, a banker, a teacher, or an unemployed criminal defendant, all people whom I represented at one point or another, everyone deserved equal respect. I adhere to that advice to this day. A couple of years into my private practice in Fort Fairfield, Neil Adams, who was the DA at the time, invited me to come speak with him. He informed me he was impressed with what he'd seen from me and offered me a job as an assistant district attorney. And whether that was true or not, or whether he just needed to fill a position, I'm not sure. Anyway, I was always interested in public service, so I took him up on his offer. I'll tell you, there wasn't much training provided. I was pretty sure I prosecuted a jury trial during my first few weeks as an assistant DA. And for whatever reason, I had pretty good success in my first several jury trials. I think the first 4 or 5 trials I had, we were able to generate a guilty verdict. Then I prosecuted my first domestic assault case. The defendant in the case was an airline pilot. He was confident and he was poised. The victim was his wife. She was shy, soft-spoken, and hesitant. The defendant was represented by attorney John McElwee. Now, if you know John, he's smooth and polished, and he's always downright likable. John suggested I dismiss the case. I didn't, and we went to trial. My star witness was the wife. Long story short, she changed her story on the stand. I was caught off guard, and the defendant was found not guilty. Now, I dropped the ball, and I knew it. Out of frustration, I did some research on domestic violence and realized how little I did know. I asked Neil if I could attend trainings to expand my understanding, and he was a bit prickly about spending the state's money or the county's money, but in this circumstance, I think he saw the value. Soon thereafter, we established a coalition of stakeholders. These were representatives from the local domestic violence project, a couple of law enforcement officers, and myself to train other prosecutors and law enforcement officers. In fact, my best memories from my stint as a prosecutor were those times I worked with that coalition to train law enforcement officers and prosecutors about domestic violence, the impact on families, our communities, and the many levels it had on us personally. I found that very rewarding. About 5 years into my stint as a prosecutor, one of the magistrates who traveled up to Aroostook County indicated that there was going to be a position opening. That intrigued me. So at her suggestion, I applied for the role. I'm now, as you've heard, nearing my 19th year as a magistrate. And it wasn't just Aroostook County. I found out later it included Washington County and northern Penobscot County. I spent a lot of times on those rural back roads in northern Maine. Even though I've been at this job a long time, I don't believe I've stagnated. Every day brings different people, different situations, and different opportunities to help. I enjoy what I do. However, I do look forward to the possibility of a new prospect. A district court judge deals with a wider range of issues and much more varied challenges. If I am lucky enough to be confirmed through this process, I know I am ready to address those issues and face those challenges. In other words, I'm willing to put in the hard work. Now, in preparation for this hearing, I met with the clerks in Holton and Presque Isle to get a sense of the different case types and the time that the judge allots to each. The following breakdown I'm going to give you isn't scientific, not even science-based or evidence-based. It's just mostly based on anecdote, gut feeling, and a loose review of a calendar. Roughly 40% of judge time in Holton and Presque Isle is spent on criminal matters, about 25% on family matters, 25% on child protective custody cases, and the remaining 10% just the sort of random various civil actions, PFAs, FE&Ds, small claims, things like that. Looking at that breakdown, as you can surmise, I'm very comfortable in dealing with family matters. There's often an overlap between family matters and PC cases and PFA matters as well. So I expect a short learning curve to make that leap, I guess. My background, as you've heard, includes much criminal work, but it's been a number of years since I've dealt with a criminal case, so I need a little bit of time to come up to speed, but I think I can do so in short order. The remaining civil cases will require me to learn and relearn the law in those areas. I'm confident I can do so. I'm a pretty quick study, and as I previously indicated, I'm not afraid of putting in the hard work. One thing I've learned from my many years involved in the court system is that everyone has a story to tell. And it's most important to them that they be given a chance to tell that story. In other words, people just want to be heard. In every conference I hold, in every hearing I preside over, I make sure the litigants are given that chance. At the chagrin of some of the attorneys that appear in front of me, and sometimes to my own detriment, I will always ask the parties if they have any questions, any comments, or anything to add. I read somewhere that one of the biggest complaints from people who have been through any court process is that they didn't get a chance to be heard. I make sure that's not a concern where I sit. Now, as you probably know, district court is not a happy place. Nearly every court event results in some type of loss. Loss of liberty, loss of funds, loss of children, loss of a relationship, loss of property, and so on. The court is dealing with people who are oftentimes suffering through some of the most emotionally impactful moments in their lives. I think the least we can do is give them a chance to be heard, and more importantly, to actually listen. With that sober thought, I am prepared to listen to any questions that you may have, and I will do the best I can to answer them. Thank you.
Thank you very much. The chair will ask if any members of the committee have questions for the nominee. Please raise your electronic hand. Representative Reckitt, you may proceed.
Hi, welcome.
Thank you.
Honorable Lang, I murdered your name. And
that's fine. Like I said, it took me many years, so go ahead.
Well, people murder mine all the time. So it's like you get to say, you know, you have to have some little kudo thing. I always say Reckitt is like, smash it without the W, you know. It's like, so anyway, I was thinking as you were speaking about your broad range of experience in the northern part of the state. And I was thinking back to two of the, I think two times I went to Russia with the Rule of Law Commission and a bunch of judges, one of whom was a judge from Aroostook County, retired judge whose name has flown out of my head. And the other was David Kennedy, who was, I think at that time, either a judge or a magistrate, I can't remember. But it caused me to think of this question. Have you had any interaction, I think internationally, but I'm thinking Canada. I mean, have you observed or paid attention to, I'm sure, what happens in the Canadian courts and whether or not there's anything to be learned from how they operate or what they rule on that would be helpful to judges in Maine?
Thank you for the question. As you can imagine, living in the border county that I live in, Fort Kent, we have a lot of folks who cross the line, well, used to before the whole COVID issue. Same thing in the town I live in, Fort Fairfield is a border town as well. Holton, same situation where it borders Woodland, Woodstock in New Brunswick. So we do get some overlap between the American court system and the Canadian court system. I can't tell you I've ever had a chance to sort of line them side by side and make a comparison contrast. I do know that we've had communications. I've had communications with judicial officers in Canada when we may have an issue concerning a child custody issue with, again, I don't want to bore you with legal terms, but a home state issue, whether the matter should be brought in the American court or the Canadian court. And they're always gracious to a fault. Always happy to have a conversation with another judicial officer. And I find that the same is true in other states as well. I can only tell you that I have not, and it's amazing when you bring it up, that I've not had any dealings myself to the point where I've been able to pick up on any little bits and pieces or nuggets of information that have helped me or been able to share, other than those few occasions where we've got maybe a litigant who has either a dual citizenship or has maybe some government benefits they're receiving in Canada that may be an overlap with some of the state benefits. But I wish I could give you some insight into what they do better or worse than us, but I don't have that to share. I'm sorry.
Thank you.
You're welcome.
Representative Babbage.
Yes, thank you very much, Madam Chair, and welcome, Mr. Langner. I appreciate your comments very much. In looking over your background, I was looking for the reason that you left Massachusetts, New Hampshire, and got to Aroostook County, and I thought it might be a relationship, it might be a job, and I didn't know if it would be the assistant DA position or maybe the Little League coach was part of that. But you answered all of that very well, I thought, and I particularly appreciated your comments with regard to your work with domestic violence and all of that. You have traveled a great deal of the state in what you've done as a family magistrate over such a long period of time. You know, geographically, when you go from courthouse to courthouse, I wondered if you had any reflections on, oh, I don't know, the physical plant and that impact on the administration of justice, as opposed to, and also, well, just very basically the what you may have observed as to the state of the consistency of justice applied in those courts.
Sure. In response to, sorry, I didn't mean to cut you off. In response to geography, we have courts that are as centrally located as I suppose they can be for now. Once we go to maybe more of a digital world all the way around, it'll be hopefully better access, more readily accessible to folks. But for instance, you've got a courthouse in Calais and a courthouse in Holton. There's 2.5 hours, let's say 2 hours between those locations, and there are a whole lot of people. From my perspective, a whole lot of people in between. From your perspective, and maybe some more urban areas, not a whole lot of people. But there are people who live an hour plus from a courthouse, from the physical courthouse. You've got people in Allagash who their court is the Fort Kent court. That's an hour. You've got people on the outskirts of some of these other communities who have a long drive, and not everybody drives, and not everybody has access to a reliable vehicle. So you're right. There are some problems out there that exist because of the rural nature of Aroostook County and Washington County, and to some extent, I suppose, northern Penobscot County. I know the system is set up to encourage and to facilitate equal access to all. And I think this push towards electronic and digital filings and moving in the direction of less requirement of people actually attending the courthouse will ease some of that strain. But that being said, some of these same people may have issues with regard to reliable internet or the funds necessary to, I know this may be a hot button issue, but some of the documents and some of the other filings that are out there to access once we get up and running, I know that's a work in progress. So I think the judicial branch, and I myself am aware of some of those limitations, and I'm hopeful that we can attend to those. We've not been able to fix the geography problem. We certainly do make accommodations in allowing folks to call in for some of these things, and certainly with the COVID issues, that is what we're doing anyway, or participate by Zoom. But because of some of the limitations on these rural areas with regard to access to Wi-Fi or internet, there's still going to be some limitations that we need to deal with as a judicial branch, and probably you folks as well as the legislative branch.
Thank you, Representative Babbage. Representative Moriarty, did you have a question?
I did. Mr. Langer, many people, I think, probably use the term judge and magistrate interchangeably, but there is a difference. And I wonder if you can just explain for us very briefly what your duties were or have been as a magistrate as opposed to a judge.
Will do, certainly. Without a doubt, there's a difference between the two. A magistrate is authorized to address only family matters or matters that involve children. And there's an overlap with protection from abuse cases. But our role is really to facilitate access to family court and the litigants, whether they have attorneys or not. Our role is to explain things, offer them options to arbitrate or mediate their differences. We do have the authority to address matters on a contested nature, but in select circumstances. So we will address child support issues, whether it's agreed upon or contested. That is our bailiwick. We can do that without any approval or any additional authority sent our way. We can address initial conferences, set things in motion, if you will, for the rest of the case. There's a pilot project out there that allows magistrates to hear contested hearings involving any family matter topic 3 hours or less. So we've got a little bit of authority. That's, sort of feeling it out to see if that is going to work, only because there's always a bit of a backlog in addressing judge time. And for the most part, any contested matters in family court would go before the judge. But for child support, now we've got a little bit of a leash, I guess, to allow us to attend those 3-hour hearings. And I find that does move the docket more. There were cases where you'd have everything's been resolved except where they exchanged the kids. You know, you got mom living in Aroostook County, dad living in Cumberland County, and they need to meet to exchange the kids, but they can't reach an agreement. Well, in the past, we'd have to set that up in front of the judge for, you know, whatever, a half-hour hearing, whatever. When if we've got the time and they consent to it, the magistrate can deal with it. So that does move along the process quicker for litigants. There are, again, limited issues a magistrate can deal with concerning a protection from abuse case. We can only modify a protection order as it pertains to contact or access to the children. We can't modify anything else. Only a judge can do that. So there are occasions when there may be agreements presented to a magistrate that the magistrate can't deal with it because it steps over the authority of a magistrate, and we have to send that off to a judge. And it makes sense to me. I understand it, and certainly I've been working under that umbrella for a long time. I hope I've answered your question, Representative Moriarty.
Thank you, Representative Moriarty. Did you have a follow-up question? Okay. Representative Babbage, I see that your hand is still raised. Did you have a follow-up question? I'm sorry if I moved on too quickly.
That's fine. Actually, I was just trying to raise it, but it was already there. So thank you for that. Yeah, I just had one. I'm reminded of a judge who, upon retirement, shared that he would oppose greater specialization of the duties of a judge to concentrate, for instance, on child custody cases. And his thinking, I believe, was that it was emotionally, it took a toll. Or he thought it should take a toll, and that should somebody be doing that 24/7 in all assignments, except as an occasional venture, he thought that justice might not be as well served, and also that mental health may not be as well served on the parts of the primary participants. Do you have a comment about that?
I can only talk from my own experience as, you know, what I've done. And of course, you all know what I've done is just family matters for the past almost 19 years. I don't meditate, but there are times when I would drive 3.5 hours from Machias to Fort Fairfield, and I could reflect. There's some time where I could sort of disengage, if you will, from what I've dealt with that day or that week or what have you. I can see the point you raised, Representative Babbage, or the retired judge made, in that if you're only dealing with the same hammer day in and day out, you're going to hit your thumb time and time again. I understand that. However, I think each individual judge, magistrate, or whatever it is you're dealing with has the capacity to, I'll use my term again, disengage. I'm not burnt out. I could continue to do this for another 18 years, I suppose, if that was what was required of me. I have ways to escape from my day life job, which is as a magistrate. My 3 kids took up all my nighttime job. And as you may have picked up on from my paperwork and my statement today, my daughter's a senior. I'm not going to have those 3 kids around. 2 are in college now. My daughter will be there next year. So my wife and I are going to get to know each other again. I think you need to rely upon some of those external opportunities to remove yourself from whatever may appear to be others as the same old, same old. I've never considered it as such. I see the same type of cases in law, but I will confess to you, every case is so different. I don't want to bore you with my day on Monday, but Monday I had 2 matters scheduled in front of me that I'd never seen before. And again, you would think I've seen everything, but I haven't. If you're a baseball fan, you'll see that every week there's a new record set. There's some new milestone reached. It's amazing to me that that can happen after how many years folks have been playing baseball. Well, I find the same to be true with whether you're specializing in family matters or PC cases or criminal matters. But I agree with the judge that I think it's better to have intellectually more opportunities to do more things rather than hone in on one thing. It's great to be a specialist, but I think some folks would benefit from having opportunities to do more than that one thing. And again, I hope I answered your question, Representative Babbage. Thank you.
Thank you, Madam Chair.
Thank you very much. Representative Reckitt?
Yes, I just have a question about a subject that we are considering at this committee and will be for most of the year. And we've been talking about the land claims settlement and the jurisdiction, criminal and civil jurisdiction of the tribes and the state. And my question is, I know that you don't deal with criminal matters in your magistrate role, but you may well in the district court role. And my question is sort of two parts. Have you had significant interaction with the tribal entities in northern Maine such that you have connections there or have understanding of the tribes? But do you have any, what we're trying to figure out and what I'd love your input on is where should the lines be drawn, if anywhere, in the distinction between whether or not native Mainers are going to be in jurisdiction of the Maine courts or tribal courts?
Thank you. As you can expect, as I mentioned with the border counties or border communities with Canada, within the borders of the counties I sit in as well, there are tribal nations, whether it's Micmac or Passamaquoddy or what have you. So there's an overlap there as well, where I've had communications with, whether it's Rebecca Irving, whomever the tribal judge might be, on jurisdictional issues as well. I'm sensitive to the sovereignty of the tribal nations. I'm sensitive to the abuse levied against the Indian nations for the many years, and certainly why we've got the Indian Child Welfare Act that certainly should be adhered to and applied, and everybody should be sensitive to. I'm not aware of specifically what you're asking for with respect to the criminal connection there, only that I believe the tribal nations are sovereigns. I believe that Maine courts have their authority. And I think between the two, level heads can prevail. And again, I'm not sure what it is that you folks need to attend to, but I think that if you get the proper folks together to have that conversation, I think it'll be figured out. And I just wish I had more information to comment more thoroughly, but I just don't. Thanks.
I had a question for you, Magistrate Langner. You spoke a little bit earlier about how you sought out the clerks and some information from them related to the case mix that you'll have if you're confirmed to a district court judgeship. And in the previous nomination, we heard some about the nominee's leadership style. And I was wondering if you could describe for us a little bit more your leadership style, since you'll be moving into a different role relative to the judicial branch.
Certainly. And I'll say from the get-go, judges aren't the bosses of the clerks. The clerks don't answer to the judges. In fact, oftentimes it works the other way around more often than not. They don't control everything, but they've got their finger on the pulse of the bar, of scheduling in their court as well as other courts. So they're certainly a good resource. I find that I think the best way to lead is by example, and to keep the channels of communication open. The clerks I work with, again, I'm going to be working with the same clerks I've worked with forever. Unfortunately, we've got a bit of a turnover here in Presque Isle. We need to figure that out. But I think the best thing we can do is attend to our issues as a team, work together, realizing that we're all working for the same end. Again, I'm just another player on the team. I use sport metaphors all the time, and I apologize. It's just who I am. So I'm not the captain of the team. I'm just another player on the team. We've got to work together to go for the win, which is really equal justice to all and smooth flowing dockets. And again, I hope I answered your question.
You did. Thank you. That was really helpful. And I also just want to express appreciation for what you just referred to and what I think it was Mr. Hobson spoke to about the importance of having a really timely outcome in a judicial proceeding, especially when you're dealing with things like families and the sort of the most significant parts of people's lives. Thank you.
I agree with you. That's an important aspect. And as you've heard Attorney Hobson state, and again, I'm not going to pat myself on the back, but I will bust my arm to get those decisions out as quick as I can, because it does impact families in a big way. And I understand that.
Thank you. Committee members, does anyone else have a question for our nominee this afternoon? Just stepping back to make sure. I don't see any real or virtual hands. Thank you very much, Magistrate Langner, for answering all of our questions this afternoon.
You're welcome. I'm going to mute myself unless I'm called again. Thank you, folks.
The chair will now take comments from persons attending this hearing who wish to speak for or against the nomination. Anyone who has a written statement but who does not wish to speak should have submitted the statement with the committee clerk prior to today's hearing. All such statements shall contain the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee upon his request prior to the committee's vote, and the nominee will have an opportunity to respond to the written comment. At this point, I would check in with our committee clerk, Ms. Panett, and ask if all of the written comments have been provided to the committee members and to the nominee.
They have.
Thank you very much.
Very welcome.
Those who wish to speak in person register with the committee clerk prior to the start of this hearing and will be called upon by the chair, at which time they will be promoted to a panelist status in Zoom and can be seen and heard. When it is your turn to speak, please observe the following. State your name and place of residence prior to presenting your testimony. Only comments concerning the suitability of this particular nominee for this particular position will be considered in order. All other comments will be considered out of order. After you are done speaking and there are no more questions from the members, you'll be returned to attendee status and the next person will be called. The next person on our list to speak in favor of the nominee is Senator Mike Carpenter, who we are very pleased to welcome back to the virtual version of his committee room.
Senator Carney, thank you so much. Representative Barnett, it's always a pleasure to have to deal with the Joint Standing Committee on the Judiciary. Some of my fondest memories over the last few years are in that room that you're all not in, somehow I can see. But I'll be very brief. I appreciate the opportunity to come before the committee, and I apologize that we're not doing this in a live format, so I can bring to you the largesse to which you are expected and to which you are entitled as a returning committee member. I've practiced law in Aroostook County for 35 years, 20 of which Rob Langner, 19 of which Rob Langner has been here as the magistrate. I haven't practiced in the family law in a few years, having limited my private practice the last few years, mostly to guardian ad litem work and criminal and some criminal defense work. But I know Rob Langner, I know who he is, and I've talked to enough people about Rob Langner to feel pretty comfortable in making a recommendation. He's well thought of. He understands the law. He understands the people of Northern Maine. He won't have to do quite as much driving now, just between Pascal and Fulton, two areas that he's extremely familiar with. He's been dealing with many of the same issues, whether it's domestic violence, whether it's substance use, or whatever, in the family law that he will now deal with, not only in the criminal law, but in the child protective area, which does take up, as he indicated, a significant piece of the district court time. I know from talking to the clerks, and this is a real testament to Rob, from talking to the clerks, they have great respect for him. You can't be around 19 years without there being some people who are unhappy. However, I know of none. And I have done some asking around just to make sure that people were comfortable. He's always respectful, not only of the litigants in front of him. I've had recently, I'm literally on a case right now that he appointed me to as a guardian ad litem. And his concern there was that the child in this case be well represented. I think he'll do an outstanding job. When you come into a position like this, the best circumstance is to come in behind somebody who hasn't done such a great job Rob is in a kind of tough spot. He's going to come in behind Judge, now Justice Stephen Nelson, who is dying to get out of the district court. He's been sitting as an acting Superior Court justice now for a year. One of the things you can almost guarantee was that Rob's hearing was the day there would be a snowstorm or some other natural disaster. When he was first nominated by the governor, I don't think he had any gray. I think the grays all come in the number of times that his hearing has been postponed. But seriously, Justice Nelson has done an extraordinary job, and I have no doubt that Rob will do as well. Rob is a good listener. And I think what he said early in his testimony about the necessity or the obligation of a judge to listen to people and to convince them that he or she is listening. I believe Rob possesses that, and I think he'll do a wonderful job as a district court judge, and I'd be more than happy to answer any of your questions.
Thank you very much. Are there any questions for the Honorable Mike Carpenter? I would like to recognize Representative Harnett.
Thank you, Madam Chair. Not so much a question, but just wanted to say hello to my dear friend, Senator Carpenter, and how wonderful it is to see you again, sir. I wished it could be in person, and please know that just because we're in the middle of a pandemic, you will be down here at some point, and you will deliver what you know needs to be delivered to the members of your old committee. But great to see you.
I will deliver. I promise you I will deliver. Representative Barnett, thank you so much. I had surgery 10 days ago, so I'm home sort of recuperating. Today's the first time I've actually put a dress shirt on in weeks. But I hope when the pandemic eases a bit and you folks go back to real life, I would love to come down and visit. Thank you very much.
Representative Evangelos.
Thank you, Madam Chair. Hi, Senator Carpenter.
Hi, Representative Evangelos.
I just wanted to second what Tom said. We miss you dearly here, and you did a fantastic job for us. So I wish the outcome had been different in November, but I better stop there. But anyways, it's really great to see you.
Thank you. It's great to see all you, and in my case, it's great to be seen.
Representative Babbage.
Yeah.
Chris, we're not able to hear you.
I was just going to say the great to be seen comment is right on the mark from Senator Carpenter. And I just want to also pay homage to our former leader and say it is good to see him looking well. So good to see you again. Thank you.
Thank you very much. And Representative Reckitt.
I come on only because if I don't speak, you'll think that I don't miss you, which I do. So I just wanted to be absolutely clear that I did, and I do. And also, how's your dog?
Dog's doing fine, thank you.
All right, great.
Senator Keim.
Following up on Representative Reckitt, I also feel like I must welcome you back, Senator Carpenter. It is good to see you looking so well.
Good. Thank you, Senator Keim. It's good to see you.
I'm sure that if all of the 129th members were still on the committee, they would all be sending you greetings and wishing you well. And I'm also delighted to see you, Senator Carpenter. I hope that you continue to have a speedy recovery.
Thank you.
Representative Babbage, did you have another question, or are you all set? Okay, great.
Thank you.
Well, I think that you are done for now, Senator Carpenter, and we'll see you with tribute in the months to come. Take care.
Thank you very much.
The next person who's registered in advance to speak on behalf of the nominee is Robert Lasky, and I see that he has joined our meeting. You may have the floor.
There, thank you very much. Senator Carney, Representative Harnett, distinguished members of the Judiciary Committee, I'm Rob Lasky from the town of Eddington, and I'm here to speak on behalf of the confirmation of Rob Langner as a district court judge. I thought in my comments, I said I thought I've known Magistrate Langner for 20 years, but it appears I've known him for 19 years and appeared before him for 9 of those years as an Assistant Attorney General when I represented the State of Maine Department of Health and Human Services as an Assistant Attorney General. And for the past 10 years, I've been a family law magistrate and have worked with Magistrate Langner as a colleague. During my tenure as an AAG, I appeared before Magistrate Langner hundreds, probably more than 1,000 times. In my experience in his courtroom always led me to admire and respect his approach. It's been many years since I'd appeared before him. I've talked to people, some attorneys who routinely do appear before him to try to get a sense of their impressions and experiences in his court. And those attorneys also uniformly admire and respect his work on the bench. Attorneys remark on his ability to communicate with unrepresented parties in a very effective and personable way. We've heard that already from other folks before me, and it's true. They describe, these attorneys I spoke to describe his capacity to explain the judicial process to unrepresented parties in a way that they can understand. Litigants are comfortable in his courtroom. I can attest to that from my experience. He's described as being compassionate, and that's my experience. Attorneys that appear before him remark that he treats everybody equally, whether they're represented by an attorney or whether they're representing themselves. Magistrate Langner is described as being even-tempered. He never loses his cool. He maintains an orderly and dignified court and reduces the tension and conflict that can exist in a courtroom through his calm demeanor. And the importance of these skills just cannot be overstated for a magistrate or a district court judge. My experience as a practitioner before Magistrate Langner are the very same. I'm not surprised to learn that he's consistently and reliably continued to administer justice in the same way that I'd been accustomed to. He's naturally gifted with a temperament that is really suited to what he has been doing as a magistrate and what I hope soon he'll be doing as a district court judge. And as I was listening to Mr. Hobson's remarks earlier, I was reminded of several occasions when as described, Magistrate Langner, recognizing there was a case that needed immediate attention, he would take a writing day, one day a month. A judicial officer has a day to write. He would take a writing day, go to a different court to get a case done that needed to be done. That's the sort of judicial officer he is, and he will always be. During the past decade, I've worked with Magistrate Langner as a colleague and a friend. I've benefited from his generosity in sharing his time and working on or helping me sort out challenging issues I've been presented with. And I know he does that for other magistrates and for other judges. He's very thoughtful and considerate of all court staff, including court clerks, including judicial officers, including anybody with whom he interacts. And he cares very deeply about what he's doing. He's committed to a fair administration of justice, and he'll be a great judge. I've come to also appreciate and admire Magistrate Langner's commitment to what has effectively been a lifetime of public service. He did practice law in the public or the private sector for some while, but he was an assistant district attorney, as we've heard, and for the past 19 years, he's been a magistrate. And his commitment to service is also reflected in his community service. We heard Judge Dow earlier this afternoon talk about the spirit of volunteerism in Aroostook County, and certainly Magistrate Langner is demonstrating those qualities. He's taken time out of a busy schedule where he covers a geographical range the size of Rhode Island, I believe. It's not an exaggeration. Yet he found time to serve on community boards, direct community activities, serve as a coach in basketball, baseball, cross country, and perhaps more important than all of those things, or equally important to all of those things, I've come to learn how very proud he is of his family and how very important his family is to him. I'm sure they're proudly watching here today, and they have every right to be. For these reasons, I respectfully request that you act favorably on the nomination of Magistrate Langner as a district court judge, and I thank you very much for this opportunity to make these remarks. I'll be happy to answer any questions the committee may have.
Thank you very much. Committee members, does anybody have questions for Mr. Lasky? Just checking for virtual and real hands, and I don't see any of either. So thank you very much for appearing before the committee today, Mr. Lasky.
My honor. Thank you all.
The next person here to speak in favor of the nominee is my former colleague with Pine Tree Legal, Jeff Ashby. You may proceed, Mr. Ashby.
Thank you, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on the Judiciary. My name is Jeff Ashby, and I'm from Presque Isle, Maine. When you hear my comments, I fear that you'll think that I conspired with the previous speakers, and I assure you that I did not. But my comments are going to sound very familiar. I come before you with an honest and enthusiastic endorsement of now Magistrate Rob Langner in support of his nomination to the District Court bench in the Central and Southern Districts of Aroostook County. I am the principal of my own firm in Presque Isle. Before starting Ashby Law Office 2 years ago, I did spend 15 years as a member of the leadership team at Pine Tree Legal Assistance and manager of the Presque Isle PTLA office. Before that, I practiced law for 10 years in downtown Presque Isle in another private law firm. I have known Magistrate Langner for nearly 3 decades. I practiced with him as a colleague in private practice and when he was a prosecutor. And I have been before him countless times in his capacity as a family law magistrate, as recently as twice this morning. As I prepared to come before you, I took the measure of my colleagues about Magistrate Langner, and I have authority to share their thoughts along with my own with you. Sharing the observations of my many Aroostook County colleagues might have been tricky and confusing with any other nominee. With Magistrate Langner, it is not a challenge at all, because without exception, the Aroostook County Bar is united in its support of Magistrate Langner's elevation to the District Court judgeship. Comments of those surveyed were universally positive, reflecting a common view of the fine qualities and capabilities that make Rob Langner a great magistrate and that will make him a great judge. The consensus is that we know of no individual who is better deserving and who has better earned the honor and obligation being considered for Magistrate Langner today. Magistrate Langner has earned the position because he has worked tirelessly in a grueling job as a family law magistrate, traveling hundreds of miles weekly, sitting in a number of courts across half the state of Maine, hearing hundreds of cases a month for a significant number of years. He issues clear, careful, and correct decisions on time. We marvel at how day in and day out, Magistrate Langner does so much work. Magistrate Langner is deserving of the position because as he does this remarkable body of work, he treats everyone with whom he comes in contact with the utmost respect and dignity. Even when temperatures are high and tempers flare, especially when this is the case, Magistrate Langner is kind to and patient with everyone in the courtroom, always. It does not matter whether you are pro se, represented, or an attorney yourself, Magistrate Langner listens to people. He is a problem solver. He is unbiased, level-headed, clear, and informed about the legal issues before him. If a decision in his case has ever been appealed, or perhaps appealed successfully, I have not heard about it. You can imagine that I, as a former employee of Pine Tree Legal, feel strongly about access to justice in the state of Maine. I do. I and many others feel that now Justice Stephen Nelson, who is leaving the position for which Magistrate Langner is being considered, has been a real champion of and believer in the concept that all who come before the court should be granted full access to the rights and remedies available there. If you elevate Magistrate Langner to the bench, it is my personal belief that the people of Aroostook County will experience in this respect a seamless transition. They will continue to enjoy true access to justice as they will continue to be heard and respected, and they will receive efficient, fair, thoughtful, and knowledgeable service from the tireless Magistrate Langner. Please vote in support of this nomination for Magistrate Rob Langner to the District Court Judgeship in the central and southern districts of Aroostook County in our great state of Maine. And with that, I'm happy to answer any questions that you may have of me.
Thank you very much. Are there any members of the committee who wish to be recognized for a question? I'm not seeing any hands. Thank you very much, Mr. Ashby.
Thank you.
And that brings us to the next, and I believe perhaps final person who's here to speak on with regard to this nomination, and that is Laurie Maycomer from the Maine Trial Lawyers Association. Excuse me, Laurie Boxer Maycomer. You may proceed.
Thank you. Good afternoon, Senator Carney, Representative Harnett, and members of the Judiciary Committee. First, I want to thank you for your service in the legislature and for your service on this committee. It's a lot of work, and the Maine Trial Lawyers, whom I'm here testifying on behalf of today, would like to also extend its thank you to you for your service. So today I'm here, I'm a Portland resident, but I'm here in my capacity as president-elect of the Maine Trial Lawyers to speak in support of the confirmation of the Honorable Rob Langner's appointment to the Maine District Court. As Chris Lewis talked about earlier, the Maine Trial Lawyers has a survey process where we survey our membership and ask them about a candidate's professionalism, ethics, skills, demeanor, and the like. And in this particular case, we received high remarks. People highly regarded Magistrate Langner for his skills, intelligence, ethics, and judicial temperament. Much of what I've heard this afternoon is what we saw echoed in our comments from our membership of trial lawyers and other attorneys. Many of them really highly respect the work that they've seen from Magistrate Langner, his written opinions, and his demeanor on the bench. One respondent said that the nominee has for many years exhibited exemplary judicial abilities in the Washington County courts where I practice family law. He will make a great judge and will be missed locally as a magistrate. Another respondent opined that he has exhibited the perfect temperament to deal with pro se litigants, which is critically important, as everyone knows, particularly in rural areas where access to justice is not as common as it may be in other parts of the state. And that respondent also said that he was an excellent appointment. Our executive committee met to review the comments of our membership, and we agree with the assessment. And I guess I should say that, you know, sitting here today for the last hour and a half, even though I haven't appeared before Magistrate Langner, he is the type of judge that we need here in this state, and it's wonderful to hear the breadth of experience that he'll bring to this appointment, not just his legal experience, but his real life experience and experiences as a parent, husband, and a community member. So we're thrilled to see someone like that appointed to, hopefully appointed to this position. And I do want to emphasize on behalf of the trial lawyers how important it is to have judges appointed who have private practice experience, not just public practice experience or limited experience where they're not actually practicing. And it appears as if we've got that in this candidate as well, someone who really understands what it's like from all different angles. And so we're highly supportive of the fact that he brings those skills to this position as well. So in sum, I echo what we've heard from others today, and we believe that he will make an excellent district court judge, and we support the confirmation of him by your committee. Thank you.
Thank you very much. Committee members, does anybody have a question for Ms. Boxer Maycomer? I do not see any hands raised. Thank you very much for appearing before the committee today.
You're welcome. Thanks.
At this point, we are done with the list of people who signed up ahead of time to provide feedback. And I just need to take a moment to check with those who are in the waiting room to make sure that they're not here on behalf of this nomination. I see that we have a number of attendees in the waiting room, and I would just ask the attendees to please use your raise hand function if you wish to speak in support of the nomination of Rob Langner. I'm not seeing any virtual hands. Is there anybody who wishes to speak in opposition to the nomination? And again, I'm not seeing any raised hands. All public comments having been taken, the committee will now proceed as follows. We will review any additional written comments on the nomination that have been received by the committee. And at this point, I will just ask our committee clerk if we have received any additional written comments on the nomination.
You have not.
Thank you very much. We will vote on the nomination and notify the President of the Senate pursuant to Title III MRSA Section 157 and the joint rules. The vote must be taken within 40 days from the date of the governor's written notice, and we are within that time frame. The hearing by the Joint Standing Committee for the Judiciary for the Honorable Rob A. Langner of Fort Fairfield for appointment as a district court judge is now closed. We'll move on to taking of the vote. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. At this time, therefore, I will inquire whether any member present objects to proceeding to take the vote immediately. And so again, if you object, please raise your virtual hand or your actual hand if your virtual hand function is not working. And I do not see any raised hands. Thank you, committee members. There is no objection. And so the pending question before the committee is that the Joint Standing Committee on Judiciary recommend to the Senate of the 130th Maine Legislature that the nomination of the Honorable Rob A. Langner of Fort Fairfield for appointment as a district court judge be confirmed. In accordance with 3 MRSA Chapter 6, Section 157, and with the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending confirmation. A vote of no will be against the motion to recommend confirmation. Is the committee ready for the question? The committee clerk will call the roll.
Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime.
Yes.
Senator Kime votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Downs.
Yes.
Representative Downs votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Senator Sanborn. Senator Sanborn is absent. Representative Hagan. Representative Hagan is absent. 12 members voted yes.
Thank you very much. 12 members of the committee, having voted in the affirmative and no members in the negative, it is the vote of the Joint Standing Committee on the Judiciary that the nomination of the Honorable Rob A. Langner of Fort Fairfield for appointment as a district court judge be confirmed. Typically, we would gather around and shake your hand if we were in the committee room, and we're not able to do that. So we would like to share with you a virtual round of applause. Congratulations very much.
Thank you, folks, very much. Thank you for your time. Thank you for your dedication to the citizens of the state of Maine. As a sitting magistrate for as long as I have, I get very little feedback on what I do. It's positive to hear those remarks. So thank you for your time. And again, I enjoyed hearing those good things because it confirms that maybe I'm doing some things right. Thanks, folks.
Yeah, we are very appreciative of your willingness to serve the state of Maine, both as a magistrate and hopefully soon as a district court judge. Thank you.
Thank you again. Bye now.
Members of the committee, we have one additional nomination to take up today. That is scheduled for 3:30. And so I would ask that committee members return promptly, maybe a couple of minutes before 3:30, so that we can take up that nomination on time. And please, if you're going to leave your device, please remember to mute and turn off your cameras. I'm just going to check in with the clerk. Supi, was there something that we needed to attend to?
I don't believe so. Is Peggy on? She may have something.
No.
There she is. No.
Okay. I think we're good for about 19 minutes. Thank you very much. Hi, Ms. Gilbert. I just wanted to let you know that we are on a break until 3:30, but the live stream will continue. So committee members typically will turn off our cameras and our audio until we're just a couple minutes before 3:30.
Okay, thank you for that. I'll do the same.
Yeah, thank you. Know that we are on a break until Looks like the committee members are returning to the electronic meeting, so we'll get started in just a moment. Looks like the committee members are returning to the electronic meeting, so we'll get started in just a moment. Looks like the committee members are returning to the electronic meeting, so we'll get started in just a moment. Obviously, we are having some technical difficulties. I'm not repeating myself. So let's do this. If everybody can just mute their microphones for now, and let me look into it, also not using a microphone. And as soon as we get it squared away, we can resume. Let me just check out the situation.
Senator?
Yes.
Do you want me to go check with our clerk to see if it's an issue on their end?
She's saying that it's not. I can see her
Okay.
on the screen.
I'm wondering if somebody has the YouTube channel on and it's delayed to some degree.
I think that was the issue. Someone was listening on YouTube with their mic open.
All right. I'm not hearing myself repeating myself, so I think we're good to go. As soon as a few more committee members join us, we will resume today's nomination hearing. Representative Moriarty, you are not muted. I don't know if you wanted to thank you. So it looks like we are ready to resume today's hearing. Welcome back, everyone. This is a public hearing of the Joint Standing Committee of the Judiciary for the purpose of considering the nomination by the governor of Ms. Sarah I. Gilbert, Esquire of Hope, for appointment as a district court judge. The meeting today is being conducted electronically. Under the law and the joint rules of the legislature, this committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by majority vote of the committee members present and voting. As chairs of the committee, we will then send written notice of the committee's recommendations to the President of the Senate. The committee will hear testimony from and have an opportunity to question the governor or her representative, the nominee, and any other persons present who wish to speak for or against the nomination. Before we get started, I want to welcome some committee members who have joined us since we recessed, and that would be Senator Sanborn.
Hi, Senator Carney. Thank you. My name is Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook.
Thank you. And Senator Keim, I forget whether you had an opportunity to introduce yourself earlier or not.
I believe I did, but I can again. Good afternoon. My name is Lisa Keim, and I proudly represent Senate District 18, which is Northern Oxford County and 2 communities in Androscoggin.
Thank you. Before we get started, I want to share some information related to the fact that this meeting is being conducted using an electronic format. This meeting is currently being live streamed on the Judiciary Committee's YouTube channel. This means that anyone who is a participant in the meeting via Zoom can be seen and also heard if their microphone is unmuted. People testifying cannot be seen or heard until they are called upon to speak. This meeting will be recorded and available to view on the committee's YouTube channel soon after the meeting has concluded. At this point, we'll move on to a motion to confirm. Pursuant to Title III, Section 157 of the Maine statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes Representative Tom Harnett for the purpose of making such a motion.
Thank you, Madam Chair. I move that the Joint Standing Committee on Judiciary recommend confirmation of Ms. Sarah I. Gilbert, Esquire of Hope, for appointment as a district court judge.
Thank you. And I recognize Representative Chris Babbage.
Thank you, Madam Chair. I second the motion to recommend confirmation for Sarah Gilbert to become a district court judge.
Thank you. The statutory requirements for this position are posted on the committee's webpage. The chair now recognizes the representative of the governor, Mr. Jerry Reed, for the purpose of making a statement concerning this nomination.
Thank you. Good afternoon, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. I'm Jerry Reed, legal counsel to the governor, and here today to present Sarah I. Gilbert as the governor's nominee for appointment to the Maine District Court. Attorney Gilbert has been in private practice in Camden for more than 10 years, most recently as a founding partner in the firm Camden Law, LLC. She has specialized in trial and litigation work in state courts with particular focus on family law, personal injury, and other complex civil litigation. Before going into private practice, Attorney Gilbert was selected to serve as a law clerk to Justice Donald Alexander on the Maine Supreme Judicial Court. I spoke to Justice Alexander about Attorney Gilbert after her interview with the Judicial Selection Committee, and he gave her the most enthusiastic endorsement, praising her intelligence, work ethic, thoughtfulness, and humanity. Attorney Gilbert graduated with a degree in political science from Vassar College and earned her law degree magna cum laude from the University of Maine School of Law. Sarah Gilbert is more than just a smart and talented lawyer, though she is clearly all of that. She brings to her work the valuable perspective of someone who grew up in Washington County and attended the local schools in Machias. She is therefore familiar with the unique challenges faced by Maine's poor, rural communities. She is also the daughter of another distinguished attorney, Rebecca Irving, a longtime Passamaquoddy Tribal Court judge and the 2017 winner of the Maine Bar Association's prestigious Caroline Doobie Glassman Award, given to a woman who has excelled in the profession and paved the way for other female lawyers. In her interview with us, Attorney Gilbert talked about how her mother served as a role model for her. One can only imagine how proud Attorney Irving must be to see her daughter today, a distinguished woman lawyer in her own right and a true rising star in the profession. Sarah Gilbert's background, experience, and record of accomplishment make her an excellent candidate for the district court. And on behalf of the governor, I respectfully request your support for her appointment. I would be pleased to answer any questions that the committee may have of me. Thank you.
Thank you very much. I see that Senator Keim has her hand raised. You may proceed, Senator Keim, with a question.
Thank you, Madam Chair. Good afternoon, Mr. Reed. I had a question. Could you tell me what process the governor's office undertook when they were looking at the complaint history of Attorney Gilbert that we see with the Board of Overseers?
Sure, I'd be happy to address that. So with every candidate that comes before us, attorneys who are currently in private practice and being nominated from private practice and considered for the bench with that background, we contact the Board of Bar Overseers and ask for a report from the board of any record of discipline for this candidate. I also ask for a report that consists of any complaints that may have been filed with the board, which are very different than discipline. So I did that in this case, and I got an email back from the counsel for the Board of Overseers confirming that Attorney Gilbert has never been subjected to any discipline by the Board of Overseers. That email also said that Bar Counsel would get back to me with more information about any complaints that may have been filed against her. I never received any follow-up email with any information about bar complaints and did not pursue that further. So when the issue became the subject of more discussion later in the process, and Attorney Gilbert and I talked about the fact that there had been some complaints filed with the board, we followed up with board counsel to make sure we got that information and provided it to the committee as soon as we had it.
And after you saw this list of complaints, what sort of follow-up did either the governor's office or the committee undertake at that point?
Well, I can only speak to the governor's office, but the list of complaints that were filed from Bar Counsel indicated that all but one were dismissed summarily, and one was the subject of a letter of warning. I've talked to Attorney Gilbert about the circumstances of that matter and satisfied myself in this office that there's nothing disqualifying about the subject of that complaint.
Thank you.
Members of the committee, are there additional questions for Mr. Reed? Representative Libby, you may ask a question.
Thank you, Madam Chair, and nice to see you, Mr. Reed. It's more of a notation than a question. I appreciate that the information on the candidate questionnaire is so up to date, as Ms. Gilbert is a new nominee. It would be nice in the renominees to see such up-to-date information, as most of the time it's 1 or 2 cycles behind, and as we saw today.
Yeah, I would just remind you that, Representative Libby, that we are here to talk about this particular candidate. We did give the governor's office feedback pretty consistently when there were questionnaires that hadn't been updated. And I think that since we're addressing a candidate whose questionnaire is up to date, that would be an out of order question.
Thank you. I appreciate the information provided today.
Are there other questions among members of the committee? I am not. Yeah, Representative Evangelos, you may proceed.
Thank you, Madam Chair. Just a quick question, Mr. Reed. Was there an amended questionnaire submitted along with the committee? I didn't see anything.
No, the only questionnaire that we have received relative to this application is the one that's in the possession of the committee.
That was dated in October of 2019.
Yes.
Thank you.
All right, any further questions, Mr. Reed? Representative Harnett?
Thank you, Madam Chair. Mr. Reed, do you know if it's unusual for attorneys engaged in private practice to have complaints filed against them with the Board of Bar Overseers that are ultimately dismissed as having no grounds?
I know that it's far from unusual. It is the rule, not the exception. I think any attorney who engages in a busy litigation practice will be subject to complaints in the course of their career. What's important is not whether complaints are filed with the Board of Overseers. What's important is what the disposition of those complaints is. And in this case, the disposition of the complaints has satisfied me that there's no cause for any concern about the merits of this candidate.
Thank you.
Right, at this point, I am not seeing any additional raised hands. And so I thank you very much, Mr. Reed, for speaking with us today. Before we recognize the next speaker, I'd like to give Representative Hagan a moment to introduce himself.
Thank you, Madam Chair. Hi, I'm Dave Hagan. I'm from, I represent Hamden and Newburgh, House District 101.
Thank you very much. Next, I'd like to recognize Mr. John Hobson, speaking on behalf of the Governor's Nominating Committee. You may proceed.
Thank you very much, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on the Judiciary. My name is John Hobson. I'm Chair of Governor Mills's Judicial Selection Committee. And on behalf of the committee, I request that this committee act favorably on the nomination of Ms. Gilbert for position of the District Court Judge in the state of Maine. Ms. Gilbert brings to the job the qualities of that Mr. Reed has already mentioned, but the interesting thing about this candidate is both her personal history, her life story that brought her from growing up in Machias, a mother who was a known and recognized attorney, going from the community of Machias, going to what is candidly a bit of a different universe even, which is Vassar College. And going to Vassar College, going on, coming back to the state of Maine, which is something the state needs more of, going to the law school, graduating with honors from the law school, going on to the Maine Supreme Court to clerk for a well-known justice of the Maine Supreme Court, and then going into private practice. And this committee has heard me say this before, but being in a small town, mid-coast private practice where you have to make sure you're able to make the payroll, you have to keep the doors open, you have to pay the rent, all the pressures that come with trying to administer a small practice and practice law. You also hear in a very real and personal way about the stories of the individuals who make up the population of your surrounding community. And you come to represent them in ways and in issues, particularly in this candidate was in family law. And family law is a highly contentious area. And there was the issue that Mr. Reed was asked about in terms of bar complaints. The area of family law is rife with complaints that are sent to the Board of Overseers of the bar for attorneys that litigate in that area. Very often, those complaints can even be filed by the client of the other attorney. It is just a very highly contentious and highly emotional area. And as Mr. Reed said, there are many, I would dare say most, attorneys, certainly those who practice in the family law area, who have been the subject of multiple bar complaints. And the issue is not whether someone can file a complaint, it's whether or not there was any merit to it. And the Board of Overseers of the bar takes care of that process. And this process, obviously, Mr. Reed has told you what the results were. Ms. Gilbert has gone on to really an accomplished career for the time that she's been in practice. She's well known as being a mid-coast and in the state as someone who is a very good civil trial litigator, someone who is very good in the family law area. And this is brings something to the bench. And I've mentioned this before, that the strength of the judicial branch and the judiciary and the judges that make up the system is having a constellation of talents that make that up. And not everyone is going to be the same. And it's important that not everybody be the same. And what Ms. Gilbert brings to that is someone who is obviously very intelligent, who has accomplished very good big things in her career already, who is basically rising in the profession and brings an energy and enthusiasm that will serve the people of the state of Maine very well. And so on behalf of the committee, I request that this committee act favorably on the application of Ms. Gilbert.
Thank you very much, Mr. Hobson. I see a question from a member of the committee, Senator Keim. You may proceed.
Thank you, Madam Chair. Good afternoon, Mr. Hobson. I have a few questions, if I may, Madam Chair.
Why don't you ask one question and one follow-up, and then we'll see if other committee members have questions. Thanks.
It's three that pertain to one another. So Mr. Reed said that he spoke with the nominee regarding the complaint, and that we see the one that she was given a warning on, and that he was satisfied with her response. So I was wondering, did you see the board, did the committee see the Board of Bar Overseers complaint history at the time this nominee was being considered?
At the time the nomination was being considered, we did not, but subsequently I have spoken to the nominee about it, and I have actually read the decision that was referenced in the one letter of warning letter, and I have no concern in terms of it having any bearing on the qualifications of this nominee.
So then yourself or the committee did no further follow-up, such as questioning any other people around this complaint? You simply questioned only the nominee?
Yes, as I said, I also read the court decision that was referenced.
Okay, thank you.
Do other committee members have questions for Mr. Hobson? Representative Evangelist, you may proceed.
Thank you, Madam Chair. And hello again, Mr. Hobson.
Good afternoon, Representative Evangelist.
We're just sometimes concerns get brought to our attention, and we want to be as civil as possible. But we have had a variety of nominees come before us, and I haven't seen any record of complaints or issues with the bar. But I have that Judge Michael Duddy's ruling in front of me, and in fact, he did rule that there were two, I think, rather serious ethical violations, rules 1.9 and 1.10. So I just want to support a little bit Senator Keim's line of questioning. It seems to be justified. It's a legitimate concern and a legitimate question.
I am not in any way suggesting it wasn't a legitimate question. What I was trying to say is that I've read the decision and put that in a little bit of context. Conflict issues are sometimes used in litigation as a sword and as a weapon. They'll raise conflict issues. And that was the context. It was in the context of litigation that the decision was made. So in terms of the ultimate resolution of that issue and the letter of warning issued by the Board of Overseers of Bar, as I say, I don't have any concerns at all about the qualifications, bearing on the qualifications of this nominee.
But the issues weren't based on no grounds, right? There were grounds, right?
The Board of Overseers of the Bar issued a letter of warning. But as I say, in terms of this nominee for this position, that context does not give me any pause in terms of the qualifications of this nominee for this position.
Thank you for that. But to be clear,
Excuse me, Representative Evangelos, we're going to give all committee members an opportunity to ask questions. And I actually have a follow-up question based on Mr. Hopkins' answer to your question.
May I continue?
Let some other committee members ask questions.
The context of his answer leads to my next question. We're going to lose the context if I'm not able to ask it.
Go ahead.
I just want to ascertain that the issue with the bar, whatever it was, a warning or a reprimand, was not groundless. It was based on Judge Duddy's 2 sanctions regarding ethical violations, and I just want to be clear on that. Is that correct?
Can I just interrupt and just point out that we don't have a record of a disciplinary action? I think the record reflects a warning. And with that, you may proceed, Mr. Hobson.
As I say, the Board of Overseers of the Bar issued the decision they did, which was a warning and not disciplinary action.
Representative Libby, I know that you have your hand raised, but I just wanted to ask a question that I think will help clarify. Mr. Hobson, you referred to litigants using conflicts as a sword. Could you please explain what that means?
What it means is that there are times that litigants use the ethical rules to try to get an advantage in civil litigation. And they will use the process to allege a conflict to try to put the other attorney back on their heels and to try to gain an advantage in civil litigation. Ours is an adversary process, and they are entitled to do that. And it is used at times by some attorneys. But one has to understand the context when that is done that way, that it is done as a tactic in a litigation process, and understand that in context.
Thank you. Representative Libby, you may proceed with your question.
Thank you, Madam Chair. And I'm actually not sure that this is a question for Mr. Hobson, but maybe one more protocol. I understand that Representative Evangelos has access to the letter regarding the dismissal with warning, and I would request that the rest of the members of the committee would have access to that.
I do not have access to it either, Representative Libby, but that's something that perhaps we can follow up on.
Thank you.
Are there other questions for Mr. Hobson? I'm not sure if these are old or new hands, Senator Keim and Representative Evangelos. Do you have a current question, Senator Keim? Yes, you may proceed.
Thank you. And I would concur with Representative Evangelos that while some of our questions may go on to 2 and 3, sometimes when we're following a train of thought, it's helpful to finish that line of questioning so that the committee can follow along rather than be interrupted to change hands. And I'm more than willing to wait until, an appropriate time to ask the questions. But when I do, it would be helpful to be able to follow a line of reasoning so that we can understand the process, because nominations are always something we should take with gravity. So Mr. Hobson, when you were considering this nominee, did you ever hear any issues around judicial temperament?
No, I did not. In other words, whether she would have a temperament that would be appropriate for be a judge, the answer to that is yes. People thought she did.
And were any negative concerns brought forward to the committee at all?
Not that I remember. Not that I remember.
Thank you.
Representative Evangelos, did you have another question?
I was muted, sorry. Oh, just, Madam Chair, a point of clarification. I am not in possession of anything from the main bar other than a statement that the matter was confidential. And the only thing I'm in possession of is Judge Duddy's court ruling. But I don't have any material in reference to what Representative Libby said. Only what was disclosed to the committee regarding I believe what the attorney for the governor disclosed, that additional information had been sent to us, and that included a mention of a warning or a reprimand, but it remained confidential. I am not in possession of anything from the bar that's confidential. Just want to make that clear.
Yeah, thank you. And just to be clear, it was a warning and not a reprimand, which I think are two different things. But thank you for
We're not able to read it. We're not sure, but just my opinion.
Oh. Did any other member of the committee have a question they would like to ask of Mr. Hobson? Senator Keim?
Thank you, Madam Chair. Yes, one further, Mr. Hobson. Did the committee attempt at all to look at social media of the nominee?
Did we independently go and try to look at social media of the nominee? The answer is no. I mean, we did. There's a question we did ask about social media, but no, social media is a pretty wide phenomenon. So we don't have a investigatory arm of the committee that does that. Social media is a pretty wide term that covers a lot of different areas. So I guess the short answer to your question is no, we don't have an independent, the committee does not have an independent investigatory arm.
Thank you.
All right, just checking, and I do not see any more raised hands on behalf of committee members. So thank you very much, Mr. Hobson. We appreciate your appearing before us this afternoon.
Thank you very much.
We'll move on to the statement by the nominee. Before I do Senate, okay. The chair now recognizes Ms. Sarah I. Gilbert, Esquire, for the purpose of making a statement concerning this nomination. You may proceed.
Thank you, Madam Chair and Co-Chair Representative Harnett and distinguished members of the Judiciary Committee. My name is Sarah Gilbert. I am from Hope, Maine, and I sit before you this afternoon honored to have been nominated by the governor for an appointment to the district court. It is my pleasure this afternoon to participate in this advice and consent procedure, which is of course so important to the idea of co-equal branches of government. I want to begin by thanking all of you for your civil service and for your commitment to the people of Maine. I've had the pleasure of watching this body interact with the other nominees, and it gives me great faith in your own constituents for having elected such thoughtful, involved legislators. I want to thank the Judicial Selection Committee for its time and care in the selection process. And of course, I want to thank the governor and her representatives. Finally, I do also want to thank Justice Donald Alexander, formerly of the law court and a jurist who requires little introduction. I want to thank him for hiring me to be his law clerk years ago. That experience has significantly shaped my path in the law, and it opened my eyes to the complexity, earnestness, and legitimacy of the judiciary here in the state of Maine. I am a proud product of Washington County. I spent a large part of my childhood in a multi-unit apartment building in Machias, Maine. I watched my mother practice law from her kitchen table for many years, and later I watched her serve the people of the Passamaquoddy tribe as their tribal court judge. Given the import of your consideration of me today, especially as a new candidate, I would like to tell you a bit about my history and the forces and the influences that have shaped me as a person and as a lawyer. My mother, Rebecca Irving, was born on a farm in a little town named Oxford in Iowa to German immigrants in the 1950s. With her own intense work ethic and positive attitude, she was able to secure for herself a full ride to college in Nebraska. And she became the first of her 6 siblings to obtain a college degree. She later attended law school in Missoula, Montana, where she was able to work with folks who were on death row as part of the Montana Defenders Project. And she was only one of a handful of women to have graduated from her law school class. I stand on her shoulders today, and I stand on the shoulders of other pioneering women who have inserted themselves into this very old and very important profession. My father, Peter Irving, is a first-generation American, with my grandfather having come through Ellis Island with his extended family from Dumfries, Scotland in the 1920s. My grandfather had a thick Scottish brogue when he arrived in America. He had nothing more than an 8th grade education, and he had been apprenticed out in Scotland as an upholsterer's assistant as a little boy. It was very difficult for him to find any type of employment with a thick accent, so he worked very quickly to get rid of it. I'm told he wasn't always successful, but remarkably, he was able to put himself through night classes in New Jersey and was actually able to complete law school at night at Rutgers University, while at the same time working during the day to support multiple generations of his family in a little house in Ridgewood, New Jersey. He practiced law in New Jersey until his untimely death in his early 50s. After his father's death, my dad, who I was obviously very heartsick over that, dropped out of high school at the age of 16, and he enlisted and was sent overseas to Vietnam at the tender age of 17 to serve his country. Later, after his discharge, he moved to Montana to work with intellectually disabled adults in Missoula, which of course is where he met my mother. They got married, decided that they needed a little bit more adventure in their life, and so they picked the most eastern town in the country that has a courthouse that happens to be Machias. And they packed up a U-Haul sight unseen in 1979 and made their way to Washington County. My childhood in Machias was in some sense like going back in time, I think. In the early 80s, pre-internet and geographically isolated, I went to school with children that did not drive south of Bangor until they were teenagers or even young adults. Machias at any given time has 2 restaurants, virtually no place to buy a pair of shoes if you needed a pair of shoes. And if you wanted to see a movie in a movie theater, you were driving north to the border, which was a very rare and very exciting trip for me as a child. Washington County has undoubtedly shaped who I am as a person and who I will be if confirmed as a judge. While it has the rather unfortunate honor of being Maine's poorest county, and it is ravaged right now by the scourge of drug addiction and poverty, it is rich in its sense of community and heritage. My brothers and I were raised with people who care deeply about one another, people who shy away from materialism, folks who are plain spoken, sometimes to the point of being gruff, but if you look for it, there is a richly developed sense of humor and sense of humanity in the people up there. If I have any history enthusiasts on the committee today, I am proud to report that Machias Port was the first naval battle of the Revolutionary War, which took place in 1775. And I went to school with many people who have the same last name as those early settlers who fought in that battle. As a child, I regularly attended bean suppers and community events for those in our community who were ill or who needed financial help. I was taught the value of $1 each summer, especially because I raked blueberries every August, beginning when I was 11 years old, so that I could buy school clothes in Bangor. I was made to understand, I think most importantly, having been raised up there, that we are all in this together, regardless of socioeconomic status, religion, political persuasion. There are so few people up there. Those types of classifications mattered a heck of a lot less, I think. And if you needed help, your neighbor was going to help you no matter what. It was enough that you were a part of the community and you're accepted as such. In recent weeks, I have been overwhelmed by the outpouring of support that I have received from my friends, colleagues, and teachers at Machias Memorial High School. Their sense of pride at having one of their own sit before you today. I graduated with a class of 36 kids, and we had a very active mock trial team, which was hugely impactful for me and my classmates during high school. If confirmed, it would be an honor for me to spend time in the courts in Calais and Machias and to give back to the communities that have given so much to me over the years. Those are the values that I maintain today, and those are the qualities that will serve me well on the bench. Those are the same attributes that have made my brother John an excellent law enforcement officer in Western Maine, and my brother David, an innovative computer programmer who's able to work out of his home in Livermore Falls, which is kind of amazing. After I graduated from Machias High School, I headed down to Poughkeepsie, New York to attend Vassar College. I was bombarded with people from all over the world. I was incredibly intimidated at first. It took me a long time to get used to so many different ideas, I think. I was taught in college to think for myself. I was taught that I did not know anything about the world, quite frankly, and I was taught to value my own unique experiences. I was able to have internships in college that were impactful for me as well, in Boston and New York City. I think the most important professional experience that I had in college was when I was able to work for the International Association of Women Judges in Washington, D.C., which is a nonprofit that seeks to end discrimination against women and girls worldwide. One of my fondest memories, recurring memories from college, is showing up at the Bangor Greyhound station at 1 in the morning and seeing my dad there waiting to drive me the extra 100 miles back home. Coming back to Maine for law school was an honor. I had an incredible education at Maine Law, and I was so impressed with the faculty's commitment to creating, compassionate, well-spoken, and wonderful attorneys. In law school, I thrived on debating timely issues, which has been something that's always been important to me, but I was encouraged by my professors to speak passionately about issues that were important to me. And I think that served me well in my trial practice. Even today in the courthouses before COVID, I really took interest in and enjoyed debating with my colleagues in the courthouse hallways, policies of the day and what laws could be stretched or not stretched or outcomes. And I really enjoyed that. And I think good trial lawyers participate in that kind of activity regularly because it does force us to stretch our thoughts, and it's a good thing to do. It takes a village to raise a child, and I think it takes more than a village to support the successful practice of law. I sit here today as the mother of 2 young daughters who are watching, Ivy, who is 7, and Eliza, who is 6. I want to thank my husband, Chris, for the many, many occasions that he has fed, bathed, and put our girls to sleep at night when depositions or trial work or the press of business would keep me from being home. I know that my daughters, even at their young age, are able to watch me now and appreciate that hard work, humility, and courage will allow them to pursue their own dreams. Regarding my qualifications to sit on the district court, I have substantial trial experiences in a broad array of cases that range from the district court to the superior court to the Maine Supreme Judicial Court. The scope of my practice was highlighted for me recently in December when I sat down to be interviewed by the Judicial Selection Committee. I looked at a Zoom screen that was filled with legal titans, role models of mine, and I realized at that point that I've litigated cases with almost every single one of them over the years, ranging from complex medical malpractice cases to business and commercial disputes to divorces. Relevant to my qualification for appointment to the district court, I also have extensive appellate experience with over 13 published decisions from the law court and 10 oral arguments. If confirmed, it would be my honor to draft efficient, clear orders for the people of Maine. And as a compliment to my other new nominees, my fellow new nominees, I bring with me substantial experience in family law, which of course the district court enjoys almost exclusive jurisdiction over. I agree with the testimony of the other nominees that the district court is where humanity is most clearly laid bare on a daily basis in our system of justice. District court judges cannot and should not live in ivory towers. They must recognize each human being that appears before them as a real person. And many of those folks appearing in court are incredibly fearful, as this committee knows. And I have seen that fear manifested by lashing out, by emotionally shutting down, and in any other manner of manifestations. I have felt that realness every day that I have practiced in district court. I have overseen the forcible return of a child after a contempt hearing, for example, where the judicial marshals are forcing a teenager to go back to the other parent in the courthouse hallways. I have seen that happen on a regular basis, screaming and crying, all of that happens in district court. I have also seen the joy behind closed doors of adoption proceedings being finalized and the creation of new families. My private practice has encompassed the representation of Mainers of all walks of life, with mental health concerns, with substance use disorders, and with significant criminal histories. I am as equally comfortable handling a complicated guardianship proceeding as I am scrutinizing real estate documents in a partition or boundary dispute matter. Additionally, while I generally seek to avoid bluster and bombast in the courtroom, over the years I have demonstrated a tenacity needed to make tough decisions, even if my tenacity is communicated in a way that might be more soft-spoken than some of my peers. It is tenacity nonetheless. I have represented fathers and mothers, lobster fishermen, lobster fisher women, business owners, doctors, juveniles, and those charged with serious crimes. I have represented parents who are threatened with the loss of their children in child protective proceedings, which are some of the hardest cases any lawyer can have. I have learned not to dance around difficult conversations with opposing counsel, that clients respect honesty and directness, even when faced with horrible consequences. I take pride that in most, if not all, of my cases, that I take the time to sit down with my clients in advance and say, this is what the courtroom looks like. This is where you're going to sit. This is what case management is. This is what the judge is likely to say. This is why you should not be bothered when opposing counsel says X, Y, or Z, or anything else that I can do to put my clients at ease prior to hearings. And I think that's an important skill set that I've developed that will serve me well as a judge. As a multi-branch business owner, I have come to learn the solemn responsibilities of employing other people. And I've learned to budget in times of growth and in times of recession in ways that value my employees. This year, having been especially difficult, it has been inspiring to me to see my colleagues and friends keep the lights on for so many months. Now, I hate to end on a more somber note, but I do feel compelled to do so. It has come to my attention recently that two gentlemen have submitted testimony, written testimony in opposition to my nomination today, and that they've raised concerns that I would like to address. There is significant context that I feel is crucial for this committee to have in order to evaluate that testimony. First, with regard to Mr. Robert Conlon Jr., I think it is important for this body to know that I have represented Mr. Conlon's ex-wife in various family matters over the past several years, including a highly contentious divorce, custody dispute, and several protection from abuse matters, including a hearing that led to a current protection order being put in place. Mr. Conlon has made his antipathy towards me known on several prior occasions, to the extent that I have asked for and received additional security at the courthouse at hearings. I absolutely dispute his characterizations of my ability to be impartial and fair. Next, with regards to other materials that have already been discussed to some degree, have been submitted by Mr. Kenneth Lindell Jr. Again, I think it's very important for this committee to have the necessary context in order to evaluate those submissions. I have rarely in my career shied away from difficult litigation. I have said yes to cases that others have turned away due to complexity and the level of acrimony. The matter involving Mr. Lindell, I think, is a prime example. Mr. Lindell has been criminally convicted for the multi-million-dollar theft from my client and others. When my client's sister called me to ask whether I would represent her brother, who is a disabled Vietnam veteran, in a civil suit against Mr. Lindell, who is a former legislator, I think many lawyers would have said thanks, but no thanks. Nonetheless, I felt compelled to take the case because I knew it had merit and because I desperately wanted to help this gentleman. Mr. Lindell sought to disqualify myself and my co-counsel from further representation of my client at one point in the litigation. As part of that effort, he raised concerns about a prior relationship that he had with an attorney in Belfast, with whom we were merging our practices with. While Mr. Lindell was not successful in having myself disqualified from that case, he did file a bar complaint with the Board of Bar Overseers, which resulted in a non-disciplinary warning advising Camden Law that we had to engage in screening efforts related to the Belfast attorney. I, along with my colleagues, took this extremely seriously and immediately complied with the screening procedures. It was, and I hearken back to some of my fellow nominees and their testimony with regards to mistakes made over the years, but I think it was a valuable lesson for our firm. And I think that we learned a lot about practice management and the complexity of merging a multi-attorney firm with a 40-year-old solo practitioner's practice in Belfast, especially when record keeping between the firms was incredibly different. I'm happy to answer any additional questions whatsoever about that case to the extent that I can, because it is still pending. But that issue that's been raised by prior questions and anything else. So I look forward to answering those questions. And again, I thank you all very much for your time and your thoughtful consideration today. Thank you.
Thank you very much, Ms. Gilbert. I would ask members of the committee if anyone has a question for Ms. Gilbert. Not seeing any hands raised up. Okay, now I'm seeing some hands. Representative Evangelos, you were first, so you may proceed.
Thank you, Madam Chair. And thank you for your testimony, Mrs. Gilbert. As part of our duties and responsibilities on the Judiciary Committee, we are required to do an exhaustive review when matters come to our attention, so I don't want you to take any of these matters personally. We have a job to do, and sometimes it's hard. I just want to be clear, did I just hear you saying that around the two individuals you just mentioned, that some of these matters are still pending?
Yes, in fact, Representative Evangelos, both matters are still pending. However, I have obviously withdrawn from both, but they are both active cases, yes.
So I guess I'm questioning a little bit whether you, if they're pending, whether you should have raised them.
I'm sorry, should have raised them as a matter of public record?
Well, if they're pending legal matters and you were subject to a sanction by this judge, I'm just wondering, I mean, I've always been told in this committee, if there's a pending legal issue, we're not allowed to talk about it. I wasn't aware there was anything pending.
No.
I can just provide some clarification here.
No, I didn't ask you the question, Senator.
I'm not aware of a rule that we can't ask about what you're referring to, but go ahead, Ms. Gill.
Certainly. So my understanding is that the committee, or at least certain people on this committee, have received a copy of the public trial court order, and that I felt compelled to discuss that, having it being a public record. Similarly with Mr. Conlon's matter, and again, this is a timely issue, but all of those pleadings are of course public. And when I was confronted with pretty serious allegations about my ability to be impartial, I do feel compelled to let this committee know publicly, at least, what's available for purposes of contextualizing those concerns. So I take very seriously the privacy of my own clients, obviously. But my understanding is that, well, it's more than that. I know that those pleadings are public. So I felt that you needed to be directed towards those public pleadings.
Thank you for that. I have a couple of additional questions, but I'll pass for now, Madam Chair.
Thank you for being so considerate. Representative Babbage, did you have a question?
Yes. It's the first time talking with this candidate, so there's a lot I'd like to talk about, but thank you, Madam Chair. Yes, as a product of Machias Memorial High School, I don't know if the name Cora Greer ever was relevant. She taught AP history there for years, and we taught together, but I think the world of her, and I know she had an influence on a lot of people. What I wanted to actually ask you had more to do when we talk about moving from private practice to the bench. And I did appreciate what was written in support of you, bringing honor to the bench. I thought was a pretty high statement. But you know, obviously, in your 10 years, you've had a lot of clients with various backgrounds, and you have advocated for their legal positions. You know, what we want to know, I think, as you go to the bench, will you carry biases with you? We all have biases. Have you represented people with whom you would not share attitudes or affiliations or whatever like that? And how do you see your role in going to the bench and being able to be impartial with regard to all kinds of people that will be coming before you?
Thank you for that question, Representative Babbage. I have never once that I can recall ever asked my clients what their political beliefs are or what their religion might be or something like that prior to agreeing to representing them. I have taken pride actually in the diversity of my practice. And I think, you know, folks that know me in court know that on one given day, I'm on one side of a particular type of case, and on the next given day, I'm on the other side of the case, generally speaking, at least with regards to family law, because that's what you do in a small town in particular. You know, you take what you can. I have no doubt whatsoever that when a black robe goes on, the judges in the state of Maine take their oath of impartiality seriously. I have had the benefit of having worked for the judiciary before, and I remember scraping a bumper sticker off of my old car in law school to go to work for the judiciary, because you cannot have those types of publicly represented persuasions or beliefs. And I take that very, very seriously. And I do today as well. I guess I just want to articulate that the legitimacy of the judiciary for me is paramount. And I care about that. I really care about that. And in recent years, I don't really want to go down any rabbit holes here, but it's hard for me to see the judiciary be delegitimized in any way due to allegations that judges can't be impartial. So I take that oath very seriously. And I know that the jurists that sit on the bench in Maine today do. And it's just too serious for me to feel otherwise. I hope that answered your question.
Thank you. I appreciate it.
Thank you, Representative Babbage. Senator Keim, did you have another question?
Thank you, Madam Chair. Yes, I do have a question. My first, I think, for the nominee. Welcome, Mrs. Gilbert. Thanks for being here and for your willingness to serve. One of the questions I have for you is just if you could tell us what you see as would be your biggest challenge for going from private practice to the law court, to the courts.
Thank you, Senator Keim, for that as well. I think there will be lots of challenges. I think I could say to you with certainty that being away from my family to be trained for a period of months will be very difficult. But I can also say that the learning curve associated with presiding over such an array of cases in district court is daunting. I do think that with family law and disclosure hearings and FEDs, all of that is sort of in my wheelhouse already. But I haven't practiced, criminal defense work for at least 6 or 7 years. And so I very much anticipate shadowing other judges and catching myself up to speed for bail hearings and for criminal trials. And so I do see that as a challenge, but otherwise I would be honored. This is something I would look forward to every day, getting up, going to work kind of a thing.
Thank you. And what do you see as your own biases that would be issues that you would have to overcome your own personal viewpoint on in order to judge fairly?
That is a very good question. My own personal biases. I know we all have them. I know a lot of them are on the surface and a lot of them are deeper, and a lot of people struggle to even recognize sort of the deep biases that they may hold. But I suppose wiping the slate clean every single time. I think there was a question asked actually of Magistrate Langner, and I think he was asked, if you do the same type of law over and over again every day, and you see the same people with the same types of things before you every day, is it difficult from a mental health perspective to keep your sanity and to make sure that you're judging everybody with fresh eyes? And I suppose I would answer your question, Senator Keim, by saying that I think that if you're a district court judge who's going to see folks struggling with mental illness and substance abuse and some really serious problems day in and day out, I think that all judges, including myself, would have to say, I haven't actually seen this before. This is a new person. This is a new case. They may look like the litigant that I had yesterday. They may act like the litigant that I had yesterday, but this is a brand new person with a completely different life. And so I would struggle with that. I think most judges do, but I have utmost confidence in myself to be able to do that because I do that with my clients every day.
Thank you.
I just wanted to check in with Representative Babbage. Is your hand up for another question? It is.
Yes.
Okay. Let me circle around to some folks who haven't asked questions, and then I'll come back to you.
Thank you.
Representative Moriarty, and then Representative Evangelos, and then Representative Babbage. Representative Moriarty, yeah, thanks.
Ms. Gilbert, is there a particular geographic vacancy on the bench that you anticipate filling if confirmed?
That I actually can't answer. I know that we have had several really prominent judges retire in recent years. I do know, I believe, I don't want to speak out of turn, but I do know that there are some vacancies, I believe, in my general radius, which is large where I live. I'm centrally located. But I would be honored to serve just about anywhere. Although maybe I see Magistrate Langner on the roads passing each other. I don't know, but I think, you know, I think Mid-Coast, as a lot of courts, I will say this as well, needs more judges. And I don't say that in a self-serving way. I just think that the people of Maine are struggling to get judge time right now. And it's very, very important, I think, for those seats to get filled timely.
Good, thank you.
And I think that I see Representative Poirier also has her hand raised, and she has not had an opportunity to ask a question, so I'll call on her next. Go ahead.
Thank you, Madam Chair. And thank you, Mrs. Gilbert, for being here. My question actually pertains to a publication from back in 2017 where you were quoted as saying, "I hate to say that judges give out protection orders like candy, but we have had a couple of terrible incidents of murder suicide in Maine, and the legislature has mandated that the protection from abuse statute be liberally construed." Can you explain that to us, please?
Sure. And I guess I just one other point of clarification is I believe that was from 2013. So I think it's roughly 8 or 9 years ago, but anyway, that's an interesting question. So I was asked by an academic who was doing a survey, basically, a national survey on what family law looks like on the ground in each particular state. And I don't know how he found me. And I certainly wasn't compensated for this, but he asked me a series of questions and hypotheticals about, so what's actually happening, you know, sort of in the trenches, if you will. And I tried to be as frank with him as I could be. Now, I certainly never meant to imply that judges are somehow, you know, unable to apply the law to the facts and are sort of giving out protection orders, you know, willy-nilly or otherwise derelicting their duties to be jurists. But when I answered that question, I think Maine had just suffered one of its worst examples of murder-suicide that I can recall. And it was a family that was murdered in Dexter, Maine. I don't know if anybody recalls it. And so what I was sensing at that time as a practitioner who often has represented and defended folks who have been accused of abuse, I sensed at that time that there was a greater awareness, I think, from the judges that I appeared before about the protection from abuse statutes and about how important it is to protect Mainers. And I can say that I have, again, been on both sides of this issue many times. I have had clients come to me wanting protection orders, and I've had to say to them, no, I will not represent you in that type of, with that type of fact pattern, because you are going to jeopardize receiving custody of your children if the court finds that you've abused that protection from abuse system. You know, and I've certainly been on the other side of cases where I've, you know, litigated a PFA hearing, believing in my heart of hearts that my client desperately needed a PFA, and she or he was unable to meet our evidentiary standard of proof. But I hope that answers your question. Protection from abuse cases are some of the most compelling and oftentimes time-limited hearings that you will ever have in court. Oftentimes you'll get 45 minutes to litigate something that's hugely important. And so the judges are forced to make decisions quickly. And I certainly never meant to imply that Maine judges, are somehow just giving these things out. So I hope that answers your question.
Thank you for the clarification.
Mm-hmm.
Did you have a follow-up, Representative Poirier?
I don't think.
Okay, I forget where I was. So I think Representative Evangelos, I believe you were next.
Thank you, Madam Chair. I get several more questions, and they're not contextual, so you can go on to someone else and you can come back to me. Sarah, on your questionnaire on page 14, have you ever been cited for a breach of ethics? You answered no. And I asked the governor's representative if, since some of the issues that had come forward to the committee members, whether you had amended your questionnaire, and the answer was no. But clearly the answer to that question would have been yes, right?
Well, so actually I went back and looked, and the imputed conflict issue that you've asked me about actually happened after I filled out that application. So I did my best to be as accurate at that time as possible. And I was not asked to supplement it, although I will say that the last paragraph of my application is a complete authorization for the Judicial Selection Committee to obtain anything and everything that they could possibly want from the Board of Bar Overseers. So I assumed that they had done so, and I was actually copied on correspondence early in January, where I believe that the record of the dismissed complaints was actually sought from the Board of Bar Overseers. And again, I assumed that had happened, but I certainly have absolutely no qualms whatsoever discussing that. And I can echo that family law being what it is, as personalized as it can be for many litigants, I can echo that it is not, based on my own knowledge, unusual to be the recipient of a Board of Bar complaint following a contested proceeding.
Right. I see that the questionnaire was dated in October, and the judge's ruling was in December. But after the matter came to the attention of the officials working for the governor, you weren't advised to make an amended application so we could get an accurate answer to that question?
I was not advised to amend anything, although again, I believed that that my entire record of these complaints had been received and probably circulated. It came to my attention fairly recently that for whatever reason that hadn't happened, which is why I took care as quickly as I could to get back in touch with the Board of Bar Overseers directly myself to ensure that you all received that that letter with the list. So.
Thank you. I'll wait my turn, Madam Chair.
Thank you. Representative Babbage, did you have another question?
Yes, Madam Chair. I think I'm satisfied with that line of questioning. I wanted to go to the resume, Sarah, Ms. Gilbert. You had an opportunity to clerk with Donald Alexander, Justice Alexander, who wrote the Manual of Civil Procedure and instructions for juries, and had been all through the court system as not even including the 22 years in the law court. So I just want to know, at that time in your life, what kind of an influence was that on you being where you are today?
Thank you. It was hugely impactful. If you can imagine going from academia with no legal experience at all and being tossed into the highest court in the state, with the expectation being that you're going to research and actually make recommendations on cases that are, on murder appeals and on every sort of appeal that goes directly to the law court. Let me put it this way, it was an incredible confidence boost for me. And the other thing that I can say about working specifically with Justice Alexander is that he made me feel that being from Machias was a good thing. It's a good thing to be from down East Maine. And I know he spent a lot of time up there as a trial judge over the years. And he very much, I believe anyway, enjoys being up in that area and enjoys working with the people up there. So to have him select me as a law clerk injected me with some energy and passion to go out and pursue my dreams in a way that I'm not sure would have happened if I had worked for anybody else. So hugely impactful.
Thank you.
I see that Senator Keim and Representative Evangelos both have questions. Representative Evangelos, are you all set, or?
No, I have some further questions, but it's Senator Keim's turn.
Okay. Are you deferring to Senator Keim? Is that what you just said?
Yes, I am, but I have some questions, but it's her turn.
Okay, you may proceed, Senator Keim.
Thank you, Madam Chair. I just so you're aware, I do have more questions than this one, but I recognize that you want to bounce back and forth, so I'll ask just one. Mrs. Gilbert, recognizing that attorneys, as we just had the conversation around protection from abuse orders, recognizing that attorneys and their clients will use that to the advantage of their situation rather than always on solid fact. How will you use your knowledge of that to ascertain the truth in these situations?
Yeah, thank you for that as well, Senator Keim. I think that is hugely difficult for district court judges. And I think that this is the reason why trial lawyers make very good judges. I have had to assess the credibility of my own clients over the years. And the credibility of opposing parties in ways that it's a skill. It's very much a skill. And it's, you know, I look back on my early years as an attorney, and I think I fell for some stuff from my own clients that I shouldn't have. And I have developed the ability, at least in some part as an experienced trial lawyer, to call a spade when I have to. And I think that will serve me well in district court, because I have seen, and I think I've already talked about this a little bit, but I have seen folks misuse the PFA process. And it's important that that be recognized as well. I mean, obviously the survivors of domestic violence need protection, but if you haven't had a lot of time in court with the back and forth cross-examinations, you know, and the impeachment exhibits that are pulled out, you know, halfway through the hearing and things like that. If you don't know how to vet the parties, you know, as a trial lawyer, it would be very difficult to step in that role as a judge, I think. And I've been fortunate enough to have those vetting skills developed over the years, and I think they would serve me well.
Thank you.
Representative Evangelos, you may ask a question.
Thank you, Madam Chair. I only have 2 questions remaining.
Okay, go ahead and ask them both then. Thank you.
Okay, thanks. Mrs. Gilbert, one of the questions I had, and I have no information or proof to corroborate any of this, but some folks contacted me regarding a Facebook page you may once have had. And so the first question is, did you have a Facebook page?
I think like a lot of folks, had sort of a love-hate relationship with social media over my adult life. So I have used Facebook in the past. I have also taken significant breaks from it for my own sanity and being bombarded with information constantly. But yes, to answer your question directly, yes, I have used Facebook.
So the uncorroborated allegations were that, you know, in the heated political environment the country was in, you were making certain remarks regarding, you know, partisan things. And I just wanted to know when you deleted the Facebook page.
Let's see. So I used Facebook throughout law school, and I think the early part of my career. And then I deactivated it for a period of time, like I mentioned, and I think I was not actively using any social media at all when I filled out my application for the judicial appointment. And then I think think I want to say a half a year maybe after I had applied. I think I missed seeing some photographs of my family members and things like that. So I reactivated it sometime in 2020. And then of course, when I was called to be notified that I was a candidate, so to speak, and that I was being considered for an appointment, I thought to myself, there's just no need of this anymore. There's no need of me to use this platform. And I have young children who I would like to respect their privacy and my family members' privacy. And I thought, if there's going to be a chance that I am a public official, so to speak, it's time to get rid of this, which I did. And I want to say I deactivated or deleted everything in late November of this past year, so 2020 perhaps.
Would you be able to reproduce that for the committee to review?
I don't think I could. My answer to that question is that I took steps to get rid of everything, and I am certainly not a tech-savvy individual, but my understanding is when you delete your social media history, it is deleted. Now, to the extent that there's anything publicly available, obviously, that would be publicly available.
Madam Chair, may I do a follow-up just on this topic, and then I'll wait on my last question?
Actually, I think you should finish up your questions right now so that we can move on to Senator Kine. So continue, please.
Mrs. Gilbert, was there any posts you made on Facebook that would raise concerns about, your ability to be fair? I know the country was in a heated political environment, but this is what I've been told. I told the people to send me the information, and they're not able to produce it because the Facebook page doesn't exist anymore. So I'm just going to have to ask you, were you involved in some heated political discussions on Facebook that would have raised some questions?
Not to my knowledge. So I took whatever steps I could to privatize anything that I would put on there, so to speak. So I always considered my Facebook postings to be the equivalent of the Thanksgiving table, with friends and family in terms of debating timely issues. I want to be forthright. I mean, I have certainly felt compelled over the years as an adult and as a private citizen to speak out on issues that I felt passionately about, whether that's women's rights or the rights of veterans, for example. So I have certainly commented over the years on those topics. Whether or not they were heated, I couldn't say. But I never, to my knowledge, would have posted anything as a private citizen that could call into question my impartiality as a jurist. But again, I think the judicial canon, I think it's canon number 5, specifically states that judges in Maine aren't to have any public, politically, I forget the exact wording, but it's basically aren't to have political personas that could compromise the impartiality of the judicial system. So to the extent anything out there would have been a public, iteration of what my beliefs might be, I think it's in keeping, or at least best practice, with the judicial canon to have removed that material as soon as I became a formal candidate.
So the concerns that were expressed to me were around some comments you made about, and I'm not a Republican, but the concerns that were expressed to me were commentary you were making about certain Republicans in the country, and that's what's raised the questions about, your ability to be fair. Had you made, remarks about Republicans, certain members of the Republican Party?
I'm sure it's a possibility. Again, any remarks I would have made, I believe, would have been something to my friends and family only about probably members of both parties, across the aisle. But I would echo your sentiment that it's been a very, interesting set of years here, and I think I felt compelled to be engaged as a citizen. I think I felt compelled at certain points to speak. So yes, it's probably a possibility that I have criticized politicians from both parties over the years.
Okay. And my only one more quick question regarding the book that Representative Poirier raised, and I assume that those quotes in the book are accurate.
I think so. Like I said, it's been 8 years or so, and I talked to that fellow for a while. So, you know, there's probably context that could be added, but I have no reason to dispute that those quotes are accurate.
So the reason I'm raising this is the last session, Representative Cardone raised some issues about the ability of indigent people to be able to participate in our civil legal system. And as you're well aware, we're now dealing with that on the criminal judicial side as well with the Sixth Amendment Senate report. But there is a quote in here that had me a little concerned. And it says, if your clients aren't particularly well off, it can be a waste of money because the final hearing will be 3 to 4 months after you finally get a date for the interim order. And, you know, Rule 6.1 of the professional standard says every lawyer has a professional responsibility to provide legal services to those unable to pay. So I'm a little concerned about that remark. It seems that you may have had a separate standard for poor people.
No, my only sentiment in that comment, Representative Evangelos, was that my concern at that time, and it's been alleviated to some degree now, but it used to be very, very difficult for represented or unrepresented parties to get interim relief in family cases, whether it was interim child support or interim spousal support or what have you. And so my comment was with regards, it sounds like with regards to a represented party, right, in that instance, was that it didn't make much sense back in those days to seek an interim hearing on those support issues, because it would take a significant amount of time to get an interim hearing, after which you're going to have a final divorce trial, say 2 or 3 months after that. So it would be like trying the same case twice. And that was my frustration with the process at that point. And it's actually been corrected to a large degree through the use of magistrates. I mean, they've really, the system has been improved drastically in that regard. And you can get interim and child and spousal support fairly quickly now through the use of magistrates. But I would certainly never have a separate standard for indigent litigants. And I have taken pride in my pro bono work over the years, certainly, and was honored to be presented with the Katahdin Council award for having provided a certain number of hours pro bono to Mainers. So.
Okay, thank you. Just lastly, circling back to the Facebook question, you're not able to be more specific about things that you may have said that have raised these objections, or because that's been a cause for concern of people that have contacted me, admittedly from perhaps the opposite side politically that you and I may stand on, but that doesn't mean that their concerns are not legitimate, because my job is to be fair to everybody. And you seem to remember a little bit about them, but do you want to elaborate on something you may have said that has these people concerned? Or?
Representative Evangelos, can I just, I'm sorry to interrupt your question, but I'm having a very hard time following you. Are these people who have weighed in any way on this nomination? Have they provided any written testimony, or have they signed up to provide oral testimony here today?
There are people who have contacted me via telephone expressing concerns on the nominee, and they expressed concerns about the content of her Facebook comments. So I'm trying to gain clarification as to why they were concerned.
Yeah, it would have been ideal for them to participate in the process, because there's multiple chains of miscommunication, but thank you for clarifying.
Well, it may have been also ideal. It may have been ideal if the Facebook page hadn't been scrubbed, so we could look at the concerns and read them for ourselves. And, you know, Senator Carney, in all due respect, I signed a complaint recently regarding the Capitol Police Chief around postings he was making, because I try to be fair and deliberative in my actions. So I'm just being consistent here. It's a legitimate question, she seemed to remember some things that may have been things that she may have regretted to say and may have been a cause to scrub the page. So I think it's a legitimate line of inquiry.
Well, the police chief was a current office holder at the time, and I just leave it at that and let Ms. Gilbert answer your questions. Go ahead if you can, Ms. Gilbert.
Certainly. And I suppose it is quite difficult for me because I have had Facebook for years, and without knowing who those folks are, what they might have read, or I couldn't tell you with any specificity, what might concern them. I can testify today that I've never posted anything to my knowledge that would jeopardize my impartiality on the bench. And I guess I don't want to be semantic about this, but I do take issue with sort of this idea that I've scrubbed things. I think it's important for me, like I mentioned, for purposes of the judicial canons, not to have a public political persona if appointed. So I take that very seriously, and I feel like I did what was appropriate of me as a candidate.
Right. You took your Facebook page down in November. I believe that's what you told us.
Yes, that's my recollection.
Thank
you. Thank you, Representative Evangelos. Senator Keim, did you have a follow-up question?
Yes, thank you, Senator Carney. Ms. Gilbert, so just following up on the Facebook questions. So you said late November you were called and told you were being considered. Is that right?
I mean, more or less. I was. I think that was around the time frame where I was informed I would be interviewed. So I suppose, I in my mind at least, that meant I was being considered. I don't know how many folks were interviewed, but that's how I construed it.
And at that time, did anyone suggest to you that you should take down your Facebook page?
No, I had private conversations with my husband about the need to protect our family's privacy, I think, at one point. But other than speaking with him, I've spoken to nobody about this.
One of the things, obviously, that just makes sort of the nature of this type of confirmation, of course, is that people tend to be reluctant to speak out in opposition. And I think that's something that this committee is aware of. I certainly am, just because if you are nominated and confirmed, then you'll be a judge. And if someone comes in front of you and they've spoken out against your nomination, that puts them in a really difficult position. And I think that's why we are seeking to, get at information that people feel uncomfortable bringing forward. So thank you for your answers.
Yeah, absolutely. It's not a problem for me. And I might just add that I have extended family of very different political persuasions, and love and respect my friends and colleagues who have very different political views than I may have had in the past. Yeah.
Representative Harnett, I see your physical hand raised. Go ahead.
That's all I have working today is my physical hand. Point of order, Senator Carney. I think that these are legitimate lines of questioning, but I think the nominee is being put in an impossible position of saying, I've heard something from somebody saying they did not like something that was on Facebook, without any explanation about what we're talking about. And the nominee has answered question after question about what she has put on Facebook, what she remembers she put on Facebook. And I think you're trying to disprove a negative. Nobody's come forward with a single piece or a single post that somebody's complained about. So I don't see where this questioning gets to the qualifications of Ms. Gilbert for the position of a judge in the district court. So I would hope that we're at the end, because it's not enough to say I heard from somebody that they didn't tell me what it was, that there might have been something that bothers me. I don't know how one defends or explains that away in any more way than this nominee has already done.
Yeah, thank you for raising the point of order. And I would agree with you that the questions about the Facebook account have been asked and answered. I mean, this nominee has told us that she, when she realized that her her application to be considered for a judgeship went forward, she had concerns about the safety of her children and took down the Facebook page for that purpose. I can, as a lawyer who had an active litigation practice when my children were small, I can understand and appreciate your concerns about the safety of your kids, given how much conflict there is being a litigator. And yeah, I will grant your point of order, Representative Harnett. I see that I thought, Representative Evangelos, that you had completed your questions, but do you have another question?
Yes, I wanted to respond to Representative Harnett in all due respect.
I'm sorry to interrupt you. Are you disagreeing with are you wishing to proceed with additional questions about Facebook, or are you simply disagreeing with something that Representative Harnett said? Because I think that it's really important for us to use our time today to focus not on whether we agree or disagree with each other, but really on the qualifications of this candidate.
Yes, Senator, you granted his point of order, and I want to explain that when I
Are you making a motion to overrule the point of order?
I just want to explain that when I went to look for the evidence to back up these claims, it wasn't there. The people were somewhat specific, but it involved things I don't want to repeat here because I'm not able to provide the proof. It was what they told me. It involved some profanities. I'm not going to repeat them, but I can't corroborate or substantiate it because the page is gone. But it's a legitimate line of inquiry, and that's all I wanted to say.
I actually wanted to ask you a follow-up question, Ms. Gilbert. So you said that you have been threatened in the context of the work that you've done as an attorney, to the point where you at times had to have extra security in the courtrooms where you work?
Yes, that is correct. That has happened on more than one occasion, in family matters primarily.
And you've actually used the protective order process to get an order to protect yourself as well. Is that correct?
No, and I hopefully I didn't speak out of turn. But what I meant was I have attended many a family hearing that is so contested that I, on behalf of myself, have had to go to the judicial marshals at the beginning of the day and ask to be escorted to my car or to be escorted to the courthouse because of threats that have been levied at me by opposing parties, either directly or indirectly. I have had other colleagues who are similarly situated as family litigators who have experienced similar things in the course of their careers, including having nails put in vehicles and the tires of vehicles and parking lots and things of that nature. So to your point, Senator Carney, I do take the safety of my family very seriously, and protecting our privacy is paramount for me. If I were to be confirmed as a judge, that would be on my mind. So I hope that answers your question.
It does. And then I have an unrelated question, but you referred to the Katahdin Recognition Program, which I also participated in. And I was wondering if you could explain to us a little bit more what that program is and the pro bono work that you did to qualify for recognition.
Thank you for that. So the Katahdin Council is a symbolic award. Maybe it's more than that, but it's a symbolic award that's given to attorneys in the state of Maine who have provided a certain substantial amount of pro bono representation and to Mainers, basically. And I sought very much to be a part of the Katahdin Council. And I, in particular, am thinking of at least two cases that were in excess of a year and a half to 2 years long, that involved one of them, at least I think I wrote about in my application that hopefully has been provided, but it involved a woman who needed help severing her ties from an abusive partner, and she was a beneficiary of TANF benefits. So there was this inherent conflict. In that case, it ended up going to the law court. So I did the law court appeal and oral argument pro bono as well. But that type of representation is not unusual for me. And I will say that my colleagues in Midcoast, Maine, I can't think, I mean, there are so many occasions where my colleagues, whether it's guardian ad litem work, divorce work, criminal defense, do the work for free. And that's great. That's what makes practicing in Maine, so rewarding, and we all do it. And when I meant in my opening, growing up in Washington County made me feel like we're all in this together. I have experienced that as part of the legal community in Maine as well. And I think most of us truly feel that way. If we can do some good, we will. I mean, there are limited hours in the day. And certainly I like spending time with my husband occasionally, but I do as much pro bono work as I can.
Thank you very much. Committee members, I know we've been asking Ms. Gilbert for questions for quite a very long time, and I just wanted to make sure there weren't any other questions, but it appears that there are. Representative Babbage, is there a new area of inquiry that you wanted to?
There is.
Okay.
Thank you very much, Madam Chair. No, I just wanted to thank the candidate for the questionnaire. I'm looking for you to be impartial, whether it's a young woman of color with a BLM hat or an older white male with a MAGA hat. Your commitment to justice is what I was looking for, and your answers have been satisfactory to me. Your application, you addressed that impartiality in a couple of questions, and I appreciated the supplemental testimony that you gave to give me an idea of where you're at. And I love the fact that you have a Washington County background and went to Vassar. One of my students, Brenna Graben, was at Vassar, and I think at the same time. I also wanted to I wanted you to know that I started the mock trial program at Kennebunk High School in '94 and advised it for 8 years. And to this day, despite all the things that I've done in my life, my keychain is a Maine mock trial semifinalist, which we're very proud of with that group of people. And I love the idea that we have a mock trial participant that is now before us to be a district court judge. So that's wonderful to me. So thank you for your responses today.
Thank you very much for that. And just quickly, out of a class of 36 at Machias High School, and I give all the credit to the mock trial program, I think my class produced something like 4 or 5 attorneys. So it's an incredible, incredible program for high school students.
Thank you very much, Ms. Gilbert. So I'm looking at committee members. Are there any final questions? Representative Harnett?
Thank you, Madam Chair, and I don't mean to prolong this. Believe me, I just want to, we've covered a lot of ground here, and I just want to make sure that certain things are very clear. Ms. Gilbert, number one, you have never been formally disciplined by the Board of Bar Overseers. Is that correct?
That's correct.
You have never been found to be in violation of any bar rules or codes by the Board of Bar Overseers. Is that correct?
That I would add some context to, because the imputation of conflict issue, which is that rule 1.10, Camden law was found to not be in compliance with a screening procedure, which is what again led to the private correction letter that was sent to me. So I guess I would want to be clear about that, but it did not result in discipline, and Justice Duddy found that it had created actually, I believe his phrase was, no actual prejudice to anybody.
Again, I'm sorry, my point was that was a private letter of warning. And you said that became a learning experience. It was about an internal policy about dealing with conflicts as a merger was going on, that you considered that a learning lesson. and that you took steps to make sure that you corrected what was pointed out to you that may have been done in error. Is that a fair assessment?
Yes, absolutely. My law partners and I did just that.
Thank you. Nothing further, Madam Chair.
Thank you. Representative Libby, did you have another question?
Yes, thank you, Madam Chair, and thank you, Ms. Gilbert. I suspect this is a quite elementary question, but bear with me. When you're speaking of the screening procedure, can you explain that to those of us that are newbies to law, please?
Sure, I'm happy to do so, and I'm particularly well versed in it. I can assure you that is for sure. So normally when there is a conflict, so lawyers owe a duty of responsibility to former clients. So in other words, you can't be adverse to a former client unless your former client has given express written consent, basically, for you to take on a matter at which your former client is going to be an adverse party. And there are some nuances to it, but that's the basic premise. So the particular rule that affected Camden Law was that we were merging with an attorney in Belfast who had a 40-year solo practice as a real estate attorney. And he had 40 years worth of physical files in his basement. And so as part of the merger, we were tasked with going through all of those files and inputting into our digital system so we could run proper conflict checks and make sure that we were in full compliance. And so when we merged with this attorney in Belfast, all of his former clients became imputed to us. They suddenly became our former clients because of the fact that we had merged. And so in order for us to remain as counsel in that particular case, we were required to screen out that Belfast attorney by not allowing him to have any access to, or to have his staff have any access to or knowledge about our representation. It was sort of like a wall, a symbolic wall that goes up that prevents that from happening so that you're in compliance with the rule. So his former representation had become imputed to us, and that was why we had to screen him. So I hope that makes sense. And we brought ourselves into full compliance with that screening as soon as we needed to do so. We're told to do so, basically. And there are some nuances there, but that's the general premise. And I do hope that answers your question.
Yes, I just have one follow-up now that you've explained that so thoroughly. Thank you. One follow-up, Madam Chair, if that's okay.
Yes, go ahead.
Thank you. So with the screening process, I just wonder how that ties in with, as you said, you'd have a client on one side of one issue and then the next day a client on the other side of that issue. How does that work?
So thank you for asking that, because when I said that earlier, I thought, wow, that might be misconstrued. What I meant by that was, so particularly in family law, one day you might be representing the spouse who's been accused of violence. And in a different case, the next day, you might be representing the spouse who says that he or she was the victim of violence. So you're on both sides of cases from an ideological perspective all the time in family court. Sometimes you represent the party in a divorce who's the breadwinner. And then the very next day, you're on a different case where you're representing the client who has been a homemaker for 35 years and has no income stream. So in that way, I have been, like you say, on both sides of these cases many, 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 many times, not to say that those are directly adverse people. I was talking about generalities in terms of categories. You could never be directly adverse to somebody that you just represented the day before. I hope that's true.
Yes, thank you for clarifying that.
Thank you very much. So members of the committee, it looks like I don't see any additional questions. Thank you everyone for your questions, and Ms. Gilbert, thank you so much for all of your answers. We do have about 10 or so members of the public who would like to provide information to us today. And I would like to know, I'll ask you first, Ms. Gilbert, would you like a 5-minute break? We are done with questioning you at this point. So
I am happy to proceed, Senator Carney, if that's the pleasure of the committee. I'm fine.
Okay, are committee members able to move forward with this group of 10 people? If you are not comfortable moving forward, please raise your hand. Okay, it looks like there are a couple of people who would like to take a 5-minute break. So at this point, we will thank you very much, Ms. Gilbert. And when we resume, I will recognize people wishing to testify in support of the nomination. So it is almost 5:20. We'll come back at 5:25, please. Thank you, everyone.
Thank you.
And please remember to mute and stop your video because the live stream will continue.
I think we have on your list, the first three after the nominee. I don't believe they're in the attendee.
Okay.
We have a phone number and they're not I don't know who it is.
Okay, they may log back in at 5:30. I'll go through the list and then I think what I'll do is.
I moved over Senator Cates because he would have been next in line after Chris Largay.
Thank you very much. And I'll check the attendee list as we proceed to see if people have rejoined. Thank you.
There he is with the beard. Senator.
Witness Protection Program, Senator.
Are you at home right now?
I am.
He lives in my hometown, you know. He moved to my town.
Oh, nice.
You're only a couple of blocks away.
That I didn't know.
Yes, I'm on McGeehan. You know where Warmings is?
Yes, of course.
Right down that street.
Oh, nice. Great.
See, we're neighbors.
Wow, see you on the road. Nice to see you.
Always good to see you too. Bye.
All right, committee members, if you are back, please turn on your cameras and we'll proceed. I'm glad the sentiment was that we take a 5-minute break. That felt really good. I hope everybody's ready to conclude the hearing. So the hearing on the nomination of Ms. Sarah Gilbert for a district court judgeship will continue. With statements from the floor. The chair will now take comments from persons attending this hearing who wish to speak for or against this nomination. Anyone who has a written statement but who does not wish to speak should have submitted the statement with the committee clerk prior to today's hearing. All such statements shall contain the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee in this hearing will be made available to the nominee upon his or her request prior to the committee's vote, and the nominee will have an opportunity to respond to the written comment. And I'll just check in with our committee clerk and ask if all of the written statements have been provided.
Yes, they have, Madam Chair.
Thank you very much. Those who wish to speak in person registered with the committee clerk prior to the start of the hearing and will be called upon by the chair, at which time they will be promoted to panelist status in Zoom and can be seen and heard. When it is your turn to speak, please observe the following. State your name and place of residence prior to presenting your testimony. Only comments concerning the suitability of this particular nominee for this particular position will be considered in order. All other comments will be considered out of order. After you are done speaking and there are no more questions from members of the committee, you will be returned to attendee status and the next person will be called. So at this point, we have a number of people who wish to testify in support of the nominee, beginning with Mr. Roger. And my apologies, is your last name Katz or Cates?
It's Cates, Senator. Thank you.
All right. Thank you. You may proceed, Mr. Cates.
Thank you very much, Senator and Senator Carney and Representative Harnett and distinguished members of the Committee on Judiciary. My name is Roger Cates. I live now in Brunswick. I practice law in Augusta, and I am here to enthusiastically support the nomination of Sarah Gilbert of Hope to a position on the Maine District Court. As a proud member, a former member of this body, it's a pleasure and honor to be back with you and to see many of my former colleagues on this committee. I miss you. Senator, I've known Sarah Gilbert since shortly after she began practice in 2010. Both of us do a substantial amount of family law in our practice, and we have been on opposite sides of several cases over the years, including one as recently as this past year. In addition to my own experience with her, I can share with you a dirty little secret about lawyers. They talk a lot about each other, in the corridors of the court, on the phone, and practice. And what do you think of this lawyer? Or how can I deal with him? Or how can I deal with her? And I must tell you that the lawyer talk about Sarah Gilbert is very, very positive. Her reputation, not only in the Rockland Camden area, but statewide as well. I think, as all of you know, at a minimum, and I mean a minimum, a judge must be bright, well-versed in the law, a good speaker, and a better writer. Sarah, I think, checks all those boxes without any question. She writes clearly and succinctly and speaks in the same manner. But even more important for a district court judge, particularly, are some other qualities. And as all of you know, you've heard it referred to different ways, but the district court really is the people's court. On any given day, a district court judge may deal with several dozen different people day after day, and many of them will be pro se, representing themselves and unfamiliar with all of the settings of the setting of the courtroom or the myriad procedures of our law. Emotions often run high, and people are not always at their best. Often there's a winner and a loser at the end. Many people leave the courtroom disappointed and unhappy with the result. That's inevitable. But what is important in every single case is that people leave feeling that they have been treated fairly and respectfully, that the judge has really listened to them, and that the judge has explained the reason for his or her decision in terms that they can understand. By the way, lawyers want the same thing. Frankly, that doesn't always happen, but I have no doubt that Sarah Gilbert will be a considerate, empathetic, and yet firm judge. I know this because I've dealt with Sarah in the role of an adversary. She always did a fine job for her client, but she treated opposing counsel and opposing clients with respect and dignity, just as she did with the judge, even as she vigorously advocated for the position of her own client. Increasingly, our system has encouraged litigants to participate in judicial settlement conferences in contested cases. And I know Sarah will shine in that role because I've seen her willingness to listen and look for creative solutions in the matters I've mediated with her as opposing counsel. Particularly where kids are involved, a contested hearing should absolutely be a last resort. And again, the skills of a mediator are increasingly important skills of a judge. Sarah understands this and is uniquely qualified by her experience to do well in that role. I suspect that the people who will be unhappy with her appointment will foremost be her former law partners who will lose a trusted colleague. I commend Governor Mills for this appointment, and I hope she'll have your enthusiastic support. She'll be a star on the bench. Thank you, Senator.
Thank you very much, Mr. Cates. Are there any questions for Mr. Cates? I see Representative Libby has a question. You may proceed.
I apologize. This is actually not a question for Mr. Cates. Madam Chair, there's a second Sarah Gilbert at the bottom of it. Never mind. I think Supi has rectified the issue.
Always one step ahead of us. Thank you. Are there questions on the part of committee members for Mr. Cates? I am not seeing any. Thank you very much for presenting today.
Thank you very much.
I believe the next person is Cheryl Ayer, and she has just joined us. Ms. Ayer, you may unmute and also activate your video, please. It's nice to see you. Welcome to the committee, and you may proceed.
Thank you, Chairperson Carney and Chairperson Harnett and the members of the Judiciary Committee. I'm really happy to be here today to speak on behalf of Sarah Gilbert's nomination for District Court Judge in the state of Maine. I've been a practicing attorney in my native state of Maine since 1999. And for the past 16 years, I have been the staff attorney at the Rockland office of the New Hope for Women, which is the domestic violence project that covers Knox, Lincoln, Waldo, and Saginaw counties. And for the last 11 years, I've gotten to know Sarah professionally since she came on the scene. My cases always involve domestic violence, and primarily I do protection order hearings for people. And occasionally I take a family matter if someone really needs a lawyer and I have the time. I'll open my practice up for that. But when I wasn't able to help someone that I was really sure needed a really good lawyer, I would, in Sarah's coverage area, mostly Knox County, I would recommend them to Sarah Gilbert because she is one of the best lawyers I've ever known and practiced with. She is knowledgeable, she's fair, she's always prepared. If you have a case and Sarah is on the opposite side, you're gonna do your homework because you know she has. And she's, like I said, she's fair. I think the word that comes to mind when I think of Sarah is equanimity. She's reasonable, she's poised, she's always fair. I agree with Attorney Cates 100% about that. She's respectful to my clients, you know, and I could send anyone over to her and I knew that she would not be judgmental. No matter what kind of situation they found themselves in, she would meet people where they are. And I always got feedback from people that I sent to her that she had done a great job. And even if it wasn't a family matter, if I just got a question from somebody about who's a good this or that real estate lawyer or anything, any kind of litigation too, I would send them over to Sarah. And if I had a client who didn't have two nickels to rub together and she needed a lawyer on a protection order day and I couldn't do it, I would call Sarah and say, look, you know, can we strike a deal on your fee? You know, I would ask my client, can you scrape together $100? And if she couldn't, or he, I had plenty of male clients, the agency would strike a deal with Sarah to do something for less. And I really, really appreciated that because I know she works hard and they have a hardworking practice where she was. And she needs to pay the rent as well and make the nut. So, and she's always, in dealing with her, she's measured and thoughtful. She, as an example, I have a good example. A couple of years ago, she was handling a case for me at Rockland District Court, and she was representing a victim, and an alleged abuser was giving her kind of a hard time. I wasn't there, but my assistant came home and reported this to me. And he was giving her such a hard time, and she was really staying fair. And he eventually ended up throwing a pile of papers at her right in the hallway in the courthouse. And my assistant was just so impressed. She said, Sarah just kept her cool. She picked up the papers and kept doing what she needed to be doing. And I thought that was really impressive. I've also seen Sarah speak at a rural justice conference a couple of years ago, maybe now. And it showed me that she's really concerned about rural justice and the issues that face people uniquely here in the state of Maine. And so for those reasons, I think it's going to be a loss for the bar and a huge gain for the bench in the state of Maine. I don't think that's about it. Do you have any questions?
Thank you very much, Ms. Eyre. Do any committee members have questions for Ms. Eyre? I am not seeing any hands raised. Thank you very much. We appreciate you being here today.
Thank you.
Christopher McLean, you have joined us in the electronic meeting, and you may go ahead and proceed. Thank you.
Well, thank you, Senator Carney and Representative Harnett. My name is Chris McLean. I'm from Camden. And for the last 10 years or so, I've been Sarah Gilbert's law partner in Camden at Camden Law. I remember practicing law in Camden about 10 years ago when I got a call from Sarah Gilbert. She was looking for a job. I think Justice Alexander had suggested she give me a call. I've known Justice Alexander for many, many years. She was looking to come work in Camden, and I thought she was a good prospect, so I brought her into the firm at that time. I could see from the very beginning that she had all the qualities of a lawyer that I would consider a rock star. She was great with people. She was smart. She was ethical, hardworking, and the kind of law partner that any other lawyer would want to have in the practice. So as Roger Cates just said a few minutes ago, I'm probably among the people out there who are disappointed with the loss of her from the bar. And but I can tell the committee that Sarah Gilbert will be an amazing judge. In fact, I've told her this, and I'll tell all of you that I really see Sarah Gilbert as a judge who will eventually make it up to the law court and will be representing the judicial interests in Maine for many, many years to come. I could go on for a long time. I know you have all been considering this application and listening to testimony and debating amongst yourselves. I'd be happy to answer any questions. But I know Sarah Gilbert very well, having lived the trials and tribulations along with her in the practice of law. It's not easy doing that kind of practice of law that she's been doing for the last 10 years. You know, I'll make a couple of just observations. First of all, there is a real danger of people out there for our families and ourselves. It's a high risk profession. We haven't seen a lot of it in Maine, but a lot of lawyers end up getting shot and killed and certainly threatened. In my own experience in the last 25 years, I've had a number of death threats myself. I've had people allude to threats against my own children, and people have threatened to burn down my house, and many people have filed bar complaints against me as well. And it really is just part of the nature of the beast. It's part of the practice. But those of us that do it understand it's part of the profession. So I've walked the same walk that Sarah Gilbert's been down as well. And I can certainly understand the desire on her part to protect her privacy and shut down that Facebook page when she did. But I give Sarah Gilbert my wholehearted endorsement. The committee is considering an applicant here who really not only was a rock star as an attorney, but will be a rock star on the bench. Just so smart, so good with people, such a varied background, has experienced all the different kinds of law that she's going to see as a district court judge. And I have no doubt that she'll be appearing in front of this committee in the future to move up to the Superior Court bench and eventually to the law court. And I'm going to enjoy watching her career now as a judicial officer in Maine as much as I've enjoyed watching her career as a lawyer for the last decade. I'd be happy to answer any questions if there are any.
Thank you very much, Mr. McLean. Do members of the committee have any questions for Mr. McLean? I'm doing a quick scan. I don't see any real or virtual hands up. So thank you very much, Mr. McLean, for coming and speaking to the committee today.
It's my pleasure. Thank you.
And the next person here to speak on behalf of the nominee is Tina Nadeau. And Tina, you may start your video and unmute yourself and proceed when you're ready.
Thank you very much, Senator Carney and Chair Harnett and the other members of the Joint Standing Committee on Judiciary. It is my absolute pleasure to encourage your committee to recommend to the Maine Senate the confirmation of Attorney Sarah Gilbert as a district court judge. My name is Tina Nadeau. I'm sorry, for those of you who don't know me. I practice criminal law in Portland, and I live in Westbrook. I'm speaking on behalf of myself and not the Maine Association of Criminal Defense Lawyers, and I think that's pretty clear. Or it will be clear at the end of my testimony, at least. I've known Sarah for nearly 14 years. She was my assigned mentor, my torts teaching assistant and constitutional law teaching assistant during my first year of law school, all the way back in 2007. Sarah soon became my best friend. Sarah's humor and warmth were so welcoming to a non-traditional student like me who struggled with the transition from real life back to academia. Sarah grew up in Machias with a firebrand mother who was the local Down East attorney, consistently took on the old boys club on a daily basis. I grew up in Madawaska, raised by a similarly fierce single mother. I went to Bowdoin, Sarah went to Vassar. We certainly bonded over our similar backgrounds. I think growing up in those rural areas of Maine have influenced our worldview, both of us, and our senses of justice and fairness. I know that Sarah is and has been and always will be deeply committed to both justice and fairness. Sarah was an incredible and involved law student. She was so smart and worked so very hard. It's funny, the words that were used by Jerry regarding Justice Alexander, because those are exactly the words I've used for Sarah. So I also click for Justice Alexander. I think he's in our brains at this point, but I want to comment on Sarah's intelligence and her work ethic and her humanity and all the other things that Justice Alexander said about her. She actually worked for him, I think, following her first year of law school as an intern prior to becoming a judicial clerk. So when she told me that she was going to be considered as one of the governor's nominees for the like a judgeship, I really and honestly thought she meant the law court, and I was over the moon. But I guess we have to take baby steps sometimes. She's very wise beyond her years, but you know, the district court is a great place for her as well. But to pick up on what Chris McLean said, I definitely see Sarah doing bigger and better things later on in her career. She'll be a great asset there. After her time with Justice Alexander, Sarah moved on to Camden. As we have heard in great detail what her caseload involved, much like how I introduced Sarah Churchill a couple of weeks ago, Sarah Gilbert has always represented people, human beings, and it's so desperately important that people have experience working with clients on some of the worst days of their life, because that's what district court is. For some people who appear in district court, for too many people who appear in district court, those are some of the worst days of their life. And Sarah has been exceptional with her clients. She's generous with her time, and she's just such an effective litigator, which comes with its own hazards. Chris McLean referred to it. Sarah is not exaggerating when she says there is a lot of backlash. I think being young, being a woman, and being extremely competent and self-assured sets people like Sarah up for a lot of criticism. She wins because she's prepared and she's skilled. This is not a point of contention. This is just facts. If people have a problem with that, it's probably because they lost. When people come to interact with the justice system, the person that they usually see first, for the most cases, is district court judge. You've heard Sarah speak at length today. She brings a quiet dignity and strength to her interactions with everyone, and she'll bring that same to the bench. She has great humanity and she has a great personality, which will bring levity to proceedings when they need it, and they often do need it, but gravitas when necessary. I know Sarah will make everyone feel seen and heard. People may not always agree with her decisions. I think that's to be expected. If everyone agreed with judges, we'd have a very strange judicial system. People come with problems, and Sarah's going to have to make the tough choices, but she's going to do the right thing and the just thing and the fair thing. And that's all we can and should expect of our judges. We cannot expect perfection. Governors do not appoint angels to be judges. They appoint human beings with experience and talent and thoughts and opinions. And if anyone gets through law school without voicing a strong opinion on something political, I would be amazed to know that person. So Sarah, as a person, is just so wonderful, but she will be advocating, listening and fighting for people just as she did as an attorney, just from a different position. She'll bring a fresh perspective. Much like I said about Sarah Churchill, we have had a lot of prosecutors become judges in Maine, and that's true throughout the country. Sarah Gilbert is not a prosecutor, and that's a good thing. It humanizes the work, and I think it gives people a real clean slate when they appear before a judge with a background like Sarah's. Sarah's an outstanding human. She's an exceptional attorney. She's a trusted mentor, an admired role model for younger attorneys. She's a wonderfully loving mother, wife, daughter, and sister, and she's the best friend a person could ever hope to have. She will be an absolutely amazing judge. The state of Maine is so lucky to have a person of Sarah's caliber, heart, and integrity, willing to serve as a district court judge. She will be an indispensable asset to the bench and to the legal profession in Maine for decades to come. Thank you for allowing me the opportunity to speak.
Thank you very much. I'm looking now to members of the committee. Does any committee member have questions for Ms. Nadeau? Do not see any raised hands. Thank you very much for appearing before us this evening. I believe that our next speaker is Allison McKellar, who has joined our virtual meeting. You may proceed, and welcome to the Judiciary Committee.
Thank you very much. I am not an attorney, but I did also participate in mock trial as a high school student. So hopefully that counts for something. My name is Allison McKellar, and I'm honored by the opportunity to speak today in support of Sarah Gilbert's appointment as a Maine district judge. Until recently, I was fortunate to have lived the majority of my life with little need for Maine's lawyers, courts, and judges. Nor did I have any real understanding of the impact that both politics and personality can have on a person's experience moving through the various spheres of the justice system in our state. Today, I have a deeper understanding of the many layers, and this is the reason I feel compelled to speak in support of this appointment, even though I suspect that my support is not needed, given the tremendous record and reputation of this nominee. I serve as vice chair of the Camden Select Board in my hometown of Camden and live right up the street from Ms. Gilbert's law practice. When I began on the select board, I was extremely focused and continued to be on finding ordinances that I could enact or change to achieve better environmental or human outcomes. As legislators, I'm sure you can relate to the excitement of trying to solve all of society's problems by passing better laws. As members of this committee, though, I know you understand that the people and personalities of those who are appointed and hired often have an even more meaningful impact on the experience of Maine residents as they navigate courts and state agencies than do many of the laws that are passed. Sometimes the way a victim, witness, or accused person feels about the outcome of the proceeding actually has less to do with the law in question than the personalities they encounter, the accommodations made or not made, the way things are explained, and the tone of voice used. The combination of Sarah's compassion and her competence will be a gift to many Mainers who encounter her in the new role, just as they have been a gift to so many clients throughout the years. Although I did not know her personally, I had heard the name Sarah Gilbert for many years. She is known in town for her brilliant mind, her unflappable composure, and her willingness to donate time and services to community causes. I have watched as she represented people of all political persuasions, even political extremes. No one could survive in a small town without doing so. And while I do not think that this should be a prerequisite for any position, it is notable that I have really never heard anything derogatory said about Ms. Gilbert, which is not true of many of the other attorneys here in town. She is held in extremely high regard in the community, even as she finds herself in the middle of emotionally charged matters on a very regular basis. With her rural roots and as a working mother, she is in a position to relate to a more diverse range of Maine's residents in a way that I expect is almost unequaled. Anyone could tell you that, but my experience is more personal. My world changed forever on August 2nd, 2018. My sister Kristen was swimming with a friend on Damascata Lake when she was struck and killed by the propeller of a speeding motorboat. Kristen was my best friend and an extraordinary human being. Anyone who has suffered this kind of loss can relate to the deep sadness and emotions that an entire family must navigate, often on different schedules. On top of that, trying to resolve the need for some form of justice is a difficult and emotional exercise. The man who hit Kristen was initially charged with manslaughter and operating a watercraft at an imprudent speed. At first, we found the district attorney's office to be so exemplary in its handling of the case in pursuit of justice that part of me questioned whether I even wanted to pursue our own civil case. It seemed like it was being handled so well by the state that I even resisted the need to hire our own attorney. The suggestions that were being made anyway all pointed to men from Portland or Bangor with reputations for returning big settlements. I couldn't stomach the feeling I got, though, when I looked at their websites. Everything was about money, and rightly or wrongly, fairly or unfairly, the idea of these reputable attorneys representing our family or speaking on behalf of my sister made me cringe. Partway through the process with the state, our faith in the criminal justice system began to crumble as an election brought a new district attorney and a very different approach to the case. The voter ultimately pled guilty only to operating above headway speed in a water safety zone and was given a fine and 100 hours or so of community service. In this state, our lakes are not the property of any individual. They are supposed to be here for everyone. The idea that there could be such a small consequence was chilling to me and my family, especially after having heard such eloquent and well-stated arguments from the previous district attorney. For me, this experience taught me the hard way that a shared political persuasion is very often not an indicator of shared values and priorities when it comes to our judicial system. As that process came to an end, we began to look for an attorney who could pursue a civil case, and Sarah was the easiest decision we made as a family. I wanted someone at least a little bit like Krista, someone who lived in our community and with a strong sense of community service wrapped up in her legal work. My parents had received advice that maybe we needed someone from a bigger city to really have the power necessary to represent Kristen's case in the best way. To settle the concern, we asked a friend and personal injury attorney from another state to interview 3 options and let us know who he would choose. I was delighted, but not surprised, when he recommended Sarah. There is no happy ending in Kristen's case because there never can be. But the most difficult time in my life, when I found myself sometimes uncertain of my own judgment on things ranging from appropriate courtroom decorum to the wisdom of answering questions from reporters, I found immense peace and strength in trusting Sarah's judgment, competence, and moral character. Before we had even hired her, she took time out of her family vacation to sit with our family at the sentencing hearing for the voter. When emotions ran high, she let me know the judge was used to the outbursts from family members, and it was all a normal part of the process. I wanted to know everything about whether it was okay to stand here or there, how long my testimony could be, and whether I had all the facts straight. She had an impeccable understanding of the details of Kristen's case. And if she had been acting solely in her own best interest and the best financial interest of her law firm, there are multiple things she could and probably should have done differently. Instead, she was uniquely able to listen to me and my parents, even when we didn't agree, and suggest a path forward that would alleviate pain rather than feed it. In some ways, I am sad that she won't be available to suggest as an attorney to others or to rely on myself in the future. But I know that the competence, compassion, and judgment that I have seen in her will be of immense service to our state in more ways than we can probably foresee. Seeing the name Sarah Gilbert come up on the list of nominees to be a judge really does give me hope for the future of justice in our state. She's an outstanding and inspiring choice. Thank you.
Thank you so much, Ms. McKellar, for hanging in there and providing your statement today. We really appreciate you being here with the committee.
Thank you. It's been informative and interesting to listen to this whole thing.
Oh, I'm glad you found it so. Committee members, does anybody have a question for Ms. McKellar? Seeing none, thank you very much, Ms. McKellar. Next, we have Laurie Boxer-Maycomer. You may proceed.
Great. Thanks for welcoming me back, Senator Carney, Representative Harnett, and members of the Judiciary Committee. I am here again on behalf of the Maine Trial Lawyers Association as the association's president-elect to speak in support of Sarah's nomination. I come to you as a colleague of Sarah's as well, and she is also a board member of our organization. So in full disclosure, I wanted to share that. And as I discussed with you earlier today, the testimony that I give here today isn't just that of the board, but it's of our membership. We, survey our membership well in advance of these hearings, and we ask them to let us know about any issues, concerns, and strengths and other characteristics of the candidates. And the overwhelming majority of the responses pertaining to Ms. Gilbert were extraordinarily positive. People, just like you've heard throughout the afternoon, have been impressed by her professionalism, appreciate how down to earth she is, appreciate her skills as an unofficial mediator in family law contexts, and appreciate her writing ability. So we have heard great things about her. I can read a couple of the comments just to give you a flavor for what we got back. One person said that her experience as a legal practitioner will allow her to become an outstanding jurist. Another one called her an exceptionally skilled litigator and noted she had a true passion for the law, which I'll just, as a side note, share with you that while I was listening to some of the criticism of Sarah, I went back and I kind of did a little search in my email to see what kinds of things I had about Sarah in my email from the last 10 years. And one of the things that's really fascinating is, first off, the things that I found were extraordinarily neutral. I don't see her making any type of political statements on listservs or anything that would allow people to feel like there wouldn't be promotion of confidence in the judiciary if she were someone that was appointed. But some of the things I found were her volunteering to serve on things where she wasn't receiving any type of financial compensation. I would see people suggesting that she be a speaker on things like remote depositions or remote mediations, because she had, developed a skill set early on in COVID with technology. And another thing that I saw while the hearing was going on, and I was going back and looking at some of these things, is she's the type of attorney, when someone asks a question on a listserv about how, what type of case law is there out there on this or that, she's the one that has the case citations and can cite the rule of evidence and help point people in the right direction. And that's exactly what we want, is someone who is willing to go beyond themselves and be a resource to the bar and to the community, and is always thinking about what they can do to better the entire legal system. So that's just an aside. And with respect to, the old saying that actions speak louder than words, Sarah is the type of person that is trusted by other lawyers and by the law school and by the judiciary. She's invited to speak on things like harassment and discrimination and neutrality and bystander intervention. She's the one when, the Court Alternative Dispute Resolutions Committee, or when they're the executive director of that program, needed an attorney to come and talk to other people about how to intervene if someone's acting inappropriately. She's the person that they called on from the bar to come give that talk. And she's the person that the law school invites to serve on the rural access to justice panel. And like I said before, she's the one within the main trial lawyers that we're looking to talk to people in the family law bar about how to do some of these proceedings remotely early on in the pandemic. So she's just been a great leader and a resource. And I can share that in the context that we've seen her being the main trial lawyers association, we have not seen anything that would cause us to think that she would be anything but extraordinarily professional, highly ethical, and a great addition to the court. So in sum, we want to testify highly in favor of her confirmation as a district court judge, and I'm happy to answer any questions.
Thank you very much. Are there any questions by committee members for Ms. Boxer-Maycomber? Go ahead, Representative Libby, you may ask a question.
Thank you, Madam Chair, and thank you for being here, Ms. Boxer-Maycomber. My question is this: in looking for the full picture, I appreciate that the vast majority of comments were positive, but in looking for the full picture, to have a full look at this, was there then a minority that you would speak to their comments?
So our surveys are relatively confidential, but what I can tell you is I believe there was one comment where someone was not thrilled about a case that they had, and it, you know, some of maybe one of the issues within the case. They didn't love the fact that maybe Sarah pursued a theory of liability or a theory of some sort of a claim, and said, you know, that wasn't something that they felt was appropriate. However, that's often the case. I can tell you that, just like you've heard from many other litigators here today, that it's very often the case that someone will tell you, I've had it happen to me before too, where someone will say, yeah, that is a bogus theory, and then you ultimately end up prevailing. And so we as an organization, look at what are we getting back from the majority of our membership, and the comments were overwhelmingly in favor of her nomination. And so there was a comment, but that I wouldn't give that a lot of credence in light of the remainder of the comments that we received.
Thank you.
Committee members, are there any final questions? Okay, I am not seeing any raised real or virtual hands. Thank you very much, Ms. Boxer-Maycomer, for presenting this evening.
Thank you all.
At this point, I think that is everyone who signed up in advance who is still in attendance, but I'm going to switch over to the attendee list and ask. There's a phone number that is a 207 phone number, and there is also John Irving, and I just would like to know if either of those attendees are interested in providing any statement in support of the nominee, and if so, please raise your hand. Not seeing any raised hands. And then is there anybody here who would like to speak in opposition to the nominee? If so, again, please raise your virtual hand. Let's see, at this point, I'm not seeing it. Sarah, Ms. Gilbert, can I just ask you a question? There's a John Irving who is an attendee. Is he a family member?
Yes, Senator Carney, that's my kid brother, and I doubt he wants to testify, but I'm sure he's listening.
That's really wonderful. It's nice to have family members attend. All right, thank you for clarifying that. We won't promote him to speak with us this evening. All right, so let me return to the script now that we have clarified that. All public comments having been taken, the committee will now proceed as follows. Review any additional written comments on the nomination that have been received by the committee. And I'll pause there and check with our committee clerk and ask if we've received any additional written comments.
You have not, Madam Chair.
Thank you very much. The next step will be to vote on the nomination and notify the President of the Senate pursuant to Title III MRSA Section 157 and the joint rules. The vote must be taken within 40 days from the date of the governor's written notice. The hearing by the Joint Standing Committee of the Judiciary for Ms. Sarah I. Gilbert, Esquire of Hope, for appointment to the District Court Judge is now closed. We'll proceed to taking the vote. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. At this time, Therefore, I will inquire as to whether any members present object to proceeding to take the vote immediately. And so if you do object, could you please, first preference, raise your virtual hand, and if it's not working, raise your actual hand. Senator Keim, would you like to take some additional time? Would you like the full 15 minutes or a shorter time frame?
Yes, the full 15 minutes, please.
Okay, so it is 6:10 now, so we will resume at 6:25. And just as a reminder, we're still live on YouTube, so please mute and stop your video. See you at 6:25.
Well, you made that easy, Heather. Thank you.
You're welcome. That's the shortcut. Just search for the word reminder.
I should be able to remember a word like reminder. Oh.
So we should everybody should be returning to the electronic meeting, and we'll proceed in just a moment.
Let us hope so.
My grandfather was an attorney at the Knox County Courthouse in the 30s, 40s, and 50s.
What was his name?
Roberts, Chris Roberts.
Yeah.
He died about 1965.
Yeah, I wanted to say this earlier, Representative Babbage, but I know Brenna Graben. I knew her well at school, and I've lost touch, unfortunately, with her a little bit over the years, but I knew her when she was there. Yeah.
She used to dance with my daughter. I don't know if she ever clogged for you. But wonderful family.
Yeah. Yeah.
Good Lord, that was a struggle.
Getting back on?
Yeah, well, I'm computerless now and iPadless because
Well,
not only is my computer dead, but my iPad ran out of juice at 4:30, so I'm now on a phone.
Representative Rick, I'm gonna rename your square here on the screen.
Oh, thank you.
It is clear for the members of the public who are watching and listening in.
Lois, did that coffee kill your computer?
I have no idea because I can't see anybody about it till Saturday afternoon was the first time I could get an appointment. So I bet I would limp through the day okay till about 4:30 when the juice ran out of my iPad. So even though I had it charging while I was talking to you all day, so I think I'm gonna have to put blank screens as the solution or something to keep charged up enough to continue.
I have terrific news. I announced earlier that my toner had run out this morning. Yesterday, in anticipation, I ordered some toner and it just arrived at my door.
Get out of here.
That is pretty good service from Staples Inc.
Whoa.
I don't think we're allowed to advertise on Representative Babbage.
Sorry. Free shipping.
But now that you have toner, could you print out some documents for me?
Yes, I'll try to do that.
Tomorrow's the big day. I get my my second vaccine shot.
Very wonderful.
So Thursday, if I'm a little groggy, that may be a reason. So.
Lois, did you have any reaction, Lois?
My first one?
Yep.
But I had a headache for about 20 minutes.
This place gives you a headache for more than that.
Is there an inoculation for this place?
I think so. But boy, do I miss seeing you all in person, I have to say. Not just you, but everybody. I mean, it's just, I feel like I haven't met the new people and
Yeah.
except on the committees, and it's just really hard.
Yeah, that's the bizarre part.
Hmm. I mean, I've gotten sort of friendly with a couple of people on criminal justice. At least I think I have. Who knows? Because we've not had a person-to-person conversation. They may think I should jump off a bridge, but it seems pretty friendly. But it's just hard. You know, it's just hard to get to know anybody.
Oh, sure.
It's going to be March in another week.
Yep.
Yep.
Just want to say, I think Steve's books are way too neat.
Because he hasn't read any of them, Chris.
I could see that one. I could see that one coming.
I lost the Portland headlight. I don't know where it went on my stuff. Just disappeared. So.
Oh, you're back. Yeah, yeah.
And my background's missing. And to tell you the truth, I haven't had 20 seconds or the strength to try to figure it out today. And I think the governor's going to be off my list here at 7 too. They said they were going to send a link to people who want to see it later.
Yeah, they're going to put it online too.
Yeah. I'm sure we'll get a summary tomorrow morning.
I guess
Do we lose Ann?
CSH and PBS are both covering it tonight.
Well, you never know. We might get done by 7. And I might have be a glutton for punishment and want to put my sit and watch some more.
Chris, do you know if it's on the radio? Because I could listen to it on my way home.
I'm sure it must be if it's on the television. Yeah.
It's going to be on public radio.
Yeah.
Public would carry it, I think.
90.1. Yeah.
Okay.
Yeah, it'll be on main public.
Thanks.
That's right, Jeff. You'll be traveling, huh?
Yeah, I came up today. My aide was here, and he gets me organized with my files and stuff. I'm like Lois. I can't do it without my papers. You know, I just can't. Lois, I agree. I just, not only is it difficult not getting to know the people, but I think we're all feeling a little lost. You know, it's so much in this box. You just can't absorb it all. You know.
I'm sorry to interrupt the conversation. I just wanted, I'm not sure how long of a delay we'll have. I reached out to some of our other committee members, and I think it'll just be another couple of minutes. So we'll just ask people to be patient. Thank you.
So you renamed me somehow, Ann? Is that what happened? Except I see nothing.
Yes.
But
We're no longer sharing a name. You are Lois Reckitt again.
oh, I was sharing a name with you. Jeez.
I would like to have that renaming authority.
You should be able to do that.
No, I mean for other members of the committee.
Don't you be starting with me, Chris, boy.
Like that's going to happen.
Yeah. Oh.
If we were not on YouTube, I'd rename you right now, Chris. But I won't.
I've always counted on your discretion.
Well, here we are doing what we always did around the horseshoe. It's nuts.
Except we would be eating at the same time.
Yes,
Soupy would have saved us and we'd be eating something. I was so proud of myself this noon. I mean, oops, okay.
I've been collecting recipes. I can't wait till next year.
I'll also remind us that we wouldn't have had our mics on around the horseshoe, and so we wouldn't be broadcasting to the entire universe.
It's true.
Did you all hear about Tiger Woods?
Yeah, he's in bad shape.
From what?
He had a big car accident, single vehicle crash. The jaws of life have to pry him out.
Oh,
I heard about the accident, but I didn't hear about his condition.
Yeah, he's in surgery right now.
Oh, it's a shame.
Yeah.
My mother was such a fan of his. Of course, that was before the scandal, but even so, my mother was like, every time he was on, she would watch.
I remember when I was a boy, Ben Hogan got into a serious accident. He, managed to come back, but he was, it was tough.
Sort of like me falling off that camel. I never quite made it back.
Jeff, I don't know, but that sounds like saying, when I was a boy, George Washington had an accident. Ben Hogan.
You're older than I am, Chris.
Oh, that's what I'm saying. I did see Stan Snead get an eagle at the Portland Country Club. I will say that. So that does sound like ancient history, because those people were really great in the 40s and 50s.
Yeah.
I don't think I ever one time voluntarily watched golf.
How about the times it was involuntary?
Mostly I've been sledding on golf courses in my life.
CBS says non-life threatening
good.
leg injuries.
Yeah.
So
Golf courses are great places to sled.
The extreme weather we've had this year, it does bring back memories of the 1980s. We used to have Winter Carnival, big snow sculptures in front of the high school during the 1980s, but we gave it up because of the lack of snow in the 90s.
Yeah, I just read a book called Under the White Sky, which was very well done. It was written by the woman who wrote The Sixth Extinction. And it was scary as heck, but it was all about if there's a miracle, we might be able to do to recover the planet. So the fact that I actually read a book last week is pretty astounding, frankly.
Yeah, where do you find that kind of time?
Well, really, I do it chapter
committees.
by chapter. I can't, I make myself read over breakfast or something. It's like, who's got 20 seconds? It's just crazy.
Seriously.
Oh, I do hope that's an animal you're talking to.
It is.
A dog or a cat?
Everybody, it looks like we're ready to resume.
Okay.
Thank you for rejoining us. And we appreciate everyone's patience. Having taken a break in excess of 15 minutes, we are ready to move on to the pending question. The pending question before the committee is that the Joint Standing Committee on Judiciary recommend to the Senate of the 130th Maine State Legislature that the nomination of Ms. Sarah I. Gilbert, Esquire of Hope for appointment as a district court judge be confirmed. In accordance with 3 MRSA Chapter 6, Section 157, and with the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending confirmation. A vote of no will be against the motion to recommend confirmation. Is the committee ready for the question? The committee clerk will call the roll.
Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
yes.
Senator Sanborn votes yes. Senator Kine.
Yes.
Senator Kine votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Downs.
Yes.
Representative Downs votes yes. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Evangelos.
No.
Representative Evangelos votes no. Representative Newell.
Yes.
Representative Newell votes yes. 10-4, Madam Chair.
Thank you. 10 members of the committee having voted in the affirmative and 4 in the negative, it is the vote of the Joint Standing Committee on the Judiciary that the nomination of Ms. Sarah I. Gilbert Esquire of Hope for appointment as a district court judge be confirmed. Congratulations.
Thank you very much. Thank you.
And typically we would be gathering around the horseshoe and congratulating you in person. We can't do that. So we would like to extend our virtual congratulations and a round of applause to you. Thank you very much.
Thank you all very much for your time and consideration. Thank you.
With that, I want to thank everyone for all their participation in the hearings today. It was a very long day. Congratulations to the nominees, and we will reconvene on Wednesday for our committee meeting. And with that, we are adjourned for the day.
Good night, all.
Thank you very much.
Good night.
Bye-bye.
Take care.
Take care. Bye-bye.
Thank you, everyone.
In time for the governor's speech. I think she's speaking at 4. Good night. I'm ending.